Hi, I'm Penny, and people on YouTube told me I could dig in the dirt, so I went and dug in the dirt again. See, look, I have dirt. Mom wanted to show you what she has to clean up just so you felt good about the fact that you told me I'd dig in the dirt again, and I did. Again, today. But we got some fun stuff for you, so enjoy.
State of Michigan versus Jacob Brown. It is file number 20-19991-FH. We are here today on an arraignment for an alleged probation violation. Sir, you are Jacob Brown, correct?
That is correct.
Mr. Brown, have you received a copy of the warrant in your case?
I got this, whatever this is.
Does it say request and warrant for probation violation?
It does. I didn't get no sleep last night, Your Honor. I'm sorry. Yeah, it said request for warrant for probation violation. That is correct.
All right. That warrant alleges that you violated the terms of your probation by making threatening, intimidating, or assaultive messages on social media on or about January 17, 2023. You had previously pled guilty in this case to attempted aggravated stalking.
Yeah, I was forced to take that plea, by the way, because you guys would have a COVID case. And when I took that plea, all of a sudden, we started having jury trials after that. That is kind of curious, Your Honor. However, it is a bogus warrant. Once again, there was no assault. Who did I assault, and who's these people that I assaulted and intimidated? I'd like to know.
Well, we'll get to that. You originally, as I indicated,
you ruined my life once again.
Mr. Brown, Mr. Brown, stop interrupting me. If you interrupt me in this proceeding, I will hold you in contempt. All right, record should reflect that Mr. Brown stood up, crumpled his copy of the request and writ for probation violation, threw it on the floor, and walked out of the room that he was in at the jail. So he obviously is not willing to participate in this hearing further. We will try this again tomorrow morning. All right, thank you for your time at the jail. We will, yes, Ms. Underwood?
Is this a pickup?
Yes.
Okay, just, I guess, send me the information and let me know when we're gonna try it again.
All right, it'll likely, I think, be tomorrow morning since Mr. Brown is not willing to participate today.
Thank you.
Okay, thank you.
Thank you, sir. So let's add storm out of court on that list of things you probably shouldn't do in life.
All right. Looks like this warrant still needs to be sworn to. Is that correct?
Yes, sir.
Jesse, okay. We'll do that first and then I'll get to the arraignment here. Now calling case number 23-2430, the people versus Zachary Tyler Jutsky. This is the date and time set for a swear to. Sergeant or detective?
A detective, Your Honor.
All right, detective, can I have you raise your right hand? You solemnly swear to tell the truth, the whole truth, and nothing but the truth.
Yes, Your Honor, I do.
All right, Your Honor, please state your full name correct. Yep, you may proceed when you're ready.
I apologize for interrupting. Good morning, Your Honor. Dan Pelletier from the Royal Police Department. Before you today is the one-count warrant charging Mr. Jetsky. The facts of the case are documented under Royal Police Report number 23-2430 and are summarized as follows. On January 21st, 2023, shortly after 1 in the morning, Royal Police officers were on patrol on Main Street in the city of Royal Oak, County of Oakland, state of Michigan, and observed a vehicle driving on the wrong side of the roadway against oncoming traffic. Officers made a traffic stop and identified the driver as Zachary Jetsky. Officers had a conversation with Mr. Zachary and observed indications of alcohol impairment. Zachary admitted to consuming alcohol at O'Toole's Bar in the city of Royal Oak. Officers detected the odor of intoxicants coming from Mr. Jetski. He conducted field sobriety evaluations, and officers observed further signs, clues, and indicators of alcohol impairment. Mr. Jetski provided a PBT breath sample with the result of 0.20% BAC. Mr. Jetski was arrested, taken to the police department, where he provided 2 additional breath samples on a data management instrument of 0.20 BAC. The facts presented to the court, Your Honor, are sufficient to a probable cause standard to support the allegation. I have affixed my signature to the criminal complaint and respectfully request the court to authorize the warrant.
All right, the court finds that probable cause has been established related to the submitted charge, so I will authorize the warrant. I'm signing that now. I know you made a previous statement that you're recommending personal bond. Is that correct?
Yes, Your Honor, the defendant doesn't have a criminal history, no prior arrests. This is his first offense. He doesn't have any outstanding warrants for his arrest. He's lives locally. I'm confident he'll come to court, and as long as he's not drinking and driving, I don't feel he's a danger to society. The Royal Oak Police Department recommends a personal bond.
All right. Now, recalling case number 23-2430, the people versus Zachary Tyler Jetski. This is the date and time set for arraignment. Mr. Jetski, can I have you raise your right hand? Yo, do you solemnly swear or affirm that the testimony you're going to give is the whole truth and nothing but the truth?
Yes.
All right. It's my understanding that you wish to proceed without counsel. You can put your hand down.
Oh, okay.
It's my understanding that you wish to proceed without advice from an
Yeah.
attorney. Is that correct?
Yeah.
All right. You understand that you have the right to be represented at your arraignment, and you understand that by waiving that right, you're not going to have an attorney moving forward unless you request one. You understand that, right?
Yeah.
All right. All right, so Mr. Jetski, you are currently being charged with operating while intoxicated with a high BAC of 0.17 or more. This is a misdemeanor that's punishable by 180 days in jail and or a fine not less than $200 or more than $700. Do you understand that charge?
Yes.
Okay. And knowing and understanding that charge, you still wish to proceed with your arraignment without an attorney, is that correct?
Yeah.
Okay. All right, with that said, I'm going to waive the formal reading. I'm going to enter a plea of mute on your behalf, which means it's not guilty. Okay, so this case is going to be reset for a pretrial that'll take place at the 44th District Court. I don't have that date in front of me, but we'll get to that. Now, the detective stated that you do not have any prior criminal history. Is that correct?
Yeah.
Okay. Are you currently employed?
Yes.
And it looks like you reside in Sterling Heights on Dunhill, is that
Yeah.
correct?
Yeah.
Okay. All right. Well, based on the recommendation of the detective, as well as finding that you do not have any criminal history, I do not see that you're a flight risk, and I do agree with the detective. As long as you are not drinking, I don't think that you are a danger to society. So what I'm going to do is I'm going to order a bond in the amount of $20,000 personal recognizance. Okay, that means you do not have to pay any money, but if you fail to abide by any of your bond conditions, your bond could be forfeited and you may owe $20,000 to the court. You understand that?
Okay. Yes.
All right. So I am ordering the following conditions. You will personally appear for any and all future court proceedings. You'll not leave the state of Michigan without permission of the court. You will immediately notify the court in writing of any change to your address or telephone number. You shall refrain from using any alcohol, any form of THC, marijuana, illegal drugs, or abusing any legally prescribed medication. You will submit to random PBTs and or urinalysis upon request. And lastly, no new criminal offenses or activity. Mr. Jetski, do you understand the terms and conditions of your bond? Yes,
If I have my medical card, does that still count for THC?
it does. And
Okay,
typically I say that you are not to use it starting today. But what you can do is at your next hearing, at your pretrial, you can bring it up to the judge and maybe the judge will allow it. But as of right now, I'm
Okay.
saying no marijuana.
okay.
All right? All right, do you have any other questions?
No, that was it.
All right, Mr. Jeske, you're all set for today. I wish you the best of luck.
All right, thank you so much.
You're welcome.
Yes, sir.
Okay.
All right, and then we have Ms. Thompson as well, correct?
Yes, Your Honor. She's here present with me.
Right. Alcohol in case number 22-2391, the People versus Darlisha, Unique Thompson. This date and time set for a swear to. Detective, you were previously sworn in. You may consider yourself still sworn and you may proceed when you're ready.
Thank you, Your Honor. Good morning, Dan Pelletier for the Royal Police Department. Before you today is the warrant charging Ms. Thompson. The facts of the case are documented under Royal Police Report number 23-2391 and are summarized as follows. On January 20th, shortly after 11 p.m., Royal Police Department received a emergency phone call from a complainant witness who stated that he was being followed in his vehicle through the city of Royal Oak from I-696 and was concerned. The driver was advised to go to the police station, which he did. Just before getting to the police station, the vehicle that was following him turned off onto Troy Street, just north of 11 Mile in the city of Royal Oak, County of Oakland, state of Michigan. The complainant victim went to the police department, spoke with police officers, and reported the vehicle behind him was swerving, following too closely, speeding up and slowing down, and he believed the driver to be drunk. Other police officers located the vehicle just north of 11 Mile on Troy Street, stopped in the roadway and impeding traffic. Officers made contact with Ms. Thompson, who was in the driver's seat. Ms. Thompson was extremely confused, had difficulty articulating her words well, and there was a strong odor of intoxicants coming from her, along with watery, sleepy, bloodshot eyes. Ms. Thompson was asked to exit the vehicle, and she displayed extremely poor balance, almost falling over, unable to walk well. She conducted field sobriety evaluations and performed in such a manner that it was extremely evident that she was intoxicated to a significant extent by alcohol. Officers observed horizontal gaze nystagmus in her eyes as well. Based on that, Ms. Thompson was arrested and transported to jail. She refused to submit to a breath test. A search warrant was obtained from her for her blood. And with that, Your Honor, I believe is sufficient information to prove to a probable cause standard the allegation on the complaint. Your Honor, I have affixed my signature to the criminal complaint and respectfully request the court to authorize the charge in this matter.
All right, I guess my only question, so there was a blood draw taken, correct?
That is correct, Your Honor. The blood has been sent to, or is being sent to, a forensic science laboratory.
All right, the court finds that probable cause has been established related to the submitted charge. I will sign and authorize the warrant. Is there anything you'd like to say regarding bond?
Yes, Your Honor. Ms. Thompson is local to the Metro Detroit area. She has not been arrested before, does not have any criminal history. I don't believe she's a danger to society aside from drinking and driving. As long as she's not doing that, I think that she's absolutely fine to be released back into the public. And I don't believe that she's a flight risk. I think she has too much to lose to not show up in court. And it's the position of the Royal Police Department that a personal bond is appropriate.
All right. Now recalling case number 22-2391, the People versus Darlisha Unique Thompson. This is the date and time set for arraignment. Ms. Thompson, can I have you raise your right hand, please? You solemnly swear that the testimony you're going to give is the truth, the whole truth, nothing but the truth.
Yes,
All right. You can put your hand up. All right. It's also my understanding that you wish to proceed without an attorney. Is that correct?
correct.
All right. So you just heard the detective swear to and warrant regarding this charge. You understand that you have been charged with operating with a high VAC of 0.17 or more. This is a crime or misdemeanor that is punishable by 180 days in jail and or a fine of not less than $200 and not more than $700. Do you understand that?
Yes,
All right. Knowing and understanding the charges against you, you still wish to proceed without an attorney. Is that correct?
yes,
Okay. All right, what I'm gonna do is I'm gonna enter a plea of mute on your behalf. So this case will be reset for another court date. It'll be your pretrial. And you'll have to appear at the 44th District Court in Royal Oak for that hearing.
Okay.
Now, as it relates to bond, do you have any prior criminal history?
no,
All right. Looks like you currently reside in Sterling Heights on Kristen Drive, is that correct?
yes,
All right. Are you currently employed?
yes,
All right. Based on the detective's representations and finding that you do not have any prior criminal history, just as I said before, I do not think that you are a flight risk. And as long as you are not drinking, I don't think you are a danger to society. So I'm going to order the same bond as I ordered for Mr. Jetski. It's going to be $20,000 personal recognizance. It means you do not have to post any money. It just means that if you fail to abide by any of your bond conditions, that bond could be forfeited and you may owe $20,000 to the court. You understand that?
yes,
All right. Now I'm also ordering the following conditions. You will personally appear for any and all future court proceedings. You will not leave the state of Michigan without permission of the court. You will immediately notify the court in writing of any change to your address or telephone number. You shall refrain from using any alcohol, any form of THC, marijuana, illegal drugs, or using any legally prescribed medication. You will submit to random PBTs and or urinalysis upon request. And lastly, no new criminal offenses or activity. Ms. Thompson, do you understand the terms and conditions of your bond?
yes,
Do you have any questions?
no,
Okay. All right. What I would recommend is sometime on Monday, you need to call the 44th District Court and find out when your next court date is. Okay?
okay, okay,
All right. You're all set for today. I wish you the best of luck, ma'am.
Also on the list of things you shouldn't do, drinking and driving. There are so many options these days. You do not need to drink and drive. You can get an Uber, you can get a Lyft. There's like 20 different other services. It's not like you have to wait for the yellow cab to come from, 20 miles away anymore. You can call a friend. If you don't have any friends, drink at home. Like, you don't have to go out and drink and get drunk and then drive across town. These two were incredibly lucky that they did not get into an accident, but we have seen too many accidents looking at these videos, and it's just not worth the risk. The next video I have for you, I thought was kind of interesting. So we watch a lot of bond court and arraignments and things like that from the perspective of the judge and the court. And we don't really see it from the opposite side where the person being arraigned is sitting. And this is a professional athlete. I'm sorry, I can't remember off the top of my head who it is. But it's what it looks like in the room that they're in. They're basically just sitting in a room with a big TV screen with Zoom on it. And it looks kind of neat.
Yes, Your Honor, still great.
Okay, thank you.
I'm sorry, who is the one who is medical reset?
Positions 1 and 2, Ms. Conley. And then
When I first watched this next clip, I got a little upset. I was about to start a GoFundMe to break grandma out because I thought they picked her up from church. And then I heard her prior history and I wasn't quite so convinced, but Still. Poor grandma.
Attorney, so you don't have to attend today. One less for you to have to worry about.
Cool.
Thank you, Chris.
I'm calling prosecutor order number 23-00985, the People versus Bonita Gale Hall. This is the date and time set for arraignment. Counsel, your appearance for the record.
Morning, Your Honor. Christopher Sakely, bar number 23248, with the Michigan Indigent Defense Council, representing Ms. Hall for purposes of arraignment only with Ms. Hall's permission. Is that correct, Ms. Hall? You want me to represent you this morning?
Yes.
Judge, she
All
would
right.
waive reading of the complaint. She would stand mute.
All right. Court will waive formal reading, enter a plea of mute on behalf of Ms. Hall. Ma'am, I did receive the request for court-appointed attorney form that you filled out and submitted. Based on your representations, I do find that you are indigent, so I will appoint an attorney for you moving forward, okay?
Okay.
All right. Counsel, as it relates to bond, what would you like to state on behalf of Ms. Hall?
Judge, I believe she does have some prior history, but she has no assaultive crime. She's 66 years old. She's been employed for the last 7.25 years at Molina Healthcare as a claim processor. She has one adult child, and she rents her home on Pembroke Avenue. Would respectfully ask for a personal bond.
All right. Well, the court will note Ms. Hall does have a lengthy criminal history involving larceny, retail fraud, dating back years and years. So I do not feel that a personal bond is warranted. Rather, I'm going to order bond in the amount of $5,000 cash or surety. I will allow a 10% provision. I'm also going to order the following conditions. You are not to return to Saks Fifth Avenue or Somerset Mall in Troy, Michigan. You will personally appear for any and all future court proceedings. You will not leave the state of Michigan without permission of the court. You will immediately notify the court in writing of any change to your address or telephone number. You shall not possess any firearms or other dangerous weapons. I am going to place you under pretrial services supervision, which means if you post bond, you need to contact pretrial services within 24 hours of your release and get enrolled with them. Lastly, no new criminal offenses or activity. Ms. Hall, do you understand the terms and conditions of your bond?
Yes, I do, sir.
All right, do you have any questions?
No.
All right, I currently have your next court date scheduled for January 30th at 9 a.m. That'll be at the 52-4 District Court in Troy. I would recommend if you post bond, you need to contact the 52-4 District Court and find out if that court date's going to be in person or via Zoom. Okay?
All right.
All right. Other than that, you are all set for today, ma'am. I wish you the best of luck.
Over here in this chair.
Fun fact for the day. Did you know that SeaTac, the airport, Seattle-Tacoma, and the surrounding areas, it's a city. It's actually a city, and it has its own court. Oh my gosh. I had so much fun watching this the other night. I don't know why, but watching people who were arrested at the airport was very interesting for me. Yeah, I have issues, I know. This next one, no clue what's going on. It was a little interesting. I was super surprised he got released. If anybody understands it a little better than me, explain it in the comments for me.
And Your Honor, this is case number 3A0170569. And sir, is your name Jared John Gray?
Yes.
And what is your date of birth, sir?
1199.
And Your Honor, we acknowledge written receipt of the complaint, waive further reading, and would like him to enter a plea of not guilty. Earlier, we reviewed his charges, we reviewed his rights. We went through all his questions and answered all of his questions. And he does qualify for the public defender under the statute. And we ask for direct appointment. Thank you.
Plead not guilty will enter. I do find probable cause to detain and will direct appoint. What is the city's recommendation regarding release?
Given defendant's warrant and failure to appear history, including an active warrants out of Bremerton Municipal Court, he does believe defendant is a high risk if he fails to appear. He's requesting bail in the amount of 500 cash or bond and conditions including no contact with the airport and rental car facilities.
Any objection?
Yes, Your Honor. I would be objecting to the bail amount. I'd be arguing for my client to be released on his own personal recognizance, given the nature of the charges. On top of that, my client, he does have those warrants, but he indicated to me that he has no phone nor transportation. But he does have access to Zoom. So he didn't have the ability to go to where he had his Bremerton warrant and be able to clear that warrant because he did not, like I said, have phone to call them or transportation. But he indicated to me that for future court appearances in this court, he can Zoom into this court and that will be available to him. And also on top of that, he doesn't have any money to post bail as well currently. So for all those reasons, I'll be asking for my client to be released. Thank you.
Sir, how do you have access to Zoom and not a phone and not be able to make a phone call?
I was picked up and figured my way around, and I mostly figured life out by myself, basically.
But how do you have access to a Zoom hearing?
I think I have identification. Basically because of police services.
Right, but in order to join a Zoom hearing, you need a computer or a smartphone or what?
I'm at a facility with a computer.
So then you had it in your capability to email the court and let them know that you couldn't be there, right?
Yes. Yes, Your Honor.
But it doesn't look like you did that, I guess is why I'm.
Yeah.
Right. I guess I'm looking at your history. You have warrants on most of your cases, and I'm trying to figure out why I would believe that you would come to court.
Because I believe it's the right decision to make, and I do like to get through my legal work mostly. Some of those warrants are older, been previously quashed.
Some are, but not all of them.
Correct.
I'm looking at the last case that you had in Issaquah Municipal Court, and you were held in custody the whole time. Then the one before that, you have an active warrant out of Bremerton right now. And you're held in custody on that until that case resolved as well. Mr. Great, I do not have faith that you will appear for court if I release you today.
I will appear for court if you release me on the exact date, or you could issue a warrant. I would not like to be involved back in the system again. The Bremerton warrant is kind of a misdemeanor placebo and is actually accidental because I got near the Seattle area and couldn't afford to take it back to Bremerton. But I tried to make contact and the phone didn't work because I developed flu virus.
Because you what?
Developed flu virus. I was sick basically. I wasn't able to make it. I made it to my past ones. I will show up to court if I was released today, and I will follow through with the paperwork.
Given the nature of the charge and the fact that you don't have a long history of trespassing at the airport, I will release you on your promise to appear on condition that you would attend all future court appearances, have no new criminal law violations, update your address with the court and DOL immediately if there are any changes. And the address that we have on file is on Stillicum Boulevard in Lakewood. Is that still a good mailing address?
Yes, sir. Yes, ma'am.
No contact with SeaTac International Airport or the rental car facility. And no contact means absolutely no contact. You cannot be there unless you have a ticket to fly. And update your yeah, I think that's everything. So would you be able to come physically to SeaTac Municipal Court?
Yes.
We'll set this on for an in-person hearing on February 7th at 8:30 in the morning.
Thank you. So I will be released later today.
You will, if you don't come to that next hearing, you will get a warrant.
Thank you.
Okay.
And I'm
Thank
sorry,
you,
there
Heather.
was a condition of clear the Bremerton Municipal.
Oh,
Court
yes,
warrant.
thank you. And clear, I knew I was looking at it going, there's one more thing I wanted to add. Clear the Bremerton warrant before that next hearing.
Thank you.
All right, thank you, sir.
You know how you know you're old? When you look at a kid's hair and you're like, wow, how did that happen? I thought maybe like there was a tornado or something because it is perfectly windblown, like all the way over to the side, even the little curl coming across the face. It is like the perfect side blown, like glamour shot photo. Wow. Me.
Okay.
This is Mr. Wilson.
All right,
How you doing, Mayor?
doing well, thank you. Now calling prosecutor order number 23-00983, the People versus Michael Joseph Wilson. This is the date and time set for arraignment. Counsel, your appearance for the record.
Morning, Christopher Sakely, bond number 23248. I'm with the Michigan Indigent Defense Council. I'm representing Mr. Wilson for purposes of arraignment only with his permission. Is that correct, Mr. Wilson?
Yes, sir.
Judge, we will waive formal reading. Mr. Wilson is charged with one count of retail fraud first degree. We will waive formal reading. He would stand mute.
All right, the court will waive formal reading, enter a plea of mute on behalf of Mr. Wilson. Sir, I did receive the request for court-appointed attorney form that you filled out and submitted. Based on your representations, I do find that you are indigent, so I will appoint an attorney for you moving forward, okay?
Okay.
All right, counsel has released the bond. What would you like to state on behalf of Mr. Wilson?
Judge, Mr. Wilson's 22 years old. He's presently employed with Amazon, where he's been for the last year and a couple months in Pontiac. He's a high school graduate of Kearsley High School in Flint, and I believe he has no prior convictions of any kind. Therefore, we would request a personal bond.
All right, Mr. Wilson, do you currently?
No.
All right. Well, I do not see anything that states that you have any criminal history or any prior failure to appear history. So I do not feel that you are a flight risk. I will say that the allegations in this case are certainly troubling. But in light of this, I do. I'm sorry, say something?
No.
Given the allegations in this matter, I don't think that necessarily a personal bond is warranted. I'm gonna order bond in the amount of $4,000 cash or surety. I will allow a 10% provision, so that means, Mr. Wilson, you have to post $400 cash. You understand that?
Yeah. Yes, sir.
All right, I'm also ordering the following conditions. You are not to have any contact with Taryn Todd Deal. You are not to return to Saks Fifth Avenue or Somerset Mall in Troy, Michigan. You will not assault, beat, molest, or in any way verbally harass, intimidate, or threaten any witness. You will personally appear for any and all future court proceedings. You will not leave the state of Michigan without permission of the court, and you will immediately notify the court in writing of any change to your address or telephone number. You shall not possess any firearms or other dangerous weapons. You shall refrain from using any alcohol, any form of THC, marijuana, illegal drugs, or abusing any legally prescribed medication. I'm going to place you under pretrial services supervision, which means if you post bond within 24 hours of your release, you need to contact pretrial services and get enrolled with them. Lastly, no new criminal offenses or activity. Mr. Wilson, do you understand the terms and conditions of your bond?
Yes, I do.
All right, do you have any questions?
No, I do not.
All right, I have your next court date scheduled for January 30th at 9 a.m. That'll be at the 52-4 District Court. If you do post bond, I would recommend calling the courthouse and finding out if this hearing is going to be done in person or via Zoom.
Oh, okay.
All right.
I had to throw a quick feel-good story in here for you. It's kind of nice to see someone trying so hard to get their life together. Good for her.
This is on for arraignment.
Go ahead.
Is your true name Madison? Hold on, I just closed that. Madison Elizabeth Rittenauer.
Yes,
And what is your date of birth?
5/17/95.
And Your Honor, we acknowledge written receipt of the complaint. We waive for the reading and enter a plea of not guilty. We reviewed the charges as well as her rights, answered all of her questions, and she does also qualify for the public defender under the statute. So we ask for a direct appointment. Thank you.
Plea of not guilty will enter. Probable cause was previously found on January 4th, and I will direct appoint. What is the city's recommendation regarding release?
Given the warrant failure to appear history, including active warrants out of federal and municipal. Another court, the city believes the defendant is a high risk of future failure to appear, asking that bail remain for an amount of 1,000 cash or bond.
The objection.
Yes, Your Honor, I have an objection to the bail amount. I'm going to be arguing for my client to be released on her own personal recognizance. I can explain. So the FTA, she's been moving around and staying in hotels since the charge and hasn't had a permanent address and has not been able to be notified. On top of that, she just is finally on 11 days clean. Her sobriety just started and she's incredibly proud of, and she's taking steps to try and better her life. She actually was supposed to this morning sign for housing papers. She's been homeless for and living out of a hotel for quite some time, and it was a 5-year process of getting these housing documents together, and now she's able to do that, but that was actually this morning that she ended up missing. She's currently trying to gain custody of her child. She's working with multiple caseworkers, basically regarding her different services. On top of that, in her hotel room right now, she has a dog in it, and she's really worried about that dog. But ultimately, she's just she finally, with this 11 days clean, has her life on track, and she doesn't want basically this to be a huge wrench thrown into this. So for all those reasons, we ask for her to be released on her own personal recognizance. Thank you.
Are you in a program right now to support your sobriety?
I actually did it all by myself, but I do plan on getting outreach help, an AA meeting. I've been working with my caseworker for the last couple of days, just, slowly getting myself welcomed into it. It's not really an easy choice to make, but I did it by myself, and I plan on continuing.
Congratulations. I'm very proud of you for making the decision. and
You were the
commit-
first person to tell me that in a few days, so thank you.
I feel very honored to be in that position. Okay. So I'm going to give you, given the nature of this charge, I am going to give you a chance to respond to it out of custody. And we will set this for an out of custody pretrial hearing. Do you have access to a phone or a computer?
Yes, Your Honor, I do. Both.
Okay, we'll set this on, this is City of Seattle, right? Yeah. We'll set this on for February 23rd at 8:45 in the morning. Oh, I want to change that.
Thank you, Your Honor.
Oh, no, there is no, okay, it is 8:40, February 23rd at 8:45 in the morning, and that will be a Zoom hearing like we're having now. Additional conditions of your release: that you attend all future court appearances, have no new criminal law violations. I'm going to order that you not use or possess any alcohol, non-prescribed drugs, including marijuana, or possess any drug paraphernalia, and update your address with the court and DOL immediately if there are any changes. So when you get that housing, which is going to be a huge step for you, make one of those steps, calling the court and updating us with the address. Okay? And quash the warrant in Kent Municipal Court before the next hearing.
Okay, yes, ma'am.
It was,
I'm sorry, I think it was also Pierce County District.
it was at Pierce County, it was Pierce County and Federal Way.
Yeah, they're not expeditable. I'll figure it out though. I'm really trying to figure it all out.
All right, ma'am. You are all set. Do whatever you need to do to support your sobriety, but make that your first priority.
Yes, Your Honor, I got you. Thank you so much. I appreciate you so much.
Take care.
Remember we talked about things you probably shouldn't do in life? One of those is living at home with your parents past the age of 20, especially if it's in the basement and you have a gaming system set up. Number 2 is if you happen to do number 1 for any reason at all, don't trash the place. Like, be respectful. Otherwise, you might get kicked out and then you have no place to live. And then you live in the white creepy van and that's not cool. Not cool.
Did you fill out this document?
Yes.
You
Yes, sir.
swear everything on here is correct?
Yes, yes, sir.
All right, give me 1 second. All right. Right now you're charged with abuse of an elderly adult. That's an E felony, and financial exploitation. That's a D felony. We're going to go through a number of questions and we're going to set a bond for you today. Are you from Knox County?
Yeah.
How long have you lived?
East Knox County, Straw Plains exit, right off the Straw Plains exit.
Okay, how long have you lived here?
I've lived out with my parents most of my life. I've occasionally throughout the years, I've stayed in my own place for a short time, but usually that's what I always go back to there.
How long have you lived in Knox County?
All my life. Yeah.
Are you working right now?
No, I hadn't worked in years.
Okay, are you on disability?
No, I was.
Are you currently on probation or parole?
No, I hadn't been in trouble with the law in years. The only thing I've ever gotten was a public intoxications and a couple of DUIs throughout, but that's been years ago. So I've been, staying at my parents' house for, a long time. So that's the first incident that's happened in years.
Okay. Give me 1 moment.
Okay. Sir, can I ask you a question? I've already been to court. How come these new charges have popped up?
It appears, and that's what I was just asking about it. I see that you had some other charges on here. I can read the warrant to you, but as far as why they brought him at different times, that I can't necessarily. I'm not sure. I wasn't involved with these previous offenses.
I don't have any previous. Everything I'm in trouble for has happened at that one incident.
Yeah, no, and I can appreciate that. They filed these other ones. The other charges were filed on January 15th. These two were filed on January 19th.
Yeah, will you be able to elaborate a little bit?
Well, okay, sure. This incident occurred on or about Sunday, January 15th, 2023 at 15:12. So that would be 3:12 p.m. at 750 Wooddale Church Road, Knoxville, Tennessee, 37924. The charge of abuse is placed against the defendant due to the age of the victim, as the victim is 80 years old, defined in the statute. Victim one stated that the suspect grabbed a wooden baseball bat. Do you want me to break the chandelier or all the windows? I imagine this is that portion of it. Let me see if I can't get to what I would anticipate the new. Placed him and his wife in fear of bodily harm. The victim stated the suspect began to bust all the windows in the residence, busting all of the mirrors in each room and destroying the house. The victim stated the suspect then began to tear the thermostat from the wall and then went into the kitchen.
Okay, sir.
Yeah.
How come he just now thought of this?
I can't.
Thought this was.
Yeah.
I thought this was obvious stuff that
Well,
I thought this I already went to court about.
I can't tell you why they filed it later. It appears as though there was $5,000 of damages in the house, and so I would imagine that it's related to that. And the reason why they may have, I'm speculating here, the reason why they may have charged the other charge is that it may have just been charged as an ag assault initially, and somebody then took a look at it and decided that the individuals in this were 80 years old, or somebody may have been 80 years old, and so they added this additional charge. But I wasn't involved with the previous ones, and so I would have a difficult time elaborating. But that's something that your attorney will be able to discuss with you, and you guys can work that out. All we're doing today for the purposes of this is setting a bond for you on these charges. I'm not authorized. I'm not able to dismiss these charges or to do anything like that. So all we're doing is setting a bond, if you understand that.
Okay, but so nobody will be bailing me out. So, that being the case, I'll be in here for how long?
Yeah, well, let's get through this, and I'll elaborate on all of that. Have you ever had a felony conviction?
No, sir.
Are you currently on probation or parole?
No, sir.
Have you ever had a failure to appear?
No, sir.
Have you ever had any history with substance abuse issues?
Yeah, I used to have a pretty bad alcohol problem.
So do you have family here in the area?
I've got an uncle, which is my dad's brother. I don't think he wants anything to do with me now either. He's off Emory Road.
I got you. And so, are you married? Any kids?
No, sir.
Okay, so you've been here your whole life. You at least have some family in the area. What other ties to the community do you have?
Nothing. I've just been pretty much living in a cave for the past year.
Okay.
Just saying it, man. I don't have a driver's license. I don't have a vehicle.
I got you.
I have nothing.
Okay, give me 1 second.
I'm homeless now. Pretty
All right, for the abuse of an elderly adult, that's going to be a $1,500 appearance bond. On the financial exploitation of an adult, that's going to be a $2,500 appearance bond. And so, since I'm not able to give you pretrial release on these offenses, we're going to be setting these on Wednesday, January 25th in felony court for a bond hearing. You'll have an opportunity to have an attorney at that time, and they will be able to negotiate with the state on your behalf. And you would have an opportunity to have a bond hearing in front of one of the judges up there. Have you had an attorney in Knox County previously?
A long time ago for like a DUI.
Okay, do you have somebody on these new charges? The other ones? You say you've been to court on them already, is that correct?
The other, yeah, I thought it was over the whole case. So I just don't quite understand what's new, what they found out any different.
Well, I see that the public defender has been representing you on the previous charges. Once again, you're charged with financial exploitation of an elderly / vulnerable person. That's a D felony. There's a $2,500 appearance bond, and it is abuse of an elderly adult, E felony. That's a $1,500 appearance bond. I see that you've had the public defender is on these other charges. Has that been going well, or have you had an opportunity to even speak with them yet?
Yeah, let's see. His name was
Andre Johnson.
Andre?
Yeah.
Mm-hmm.
So we're gonna
I talked to him in court.
Okay. Well, we're going to put the public defender on these cases as well.
Okay, so I'll be seeing Andre again.
Yeah, on the 25th.
Okay. And then would he be able to tell me then when I'll be released?
He'll be able to assist you and talk to you. I would imagine answer any questions that you would have. Do you have any questions right now?
No, I was just curious of when I'll be released because nobody will be bailing me out.
Well, and that's something that I'm not able to tell you. That's something that your attorney will be able to assist you with.
Okay, I guess that's it.
Apparently, sleeping at SeaTac is also one of those things you're not able to do if you don't have a ticket. 53 days in jail. And he was caught loitering, sleeping because he had no other place to go. And I imagine it's pretty cold up there, like cold and wet and rainy. I think that's like the year-round forecast. 53 days. Man.
Crime of criminal trespass in the first degree. Do you understand the elements of that crime? In other words, what the city would have to prove if you were to take this to trial?
Correct.
By entering into this plea, you're giving up a number of very important constitutional rights. Among these are the right to a speedy and public trial, to remain silent during that trial, or to choose to testify, to see, hear, and question witnesses who would testify against you, to have witnesses testify on your behalf at no expense to you, to the presumption of innocence unless and until a jury were to find you guilty, and to appeal a finding of guilt. Do you understand you're giving up all those rights?
Correct.
The crime of criminal trespass in the first degree is a gross misdemeanor punishable by up to 364 days in jail and a $5,000 fine. Is that your understanding?
Correct.
I know your attorney and the city attorney have an agreed recommendation. It looks like for credit for time served, but the court does not have to follow that and can sentence you anywhere up to the maximum. Is that your understanding?
Yes, it is.
Do you understand in the event you're not a citizen, a guilty finding on this charge may be grounds for deportation, denial of naturalization, or exclusion from the United States?
I understand.
Did anyone make any promises to you to get you to enter into this plea?
No,
Did anyone make any threats to get you to enter into this plea?
no, not at all.
Are you doing this of your own free will?
Correct.
In paragraph 11, there's a statement that reads, on December 4th, 2022 in SeaTac, Washington, I unlawfully entered the SeaTac International Airport Terminal by entering the Skybridge 3 and sleeping in a wheelchair while I waited for the Sound Link light rail trains to resume running in the morning. I entered the SeaTac Airport after previously being told by police officers that I was now not allowed to return without an authorized purpose. I know your attorney wrote that, but do you adopt that as your own statement?
Correct.
Is that a true statement?
Correct.
As to the crime of criminal trespass in the first degree, how do you plead?
Guilty.
I will accept the plea. I do believe it's knowingly, voluntarily, intelligently made, and there's a factual basis to support it. Ms. Chenweller, anything to add to the sentencing recommendation?
No, thank you. It is a great recommendation.
Mr. Zenner?
Your Honor, nothing to add. It is a good recommendation. He has served 53 days in custody since December 4th. Regarding fines, fees, and assessments, Mr. Stitt's financial situation has not changed since the last time he was in front of this court. He doesn't have any ability to pay any kind of fines, fees, or assessments at this time. Nothing else from defense.
I'm sorry, it's 51, right?
So it's 28 plus, I mean 51, yeah, 28 for December and then 23, yeah, 51, I apologize.
Mr. Stitt, is there anything you'd like to say?
No, there's not.
Mr. Stitt, what's it going to take for you to not return to the airport? I mean, you've just spent 51 days in jail.
Correct. Yeah. Yeah.
Yeah, that's a lot of time.
That is.
So did this impress upon you the importance of not returning to the airport?
It did. Like, yeah, I didn't know I was gonna be here for that long, but yeah.
I'm going to follow the agreed recommendation. I do think it's appropriate. Oops, I'm in the wrong one. So 364 days in custody with 313 suspended, 51 days credit for time served, $5,000 fine, all 5,000 suspended. The court is taking 24 months of jurisdiction, and jail time will be concurrent with any other holds and including the reviews. I am making the finding that you're indigent per se by virtue of the fact that in my recollection is you have no income. I can't remember if you have. Do you receive government benefits?
No, not at the moment.
But you have no source of income. Is that still accurate?
Correct.
I'm making the finding then that you're indigent. For the next 24 months, you need to attend any future court appearances, have no new criminal law violations, no contact with SeaTac International Airport or the rental car facility except for valid travel purposes. So Mr. Stitt, you cannot go back there if you're waiting for the light rail to start running again. That's not a place to wait, okay? Okay. And update your address with the court in DOL immediately if there are any changes. Do you still receive mail at the address on Southeast 151st Street in Renton?
It should be 13303?
Yeah.
Correct. It should, yeah.
If there are any changes in that, be sure to update the court.
All right.
And then with regard to the reviews, I see the parties are not seeking any action.
Correct, that's the agreed recommendation, with no action and just leave them on court monitored supervision for no law violations and no return to airport.
Okay. Mr. Stitt, you have a few months short of 3 years of jail hanging over your head. That could all be imposed. Okay, the court could do that, revoke all of it and say, nope, you're just going to be in jail for almost 3 years if you go back to the airport. Okay, you cannot go back to the airport unless you have a ticket.
Understood.
All right. I'm not going to take any action on the reviews then. You'll be released on all matters today.
Thank you.
All right. Thank you, Mr. Steth. I don't want to see you back here like this, okay?
I know.
Okay.
Thank you.
Thank you.
Thanks.
Is the
So I had this next one clipped, but Mike got to it before me. But just in case you missed it over at Law Talk with Mike, this is Mr. Johnson. Mr. Johnson has trouble saying certain words.
All right, we have Mr. Johnson here now. His audio is connected. Mr. Johnson, can you hear me?
Yes.
All right. We are on the record then in the people of the state of Michigan versus Gregory Ernest Johnson. It's file number 21-20333-FH. Today's date set for a final pretrial conference in this matter. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Johnson this morning, Your Honor.
All right, and Ms. Underwood, where do we stand with the case today?
At this time, Your Honor, I believe Mr. Johnson will be pleading guilty on a delayed plea basis, Your Honor, to the 4-year child support case, Your Honor, with the provisions that the sentencing be put out 11 months if Mr. Johnson gets his arrearage down to 8,000. It's my understanding he gets an attempt, and if Mr. Johnson manages to pay the whole arrearage down in that time, Your Honor, then he would be eligible for a misdemeanor disorderly in this case, Your Honor. I believe that is, and I believe Mr. Johnson is to pay $100 a month, Your Honor. I believe that is the plea bargain that Mr. Johnson will be pleading to today.
Okay, Ms. Brenner, is that a complete and accurate statement of the agreement?
That's correct, Your Honor. He's to pay a minimum of $100 a month. He did not pay last month, so I do expect him to make up that missed payment as well.
I did pay.
The front of the court system is not showing the payment at this time.
Underwood
So.
has the
Mr.
Miss
Johnson,
Underwood has
stop.
the receipt.
It's okay, Gregory.
We're not going to argue about this on the record right now. If the payment was made,
I will send Ms. Brenner the proof I have.
Okay, that's fine.
Mr.
I just don't see it in the front of the court system yet.
Okay, thank you, Mr. Johnson. But that is the plea you're taking this morning, correct?
Yes.
Thank
We
you.
can't see you anymore, Mr. Johnson. There you are.
all right, Mr. Johnson, would you raise your right hand, please? Can't see you now, so if you have your right hand raised, please let me know when you have it raised.
Yes, it's raised.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I suppose.
I need a yes or a no.
Yes.
You are Gregory Ernest Johnson, correct?
Yes.
Mr. Johnson, you heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, failing to pay child support?
Yes, I accept the plea.
Is it your intention to plead guilty today?
Yes, I accept the plea.
Are you satisfied with Ms. Underwood and the advice that she's given you?
I suppose.
Do you understand that the maximum penalty for this offense is up to 4 years in prison and or a $2,000 fine?
Yeah.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court, other than as we've discussed it on the record here this morning. Is that correct, Ms. Brenner?
That's correct, Your Honor.
That's correct, Your Honor.
Is that also your understanding, Mr. Johnson?
I don't know. I didn't understand the question.
Other than as we've discussed on the record here today, no one has discussed a possible sentence with me. Do you agree with that?
With me, right? Okay.
No, with me. No one has discussed a sentence with me, other than as we've discussed on the record here today, not Ms. Brenner, not Ms. Underwood, and not yourself. Is that right?
Right.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy. Mr. Johnson, if you're going to interrupt me, I'm going to hold you in contempt.
I'm sorry.
This is not a funny matter. You have the right to a speedy public trial by jury. You can ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have to your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Johnson, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yeah.
Do you also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
I didn't understand that.
Do you understand that any appeal that you might make from this conviction and sentence would have to be by application for leave to appeal and not by right?
Okay.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
He's muted now.
Yeah,
I didn't mean to mute. I don't know how I muted. How did I mute?
Weird.
Do you have any questions about any of those
Weird.
rights, Mr. Johnson?
Crap.
You're unmuted now, Mr. Johnson.
I'm about to get, I'm not, I shouldn't be. I'm not on my headset though.
We can't hear you.
Well, I'm trying.
We can hear you. We hear you.
Oh, okay. Well,
Mr. Johnson, do you have any questions about any of the rights that I've explained to you?
no.
Do you understand that you're giving those rights up?
Yeah.
How do you wish to plead to the charge that on or about September 1st, 2018 through September 30, 2019, in the city of Adrian, County of Lenawee, that you did commit the offense of failing to pay child support?
I accept the plea.
If you want to plead guilty, you need to say guilty.
You want me to say guilty? Okay, fine.
If you want to plead guilty to this offense, then you need to say that you plead guilty.
I accept the plea.
That's not,
Mr.
that's not a
Johnson,
guilty plea. So if that's all you're going to say, Mr. Johnson, then I'm going to continue your not guilty plea and we'll proceed to trial on January 25th.
I never entered a not guilty plea.
Yes, you
Mr.
did.
Johnson, there are two pleas available, guilty or not guilty. Which do you choose today? Guilty or not guilty?
They want the not guilt or the guilty, so that's
Well,
fine.
no, Mr. Johnson, it's a matter of what you want to do today. Do you want to plead
No,
guilty
it's
or
not a
not
matter of
guilty?
what I want to do.
Mr. Johnson? Are you going to plead guilty today or not?
Yes, that's acceptable.
If you want to plead guilty, you need to say that you're pleading guilty.
Yes.
Your audio was not clear. What did you just say?
Yes.
All right, this is the last time I'm going to explain this to you, and otherwise, we're just gonna leave the trial set. How do you wish to plead to the charge that you failed to pay child support?
Well, you determined that I was guilty, so yes, I am guilty.
Sir, the elements of the crime are you were ordered to pay child support and you failed to pay for whatever
My
reason.
income did not support that.
That
The
doesn't
judge
matter.
knows that.
That doesn't matter.
Well,
The-
he found me guilty, so that's where
He
it
didn't
is.
find you guilty. He's
Yes, he
asking,
did.
were you ordered to pay child support and did you fail to pay it? It's either yes or no. If it's a
I
yes,
did
then
not.
you plead
My
guilty.
income did not support the child support.
Judge, let's just leave it on for trial.
No, I want the deal.
Then you need to
Well,
admit what you did.
Mr. Johnson,
Mr.
you can't,
Mr. Johnson,
Ms. Underwood,
you are,
please allow me,
Mr.
Ms. Underwood.
Johnson, Mr. Johnson, you are
Yes.
confusing the issue. The judge found that the child support was appropriately set, okay? He
Which it
found you
was
could not
but
go
that's
back.
fine.
That is a
I
separate
get that.
issue
Okay.
than the criminal, than the criminal issue we have today. Now, did you pay that child support or not? If you did not, then you need to say
I
the
was
word
unable.
guilty.
No, I did not. Okay.
So is that a guilty?
We're not going further with this. The record is already not satisfactory.
I'm guilty of the circumstances that set this thing.
Mr. Johnson, please do not interrupt me. If you interrupt me again, I'm going to hold you in contempt and I'm going to give you 30 days in the Lenawee County Jail. All right. I do not believe that the record created in this case today to this point would appropriately allow me to accept a guilty plea. Mr. Johnson has not indicated.
Yes, guilty.
Mr. Johnson has not indicated a clear intent to plead guilty and admit to the facts that would support a guilty plea in this case. Trial is scheduled for January 25th at 9 a.m. If I don't already have proposed voir dire questions and jury instructions, I'd like those submitted by Friday.
Yes, Your Honor.
And we will proceed to trial on January 25th. There is a plea agreement deadline on January 23rd. So assuming that Ms. Brenner is willing to leave that agreement open, I will accept a plea up until that point. If Mr. Johnson decides that he wants to unequivocally admit his guilt.
Guilty. I plead guilty.
I've made my decision for today. If Ms. Underwood,
guilty.
Ms.
You want
Underwood,
to
if
set a
Mr.
time for January 23rd, Judge? That we could check back in or not?
I plead guilty today.
Mr. Johnson, I've already explained to you that you have behaved today in a way that I am not going to accept a guilty plea from you based on what you've said on the record here today. If you decide that you want to make a guilty plea, I would ask you to contact Ms. Underwood, have her arrange a time either tomorrow, Friday, or Monday to enter that plea. And if you show up and you answer the questions, Mr. Johnson, I've said it, this is the last time I'm saying it for you. If you interrupt me one more time, I'm going to hold you in contempt and sentence you to 30 days in the Lenawee County Jail. I am done. I've instructed you now as to how you can proceed if you want to enter a guilty plea. Contact Ms. Underwood. She'll make arrangements with my office. This hearing is concluded. Please log out.
Thank you, Your Honor.
Thank you, Your Honor.
All right, my friends, thank you for stopping by. Please take a moment, hit like, hit subscribe, help me out. I appreciate it. Happy Monday morning. Aren't Mondays the best? You know what's better than Monday? Sunday night, when you're watching a little Bond court to fall asleep. You can't watch serial killer stuff to fall asleep because that might give you nightmares or something. So you go with, the subtle Bond court. I saw more crazy in a couple clips than I have seen probably ever, and I watch a lot of court clips. The world's gone mad. It's madness. Here we go.
Okay, Ms. Turpin, you have been charged with 3 counts of aggravated assault. Each of those would be a Class C felony if convicted, and you've been charged with resisting a stop, arrest, or a search. That'd be a Class B misdemeanor if convicted. You understand what you're charged with?
Yes,
Would you like me to read the allegations?
yes.
Says this incident occurred on or about Saturday, January 28th, 2023 at 5:36 p.m. Officer Lee and I responded to the listed address for a domestic matter. Upon arrival, I spoke with Marcy Turpin, and she stated that she and her mother, Gwen Turpin, were in an argument. Marcy stated that her mother had consumed 6 beers and was trying to leave in a car. During the argument, Gwen shoved Marcy. Marcy was given a blue card and advised of legal remedies. Gwen was not home during the investigation. This occurred in Knoxville, Knox County, Tennessee. At 6:25 p.m., we responded back to the same address. When we arrived, 3 victims, Ira Turpin, Michael Caldwell, and Tana Craze, all stated that Marcy Turpin tried to stab them with a knife. Ira stated that she came at with the knife in her hand and attempted to stab him. Tana stated that she tried to stab her too. Michael stated that she did make contact with the knife and the palm of his hand, but there was no injury. They were able to get the knife away from her. A green steak knife was on a shelf by the door. Ira and Michael both described the knife as a green steak knife and said she tried to stab everyone by holding the knife above her head and pointed at the victims and jerking it down in their direction. Officer Lee and I attempted to handcuff Marcy, but she fought us for approximately 2 to 4 minutes. While struggling with her, she tried to pull away and made noises. In parentheses, it says cleared her throat, as if she was going to spit on Officer Lee. I held her head on the ground so she couldn't spit on him. She then tried to bite us. Sergeant Lamb assisted us and eventually had to tase her in the back. We were able to get her in handcuffs. When we put her in the car, she kicked at the door and window. Officer Lee held her on the ground until the wagon arrived. She is being arrested for 3 counts of aggravated assault and resisting arrest. All parties stated that Gwen did not shove Marcy. This occurred in Knox County, Tennessee. A citation was not issued because this is domestic violence, and officers shall arrest the primary aggressor. Okay, you have some rights I need to go over. The first is that you have the right to remain silent. No one can force you to make any statements. Any that you make voluntarily can be used against you. You have the right to an attorney. If you cannot afford one, I can appoint one for you. And you have the right to a preliminary hearing, that is a probable cause hearing, where the judge will hear the evidence against you and decide whether this case is strong enough to be bound over the grand jury for further prosecution. Do you understand those rights?
Yes,
Would you like me to appoint an attorney to represent you?
yes.
Okay, I need to ask you some questions on oath to make sure you qualify, as well as to set your bond. So you raise your right hand and be sworn in. This is the uniform affidavit of indigency that you filled out of jail. You swear or affirm that everything you filled out on this form, any testimony you give is true and accurate?
Yes.
Thank you. You have a
I have a
job?
question.
Let me get through this first and I'll take your question.
Okay.
You have a job?
No, no.
Any property Any property, a house, or a car that you own?
Nope.
Any other forms of income or of assets?
What?
Any other forms of income or of assets?
Like phones?
Anything that you could sell to make money?
No. Sorry.
And you live in Knoxville?
Yes.
How long you lived here?
I was born and raised in UT Hospital.
You have family here?
And yes, well, yeah, in the Knoxville area, yeah, but not in jail.
Who would that be?
For my family,
Correct.
like in here or out there?
I mean, I'm
Knoxville?
not worried. In Knoxville, I'm not trying to figure out who
Okay.
you know in jail. I'm trying to figure out your ties to the Knoxville
Sorry.
community.
My mom, Gwen Johnson, my brother, my stepfather, my dad, my grandmother, and my cousin, and I'm actually a lot of them, actually.
And
Everybody.
is there anybody that would vouch for your liability to show up in court?
Probably the victims, probably. Probably my mom or, probably.
Okay, so I'm going to set the bonds on the aggravated assaults at, well, first the resist, I'm going to set at 1,000. And on the aggravated assaults, I'm going to set it at 10,000 each. So that's 31,000 total. As a condition of those aggravated assaults, 2 of them are charged as domestic, 1 is not. For the 2 that are domestic, you would be prohibited from committing or threatening to commit assault against the alleged victim or victims or other family or household members. You would be prohibited from harassing, annoying, telephoning, contacting, or otherwise communicating with the alleged victim, either directly or indirectly through someone else. You'd be directed to vacate and to stay away from the home of the alleged victims, and to stay away from any other location alleged victims are likely to be.
That's not gonna happen.
You'd be prohibited. Well, if it doesn't happen, I don't know what you mean. Whether it means you're going to stay away or.
Because I'm gonna go back and I'm actually kill all of them, to be honest.
Well, I mean, do I need to revoke your bond? I can't constitutionally do that.
Because I'm just actually fed up with my family. Because when I catch them asleep, they're gone.
Okay, so here's what I'm going to do. Rather than 10,000, I'm going to set them each at 25,000 for a total of 75. And you'd be prohibited from using or possessing a firearm while on bond, should you post it. And you'd be prohibited from possessing or consuming alcohol or controlled substances while on bond. The alleged victims in those are Gwen Turpin and Michael Caldwell. And then for the other one, you'd not have any contact or communication with the alleged victim, who is Ira.
Are you serious?
No, it's Hannah Craze. And I'm going to set these in felony court.
They're getting it when I get home.
I'm going to set these in felony court on Tuesday. So if you're unable to make this bond, then the judge can reconsider it at that time. If you do post it, they will give you a different court date to go to when you've been released. Go to that one instead.
I'm mad. Really, really mad.
They have the number of the public defender's office to the jail. Try and get a hold of them prior to your court date. Excuse me, I've not gotten that far. Getting ahead of myself. I gotta wait for this to print out.
I'm really mad. I'm freaking pissed off. Sorry, but that's bull crap. My mom started it. You got drunk. Yeah, she did put hands on me, actually. They're just lying about it to get away with it, to be honest. Because I was actually in the kitchen when she put hands on me. So I was gonna end up punching her to keep her, or defending myself, and she.
And it looks like you are currently represented by the public defender in some cases that you have pending.
Patrick.
That is the specific one that is assigned, yes. I will appoint them to represent you in this case as well. I'll waive the administrative fee that we normally assess for the appointment of counsel because it's already been assessed in a pending case.
Okay.
They have the number of the public defender's office to jail. Try and get a hold of them prior to your court date, which if you don't post those bonds, will be on Tuesday.
Well, if I get released in court, I mean, I'm going back to the house and I'm going to actually get tipped in murder, to be honest with you.
So,
because I'm actually done with my family, because they're not.
So you said that you had a question earlier. What was that question?
The question was, if I do get out, if I go back to that house.
They'll revoke your bond and charge you with a new offense. It's an offense to violate that order. So not only will they revoke your bond, you won't be able to get back out of jail, but you'll also get a new charge.
For attempted murder.
And that's all I have for you.
All right. There you go. Is that it? Yep,
That's
there's
it.
your stuff. We can put that.
It was pretty hard not to interrupt that one every 2 seconds to say, what? Are you serious? What? Don't say that. Shh. Don't say that. Wow. I thought for a minute maybe she was a little, I don't know. But then she caught herself from cursing in court. So, you know, I don't even know what to say to that. Wow. 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 Yeah. Wow. Wow. Please don't stab your parents. I know you're upset. That's not the way out of this.
Hi, how are you?
Hello, what's your name?
My name's Hediel.
And last name Hamid?
Hamid, yes.
All right. And Hamid, you have been charged with aggravated assault. That would be a Class C felony if convicted. You understand what you're charged with?
No.
So aggravated assault, they're alleging assault with a deadly weapon, specifically a knife. And it's a Class C felony, which means if you have no priors, which I don't think you do, if you're convicted, you would be facing a sentence between 3 and 6 years, which can either be incarcerated or on probation. Would you like me to read the allegations?
Can you say it again?
Would you like me to read the allegations?
It's like you said, I fight with knife, but I didn't beat her by knife, like to cut her or maybe.
Well, I'm not
Okay,
saying you are, or you did, or you didn't. I'm just telling you what you're charged with.
It's like I just told her,
So,
can I be?
Listen, time out. So right now, this
No,
is.
I told her. Sorry.
Time out. Time out. I'm telling you, time out before you hurt yourself. Your legal case. So.
Okay.
This is just an arraignment. This is not a place to argue your case. All I'm doing is telling you what you're charged with, telling you your rights, getting you a court date and an attorney if you'd like one. That's all we're doing. Don't argue your case. You don't know the law. You might end up hurting your case. Okay? Well, I'm not saying you don't know the law, but chances are. Okay.
I don't know the law.
So, would you like me to read the allegations? That's specifically what they're accusing you of doing.
No, but can I know if that's what you charge me? What?
It's
No, thank you. I just get it.
Tell you what, I'll read them anyway. It says, This incident occurred on or about Saturday, January 28th, 2023 at 2:22 p.m. at 7224 Jana Chris Lane. On that time and location, Officer Messer responded to that location in reference to a domestic matter. Upon arrival, the complainant, Hadil Hamid or Hamid? Am I pronouncing it correct?
Hadil Hamid, Hameed.
Okay. Stated that her mother attempted to stab her with a knife and that the complainant was made to live in a dirty place. Upon speaking to the victim, Huda Ahmed, she stated the suspect has mental issues but does not take medication. The victim further stated that it was actually the suspect that attempted to stab her and showed officers a video from their doorbell camera showing the suspect with what appeared to be a kitchen knife in her hand, lunging at the victim in an attempt to harm her. The suspect was taken into custody for aggravated assault and transported to the Roger D. Wilson Detention Facility via wagon. The victim refused medical treatment. The victim was advised for legal rights and given a blue domestic violence card. This occurred in Knoxville, County, Tennessee. All right, you have some rights I need to go over. The first is that you have the right to remain silent. No one can force you to make any statements. Any that you make voluntarily can be used against you. You have the right to an attorney. If you cannot afford one, I can appoint one for you. And you have the right to a preliminary hearing that is a probable cause hearing where the judge will hear the evidence against you and decide whether this case is strong enough to be bound over the grand jury for further prosecution. You understand those rights? You understand your rights?
No, I didn't understand my right.
Okay. Is it because of a language barrier or?
It's like I didn't hear it. Can you say it again, please, and thank you?
Okay. You have the right to remain silent. No one can force you to make any statements in this case. Any that you make voluntarily can be used against you. You have the right to an attorney. If you cannot afford one, I can appoint one for you. And you have the right to a preliminary hearing that is a probable cause hearing where the judge will hear the evidence against you and decide whether this case is strong enough to be bound over the grand jury for further prosecution. Do you understand those rights?
Did you say my right is I can be out of here?
You do have a right. You do have a right to a bond, but even then, you still have to come back to court.
All right, I can be back to court, but can I be out of here? Or what the second right?
The second one was the right to an attorney. I can appoint one if you cannot afford one.
What does that mean?
It means if you cannot afford an attorney, I can appoint one. I can give you an attorney. I can give you an attorney.
No, I just want to be able to be out of here, and I will be back for your card.
So, are you going to represent yourself?
If that's work.
So I can appoint an attorney. All righty. Let me ask you some questions on oath.
Okay.
And set your bond and see if you qualify for an attorney. So will you raise your right hand and be sworn in?
Can I know my third right?
That's a preliminary hearing. So there's different levels in the prosecution. So they don't go straight to a jury trial. They have a check. So first they come to me, the magistrate, and say, the police officer says, this person did this and that, but it's just allegations. They're saying that you did it. So then they go to the preliminary hearing, which is the two sides have a hearing, and he decides whether there's probable cause that the crime was committed and that you committed the crime. Then if he feels that it is, then he binds it over to what's called the grand jury. And then the prosecutor presents the case to a jury, and they do a probable cause check to make sure that it meets the elements of the crime and that they believe that probable cause that you did it. If they do that, then they indict you, and then it goes to the trial. And then you have the trial where you get witnesses and they bring witnesses, and if they believe beyond a reasonable doubt that you committed this crime, then they convict you. And after that, it goes to appeals.
All right.
So,
I have what?
What's that?
The first choice is means I'm able to be out here today.
No, these are not choices. These are rights. So
I mean, my first right.
So you do have a right to a bond, but you would have to post that bond to get out.
What that mean post?
So I'll name a number, And so it's 10% of that. You call a bonding company, you pay them 10% of whatever that number is, and then they'll let you out, and you have to come back to court, or you owe them the remainder of that
Like how
bond.
much? How much I have to pay?
We'll see. We haven't gotten that far yet.
All right.
Okay, so I need to ask you some questions on oath to set your bond, as well as see if you qualify for a court-appointed attorney. So will you raise your right hand and be sworn in? This is the uniform affidavit of indigency that you filled out of the jail. You swear or affirm that everything you filled out on this form, any testimony you give is true and accurate?
Yeah.
Thank you. You have a job?
No.
Any property?
Is this work if my sister paid for me?
We're not there yet. Any property, house, or car that you own?
They will be here today.
We don't know. You own any cars? You own a car?
Yeah, I own my car.
What is it?
That's right. It's Toyota Virus. Virus. BIRUS.
Wait, what year?
It's 2005.
What do you think it's worth?
What, sorry?
What do you think it's worth? If you were to sell it, what would you ask for it?
I don't know. Any prices? Any price? Maybe all the price that can take me out of the jail.
So how much would you ask for if you were selling? I bet it's a Prius, I bet it's Prius.
It can be 2,000.
You owe anything on it?
But I just want to sell it.
Do you owe any money on it? Do you make payments?
I know I don't have payment on it.
You live in Knoxville?
Yeah.
How long you lived here?
It's like more than 5 years. I don't know exactly. I just came out 2016 and I'm here until 2023. So yeah.
Do you have any family here?
Yeah, I have my whole family.
And is there anybody that would vouch for your liability to show up in court?
What do you mean?
Is there anybody that would tell me that you're going to show up to court?
Yeah, I will call by my sister's number, and I will tell you if I will be here.
Okay, I'm going to set the bond at $10,000. As a condition of that bond, should you post it, you'd be prohibited from committing or threatening to commit the offense set forth in the arrest warrant against the alleged victim or other family or household member. You would be prohibited from harassing, annoying, telephoning, contacting, or otherwise communicating with the alleged victim, either directly or indirectly through someone else. You'd be directed to vacate and to stay away from the home of the alleged victim, and to stay away from any other location the alleged victim is likely to be. You'd be prohibited from using or possessing a firearm while on bond, and you'd be prohibited from possessing or consuming alcohol or any controlled substance while on bond. And the alleged victim's name is Huda Ahmed.
Yeah.
And I'm going to set this in felony court.
You said how much? How much I have to pay?
$1,036.50.
1,000. Okay. How much I have to pay first to be out of here?
That's
like
it.
10%?
No, that is 10%.
Oh, so 1,000 is 10% of it?
Correct. And I'm going to set this in felony court on Tuesday. So if you're unable to post this bond, the judge can reconsider it at that time. If you do post it, they will give you a different court date to go to when you're being released. Go to that one instead. And I'm going to appoint the public defender's office to represent you.
So, will you give me a receipt? Then I will be back to pay it, you said?
And I don't know. You'll have to work that out with the bonding company.
It's like you said.
There is a $50 fee for the appointment of counsel. That needs to be paid in the General Session Court Clerk's office on or before February 12th. But if you are unable to pay by that time, they will add it to your court costs at the conclusion of the case.
So
They have the
for how long I should stay to pay it? Like how long time?
I don't know. You'll have to ask for a phone call.
Can you say it? Sorry. Can you say it because I didn't understand.
You'll have to ask for a phone call.
No, you said
There's a $50 fee for the appointment of counsel. That needs to be paid in General Session Court Clerk's office on or before February 12th. But if you are unable to pay by that time, they will add your court costs at the conclusion of the case. They have the number of the public defender's office to jail, try and get a hold of them prior to your court date, which if you don't post that bond will be on Tuesday.
All right. Can you say the date again that I will be able to pay?
Right now. Right now.
No, it's not the. No.
Right now. As soon as you can make a phone call.
I can make my phone call.
I can't say that you can make a phone call, but as soon as you're
sorry.
able to make a phone call, you can make it.
All right. So until, all right. So what today date? 30?
Today is the 29th.
So today is. So can I be out? Then I will be back to bed.
No, they'll give you a different court date if you get out.
No. All right, let's work. Can you take me out? Then I will be back in different date and based. Please and thank you.
You have to post the bond to get out.
Okay. What does that mean, post the bond?
Correct.
What does that mean, post the bond?
You have to call a bonding company.
Oh, yeah, but he said you can.
You have to call a bonding
Base
company.
later.
Yeah, okay.
I didn't.
Are we done here?
Yeah,
I didn't
yes.
understand. Sorry.
Thank you. All right, you can,
I didn't understand.
I'll let the men know that we're done.
All right, thank
All
you.
right, so what he said.
No, there's a little bit of a language barrier there, but he just wants the hell out of there. She wants out like now. And I mean, I don't blame her. I'd want out too, but it's with stabbing people and knives and threatening to stab people. Don't do that. Don't. Not a good thing. Then you end up on bond court and stuff. The interesting thing was she thought there was like an IOU for the bond. And again, I know there was a language barrier, but I'm curious, is that a thing somewhere else? Is there another country where you can get an IOU on the bond? Like, hey, let me out. I promise I'll come back and give you that $5,000 I owe you. Like, I might have to look that one.
I can't see the judge. Right here. That's right in front of you. Yeah, it got a blur. I cannot see the judge. Can't fix that. I just judge the clone right now. Am I right or wrong? I can see it.
Is this Mr. West? Let's put him on mute, please.
You said put him on mute?
Yes. Mr. West, this is your extradition hearing. You are being alleged as a fugitive. You do not have charges facing you in this case, in this state. However, there is another state that is requesting that you return. You are wanted out of the state of Texas as a fugitive for violation of probation. And they have indicated that they want to take you back to the state of Texas. In accordance with the state laws of Georgia, you are brought before me for an explanation of this proceeding. You have the right to contest the legality of these proceedings and voluntarily be returned, or you may waive your right to the extradition process. So it is the desire of this court. You know what? Let's reset him till tomorrow. Let's reset him to Miss Mary. Did you see that? Hear that?
I'm judge. I apologize. I'm just. Yeah, we reset. I'm just excited.
We're gonna, you can't be that excited, sir. Have a good day. We'll see you tomorrow. Have a good day. You are reset. Reset till tomorrow. You're wasting your breath because I can't hear anything you're saying and I don't read lips.
Does his happy dance remind you of anyone? Just saying. Some people get very excited in court. He is very excited to go to Texas. Everything's bigger in Texas. Maybe I should move to Texas. Texas is a great place. Maybe. Maybe not. Judge Stevens is in Texas. Whoa, mama.
Please fix your shirt.
I had to throw that one in there because it reminded me of Mike. And Law Talk with Mike, if you're poaching this clip, you got to throw this one in there too. Fix your shirt, man. Fix your shirt. I mean, don't, because it'll make Kel Murray upset, but Fix your shirt.
The judge need you.
Again, are you Cedric Bohannon?
Ma'am.
You were charged with terroristic threats, possession of a weapon during the commission of a crime, and obstruction of an officer. Do you understand your charges?
Ma'am.
On the terroristic threats, your bond is $10,000. For the possession of a weapon during the commission of a crime, your bond is $10,000. For the obstruction of an officer, your bond is $3,500, for a total of $23,500. A condition of your bond is you shall stay away from Rodney Campbell, and you shall not return to 6057 Pine Creek Road in Forest Park. Do you reside there with Mr. Campbell? I'm sorry, I didn't hear you.
Ma'am.
Since that is your residence, I will allow you to go with the sheriff's escort for the limited purpose of retrieving your personal property. However, you may not go back to that property for any other reason without a sheriff's escort until this case is resolved or until that condition is modified by another judge. You must also not violate any laws out on bond. Do you understand? They have you muted again. I'm sorry, I can't hear you.
Yes, ma'am.
Are you able to make bond?
Yes, ma'am.
Two of your charges are felonies. As such, your next court date will be February 13th at 8:30 a.m. in room 201. Have a good day.
Go back to the cell.
What to do at your arraignment/bond hearing? Look fly, say not guilty. Got it. Okay. Okay, I'm good. Got it.
Sir, your charge is disorderly conduct. Do you understand your charge?
No statement charge?
Yes.
Not guilty.
All right. Your bond is $1,500 and you must not violate any laws out on bond. Are you able to make bond?
Not as of right now, but I want to file a motion for dismissal. Send the court a motion on a proof of service.
Okay, you can share that with your attorney. Your next court date will be February 14th at 8:30 a.m. Have a good day.
Guess who got bunked with the jailhouse lawyer? That guy. But guess who's back? And he hasn't fixed his shirt.
The very first.
Hold on one second. What? Where is Hector Duran? Did we find out if he was OTB, Miss Mary? I'm sorry, that was like a whole hour ago. The add-on.
Yeah, he's OTB.
Okay. What was your question, sir? What'd you say, Miss Mary? I'm sorry.
No, not what's a minute.
She saw you already. So why you back in line?
Because we clarity on her order.
Cleared on her order.
Yeah, she asked about a move out date. I was like,
What? Come on, Bohannon, because I don't even know how you got up here. What's the question?
on your move out day, you requested, I was just letting you know that I have a legal lease signed with that tenant at their residence. Are you telling me I need to leave?
Yes.
Yes. You have to, you can talk to your lawyer about that, but this is something we do in all those types of cases, whenever there is allegations of violence. And honestly, based on the only reason I gave you a bond, to be honest, is because your criminal history is not as bad as some others that I see. But yes, you actually are not supposed to be, a lot of judges will not even give you a bond, but we're supposed to see, would you be a risk for reoffending, which I don't think you will. But we also have to make sure that you're a protection. We have to do a protection for the public interest, which I can't take that risk. So no, you are not allowed to go back to that property without a sheriff's escort. You can get your property when you go with the sheriff's escort, but barring that, do not go back there. You do have an attorney who can share with the judge, another judge, about, you know, leases and all of that. But for now, you're not allowed to live there. Am I clear?
Yes, ma'am. I just want to know, how do I get to school? Do I go to the deputy, to the sheriff?
They can tell you all that when you get ready to bond out, okay? Have a good day.
It would make Penny very happy if you would like, subscribe, and leave us a comment.
Tyrese Williams. Mr. Williams, you are charged with felony count of violation of the Georgia Controlled Substances Act, tinted windows, use of possession of drug-related objects, and another felony count of violation of the Georgia Controlled Substances Act. Do you understand your charges?
Yes, ma'am. I got one question though. When they pulled me over, they told me it was for my tax.
Let me stop you. It's not time for you to ask me questions. I asked you questions and you said you do understand your charges. For the drug felony charges, your bond is $7,000 each. For the tinted window, your bond is $500. And for the use of possession of drug-related objects, your bond is $1,500 for a total of $16,000. And you must not violate any laws out on bond. Are you able to make bond? Your next court date is February 13th. Now, what was your question?
When they, during the traffic stop, they told me it was, for the tag and not the tent.
Okay, you can share that with.
Man, I hate to tell you, but I don't think the tent ticket is the issue here. It might be a little bit bigger than that. Yeah, I think it's a felony. I don't know. Not a lawyer. Might want to consult a lawyer, but I'm guessing. Be absolute madness without a quick trip to Florida. Just real quick. Just a peek.
Brian, the charge is burglary of a structure. There's probable cause for those charges. As to that charge, you want to represent yourself. You're going to hire private counsel. Would you like the public defender?
I plead the fifth.
Pardon me?
I plead the fifth.
I'm not asking you anything about the facts. I'm asking you if you'd like a lawyer.
Yeah.
All right.
So now I'm really confused. Am I supposed to say not guilty or am I supposed to plead the fifth? I gotta go call my lawyer. Y'all have a good day. I know you all need your daily dose of crazy, so how about some traffic court to get your Monday going right?
You a citation in the first place. But after that, you'll have an opportunity to either ask questions or testify on your own behalf, all right?
Okay.
Trooper, if you want to pick up the narrative somewhere where it makes sense, explain the issuing of this citation. And it seemed like it happened again, so. Oh, Hold on a second.
Complaint
Oh, no, that's
trooper.
a different trooper.
I was dispatched at approximately 11:54 p.m. to a single car crash southbound US 131 near the Kent County line. When I got out there, I made contact with Ms. McKinney and the passenger in her vehicle.
Uh-oh, I don't hear anything.
Yeah, I know. He'll have to go.
Oh, okay.
All right, trooper.
Yes, Your Honor.
Last thing we heard was you made contact with Miss McKinney and the passenger in her vehicle.
Okay, I apologize. After I made contact with Ms. McKinney and the passenger in her vehicle, Ms. McKinney stated
Penny Bear, you gonna sleep through my whole thing?
Trooper Wood, do you have the phone number to call, just call in court on the phone? We're gonna do that with an audio because you're breaking up too much.
I apologize. Yes, Your Honor. Give me just a moment here.
All right, I'm gonna go ahead and release you and just call back on the phone. Trooper Jackson, I'm on the one before yours, but you're in the right place. I'm gonna pop you back over in the waiting room.
All right. Thank you.
All right, Caleb, are you
Hello?
Caleb Harrington?
Yes.
You're in the right place. You're just early. I'm on the ticket that's ahead of you, so I'm gonna pop you back over in the waiting room. I'll bring you back over when it's time.
All right. Sorry.
All right. All right, I have a telephone number here, 0244. What's your name?
It's Trooper Stephen Wood.
All right, so Trooper Wood, you have previously been sworn in, but why don't you just start from the top on this ticket with Miss McKinney here?
Okay. My apologies, Your Honor. Okay. On January 3rd of 2023 at approximately 11:54 p.m., I was dispatched to a single car crash on southbound 131 near the Kent County line. When I arrived on scene, I made contact with Ms. McKinney and the passenger in her vehicle. Ms. McKinney stated that she was driving. She had also stated that she wasn't aware that you could slide on only water, saying that it wasn't icy. However, it had been raining during that evening, and the roads were had water on them. After the vehicle was towed from the scene, we got to a safe location. At that time, due to the statements, she stated she was driving 70 miles an hour. And as I said before, the roads had been wet from rain earlier in the evening. I did issue a citation for driving too fast for the conditions.
All right, and Miss McKinney, what is it you'd like to tell me?
I don't know where to start. First of all, I was scared to death. I don't get into too many accidents. It's not that I said I didn't know that we could not be in water. I said I didn't know it was black ice out here. I
Well,
was not.
ma'am, let me explain something to you before we get too far. Weather conditions and road conditions are not a defense to this ticket.
Okay, got it. Well, I feel like I have a assumed ticket. You're assuming I was going fast on ice in the weather.
Let me pause you again, ma'am. This is not a speeding ticket. You can get this ticket for going 10 miles an hour. Essentially, you get this ticket for your car leaving the roadway. You have an obligation to maintain your vehicle on the roadway. Anytime your car leaves the roadway, this is the ticket you get.
Okay, I didn't leave the roadway though. I was still on the highway. I hit the medium. It was go in the ditch or hit the medium while we were sliding. It was ditch or medium. I took the medium.
Okay, but that's exactly what this ticket is, ma'am. You failed to maintain control of your vehicle to avoid an accident. You left the roadway.
Weather doesn't, I mean, I understand what you're saying about weather. We're in the middle of winter. It's raining now. I couldn't even see outside. It's foggy. I have the weather.
I get this ticket all winter long. And here's what I would ask. Were there other cars successfully traveling up and down 131 without sliding off the road?
Yes.
So the defense to this ticket is you did not slide off the road.
The defense to this ticket is I could not help but to slide off the road. I had no choice. The weather, I was on black ice. That day, it was so bad. He couldn't even talk to us. It was raining so hard. I mean,
I understand, ma'am. But let me just tell you, every winter, there are several days where what you're talking about, these next tickets I have here are for December 25th, which is one of the days where they're going to get a bunch of people this happens to. January 3rd was not one of them. This happened to you, but it mostly didn't happen to everyone else. That's why you have a ticket. But essentially, we can't give the black ice a ticket. You're the driver that left the roadway. You're the driver that gets the ticket.
Well, I have no defense because my defense is bad weather. So if I can't
understand, ma'am.
Bad weather, I know I was
kind
right.
of what I'm explaining to you is there is no defense to say it's not my fault, it's the weather's fault. If you had been driving slower, maybe you wouldn't have slid off the road. Other drivers who drove the same part on 131 did not slide off the road.
Okay, excuse me, but again, how can we maintain that my tires was better than their tires? It was raining. There was probably 2 cars on the highway. It was literally bad out. I'm going to Plainwell. It was terrible out. He asked me how fast I was going. I said probably 65 to 70, if that, because I can't see as bad.
Wait, is she seriously trying to argue that she was going 65, 70 and the conditions were that bad and it's not her fault? For real? For real? For real? Oh, Lord.
Ma'am, the prima facie evidence that you were traveling too fast for the road that day is that you in fact had an accident.
That makes no sense. I'm sorry, Judge. I mean, I guess I have no defense because this is weather related. So if I can't, that's not my defense as weather related and you're just assuming I was speeding, then I guess I have to plead guilty because I have no defense. But
okay, but once again, ma'am, this ticket is not accusing you of speeding. You could have been going 40 miles an hour, but if you slide off the road, then you're going too fast for conditions. You should have been going slower and maybe you wouldn't have slid off the road.
That's that's the judge assuming that, that's the patrol officer assuming that I should have not been going as fast as I was going because of weather related accident.
Exactly,
so,
ma'am.
I have no defense. What you're telling me is on my defense, it does not matter. Because if I slid, if it was bad out, if the weather is weather related, that's not a defense. That's what you're telling me. You're telling me
the driver is held accountable for the weather, ma'am, not the other way around.
Yeah, I'm pleading guilty to a ticket because you guys are assuming I had to be going fast to get in an accident. That makes no sense. So I don't have a defense. I don't.
All right.
That's
Now,
my
because you had a
bad
contested
weather,
hearing,
ice, water. Ask him how bad it was raining. Ask him how we couldn't see. Ask him how I was shaking. He came over. Did you have your seatbelts on? Were you drinking? Were you this? I'm like, give me a breathalyzer. I'm 49 years old. Why wouldn't I take precaution? I'm not a little girl. I'm a 49-year-old woman. This was a freak accident. I'm scared to death. I'm worried about me, and you're handing me a ticket saying, well, you must have been going fast. So you're right. I have no defense. If the defense is not weather related, or you guys are just assuming you had to be going fast, then I have no defense.
all right. Now, ma'am, because you had a contested hearing, you do have a right. You can appeal this ruling within 7 days of today's date. That must be in writing. And then you'll have a formal hearing with the prosecutor's office in front of the district court judges on the same citation. But ma'am, I will explain to you again that road conditions and weather conditions are not a legal defense to this ticket. But we're all set for what we needed to do here. Thank you.
Okay, go ahead.
Thank you, Your Honor.
That I'm just not going to talk about that anymore. Have y'all ever argued a traffic ticket, took it to court? I haven't done that. I haven't got a ticket since I was young because I drive like an old lady. Because, safety and all. Got to be safe. And I live in Florida. If you're not safe, then you die because people don't know how to drive in Florida. It's a proven fact. You should look at the statistics. If you've already argued something in court, tell me the story in the comments. I'm interested. I want to hear it. If you argued your ticket in court, did you change your story from what you said at the time of the ticket? Because apparently that doesn't work.
All right, on the iPhone, what's your name, ma'am?
Rhonda McKinney.
All right, you're in the right place. You're just a bit early, so I'm going to pop you back over in the waiting room.
Okay.
And then you are Mr. Vanderkolk, right?
That is correct.
Okay. All right, this is a citation. It was issued on December 26th of last year, 144th Avenue, Overijssel Township. This is for improper turn as a civil infraction. Mr. Vanderkolk, you're here on this citation to do one of three things. You could admit responsibility to the citation, or two, admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened. Or three, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
Contest it.
All right. Then I'm going to ask you to raise your right hand the same way the deputy is going to raise his right hand. Swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
I do. I do.
All right. Mr. Vanderkolk, it makes a lot more sense for me to start with the officer. He has the burden to establish to me why he issued a citation in the first place. But after that, you'll have an opportunity to either ask questions or testify in your own behalf. And with that being said, Deputy, if you want to pick up the narrative somewhere where it makes sense, explain the issuing of this citation.
Yes, sir. I was dispatched to a property damage accident at 144th and 43rd. Upon my arrival, it appeared that there was a vehicle in the ditch with, I believe it was rear right damage. Upon contact with Mr. Vanderkolk, he admitted responsibility of the crash, causing the crash within the intersection. It sounds like he went past his turn and he went to turn around in the intersection, in which a following vehicle sideswiped his vehicle hauling a trailer. I also noticed on his trailer that the lights on the back end were not active, which did not alert the vehicle behind him of the stop in the intersection. So ultimately, with his admittance and asked for, he stated that it was his responsibility and asked if if I would not cite the victim in the crash.
Okay, Mr. Vanderkolk, what is it you'd like to tell me?
Yeah, so I did think, I wasn't sure if my lights were not working at the time, but you know, after further thinking this through, they could have got dislodged when I got hit. And I feel like if I get hit from the rear, the person behind me should always be in control. And yeah, I was swinging a little bit further, taking a left, but I have the right of way. The person behind me does not have the right of way. I'm a seasoned driver. The 16-year-old behind me should have had his truck under control in the snowy conditions.
Yeah, but here's the problem. I'm not even sure this deputy would have done a thorough investigation of the crash and or talked to the other driver about what did or didn't happen. If what you're saying to him at the scene is, oh, this is my fault, please don't give that other driver a ticket.
I didn't tell him, don't give the other driver a ticket. I said, it sounds like it's my fault because my blinkers were not working. But, you know, realizing how fast they were going behind me and they were out of control.
In your honor, I wouldn't mind. I did think this through after that crash with his admittance to me at the time. When it comes to a PDA, it doesn't make sense for me to cite both drivers in regards to insurance purposes. So I just found an at-fault driver with the improper turn within the intersection.
Okay. And you know, that's the other problem is, in other words, you don't have a ticket. You're right in that what you're cited for is the improper turn. So that's what I need you to tell me you didn't do. The other driver crashing into you is not why you have a ticket.
I have the right to take a left turn. That's where I don't get this. I get it if you would have ticketed me for, okay, my lights weren't working.
Sure, but you have to make a proper left turn.
What I am making a proper left turn. How would I not be making a proper left turn? I was turning left and then swinging on the other road to turn around. I wasn't going to turn around.
Yeah, that means you're using the improper lane to turn.
No, I was in the right lane making a left turn on another road. I was never in an improper lane. I mean,
no,
okay,
but here's what I've said. You that you sort of missed a turn and you were turning around in the intersection is what I was told. So you tell me what you did.
I didn't miss this turn. I was purposely turning here. I was swinging a little bit more to the right to take a left, but I have every right to take a left turn.
Yeah, but what I'm saying is, did you swing out of your lane to make a wide turn?
No. I mean, how would I swing out of my lane? The guy hit me. He was past me on the left.
All right.
He clipped my plow on the left side. I was just swinging and he.
Do you have a trailer on the back and a plow on the front?
That is correct.
Okay, which is a lousy idea, right? You should have one or the other, but not both.
Maybe, but.
All right. So you're driving down what road?
Is it 144th that goes north and south?
All right. So it's two lanes.
And he's following me.
Yeah.
And
you're coming up to this intersection and you want to make a what turn?
I'm taking a left.
All right. So you're driving north or south?
I'm driving south.
Oh, okay. And you want to make a left turn?
Correct.
And then what happens? So as you approach that intersection, what happens?
As I'm taking a left, I'm taking a left. I can see in my rear mirror this guy coming alongside me, trying to slow down, puts his blinker on left to try to do a quick left to avoid hitting me. And just clips,
He's coming up on your left or on your right?
he's coming up on my left. Because he's
So
going,
he was trying to pass you.
he was going too fast behind me. He couldn't slow down. The roads were slippery. Yes, he was
Okay.
past me.
Let's start all over again, Deputy.
Yes, sir.
Because you said something different, that he said something about was going to miss his turn or making a wide turn. But tell me again, when you came up onto this accident, you talked to defendant. What did defendant say?
From my understanding, 43rd would be the street that goes north to south, and 144th would be east to west. So from what I understood at the time is there was a misturn, and he was attempting to make a turn. I'm getting a little confused here with this now, because I'm trying to go back on the scene of the crash. So from what I remember being told is there was a admittance to making a turn within the intersection after missing a turn. And then he clipped the side of his vehicle in an attempt to avoid the vehicle. That was the victim in the crash. This is me going off of a statement. I obviously didn't see the crash.
But see, that's the problem is Mr. Vanderkolk is trying to have his cake and eat it too. So in other words, you explained what happened at the crash and said, oh, it's my fault, give me the ticket. So the deputy does probably less than thorough investigation or objective view of this crash, because the mystery is already solved. Mr. Vanderkolk admitted, oh, this is my fault. Then you want to come to court and say, I didn't do anything wrong. And the deputy is supposed to provide the evidence that you did.
Okay, but I was expecting, hey, a ticket for, hey, my lights weren't working, not an improper turn. I had the right of way to make the turn.
Yes, but what is this about? You missed the turn.
I didn't miss the turn. I was making the turn purposely, going left. I didn't miss any turn. How did he hit you on the right passenger side? How did he hit you on the rear passenger side?
That would have been the victim's damage.
He hit me in the plow with his rear right, not even his rear, his right side door.
All right, let's stop. Because that doesn't make any sense. What part of your car got in an accident?
My plow on the driver's side.
All right. So that would be the front driver's side of your car got in an accident with what part of his car?
The passenger.
Don't say his rear.
His passenger door. He had a
okay, that's you turning into him.
That's him passing me as I'm turning.
Yeah, but here's what I'm saying. Look where the damage is. All right, the side of his passenger, the passenger side of his car, somewhere in the middle of the car, and the front driver side of your vehicle.
Yeah, he was passing me on the left as I'm turning.
All right. So I would find you responsible for this citation as issued based upon what I've heard here today. But because you had a contested hearing, you do have a right. I'm assuming there was a UD-10 here.
Yes.
You do have a right to say, I don't agree with what just happened there. I want to take this to formal hearing. You must ask for that in writing within 7 days of today's date. That'll involve the prosecutor's office, and they'll subpoena the other driver if you want a second bite at this apple. But what's being explained to me here, I would find you responsible at an informal hearing for this as an improper term. All right.
Okay.
So you're all set for what we needed to do here today. I'm going to release you.
Thank you.
A couple of y'all might have seen this one before. I think I threw it in a live, but I had to take a live down because there was like half a second of some music that YouTube said I copyrighted from some. Yeah, I'm learning the rules. I'm working on it. I'm trying to follow the rules. I like to follow rules, unlike some people. Yeah, this guy likes to follow rules too, even when they're going to screw up his chances of getting a job and he has the chance to do something completely different. Oh.
All right, Ms. Morales, we'll start with you. This is file 221421ST. I'm going to read it to you so you understand what it is you're charged with. This says that on or about May 20th of last year on 58th Street in Manlius Township, Allegan County, State of Michigan, that you were driving while your license was either suspended or revoked. That is a misdemeanor, is punishable by up to 93 days in jail and or $500 fines and costs. Do you understand the charge?
Yes, sir.
And do you wish to plead guilty or not guilty at this time?
Guilty.
All right. I will tell you this real quick. You can't plead guilty right now in front of me, but I can't make plea deals with you. So if you plead guilty in front of me, you have to plead guilty as charged. If what you were looking to do was to talk with a prosecutor and maybe work out a plea deal to a lesser charge or explain your situation, that's possible, but not today. That would be possible at a next court date if you pled not guilty today. So I'll just ask you once again, do you want to just continue to plead guilty or you want to take your chances with the prosecutor?
Take my chances with the prosecutor, sir.
All right. Now, if this were to go all the way to trial, would you want that trial to be in front of a jury or in front of a judge?
Judge.
All right. And you would continue to represent yourself for free, or you could always hire an attorney. I'm going to give you what's called a $300 PR bond, which means you don't have to pay any money. We're essentially just trusting you that you'll keep showing up for court, but that is no driving without a valid driver's license. You understand and agree to that?
Yes, sir.
And is this a good address for you on 105th Avenue in Pullman?
Yes, sir.
Then you are all set. You will get a next court date for courtroom A in front of Judge Scotchless. That'll get sent out to you in the mail. That'll be the next time that you're doing court and the first time you get to talk to someone from the prosecutor's office, hopefully resolve your issues. But you are all set today. You can go ahead and go.
Okay, thank you.
Mr. Taylor, you able to hear me?
Yes, can you hear me?
Yes. This says that on December 11th of last year on Blue Star Highway there in the city of Douglas, that you were carrying firearm under the influence of alcohol. That is a misdemeanor, punishable by up to 93 days in jail and or $300 fines and costs. Do you understand the charge?
Yes.
And do you wish to enter a plea of guilty or not guilty to that charge at this time?
Guilty.
All right, so you don't want to talk to a prosecutor, you just want to plead guilty for fines and costs right now?
It was just a mistake of mine, and I don't have even an outstanding parking ticket or speeding ticket for the last 20 years.
Okay, and so anybody force you or threaten you to make you plead guilty to this?
No.
And are you pleading guilty to this because you believe you are guilty?
Yes.
And were you carrying on your person a firearm back on that date in December of last year?
No, it was not on my person.
Oh,
I keep it in my car and
vicinity in a
usually leave it
vehicle?
at home.
And had
It was
you,
in the vicinity of the vehicle.
okay, and had you been drinking alcohol on that date?
Not on that day, it was the night before.
Okay, but you had alcohol or consumed alcohol to the point where it would have been noticeable to.
Well, I just wanted to drive, and you could probably, I didn't brush my teeth, and you could smell it on my breath.
All right. So I do find that's a factual basis to accept your plea. Your plea is knowing and voluntary. It will just be fines and costs. What we mean by that is it's a $90 fine. The statutory costs are $100. There's a $75 crime victims' rights fee, a $50 state cost, and a $10 conservation fee.
I have one
Is a
question.
total of $325.
Okay. I just have one question, really quickly. I'm actually applying for, I'm unemployed. I'm not a problem with the money right now, but I'm applying for jobs and they do background checks. And unfortunately, this is probably gonna come up like a rash. Is there any way I can keep this off my record if I pay more fines or probation or?
Well, no, but
know-
you could plead not guilty, and then that would mean you don't have a conviction. You need to press that or it's gonna go away. That means you, in other words, usually when they are talking to a job interview, I'm not trying to give you legal advice, but the question should be, do you have any convictions? You'll have a conviction after today. Now, if you want to unwind this and plead not guilty, you would not have a conviction for the next couple of weeks or months while this is, making its way through the system. You could always plead guilty on a later date, but then, any job interview or job application you had right now, you don't have a conviction. It's up to you.
Yeah, I'm still gonna plead guilty because even if I, draw this out, I was wrong. There was alcohol smell on my breath. I did have the firearm next to me, which I keep for protection because I live around Chicago. I'm gonna have my conceal and carry and all that. As I said, I usually leave it at home when we go on vacation, but I just totally forgot about it.
Well, you have 90 days to pay that. If you need more time than that, that's fine, but you need to contact the court and get put on what's called a payment.
Okay. All right.
But you're all set for today. Thank you.
Okay. Thank you.
I just want to shake him and be like, they're telling you to talk to him for a reason. Like, there's things that can be done. We can negotiate this. Penny, come here. Dogs. Get a dog, they said. It'll be your best friend. Right. I forgot what I was saying. All right. So this guy decided to argue his ticket, and I think he might have a soft-sit friend, but I'm not quite sure because it's either that or he tried to read the statutes and couldn't quite interpret them properly. Either way, I think it's freaking hysterical.
Please.
Good afternoon, Your Honor.
Good afternoon.
Your Honor, on October 11th, 2022, approximately 8 p.m., I was on duty in a full uniform in a fully marked CHP patrol vehicle, vehicle 1448376. I'm patrolling on State Route 113 in the County of Yolo. There are clearly marked black and white signs, regulatory signs posted along SR 113 stating maximum speed of 65 miles an hour. On the date in question, I was using Stalker Dual Radar Unit DS039232. I checked the calibration at the beginning ends of my shift, and the radar unit was found to be functioning properly during all checks. The last IACP check on this radar unit was performed by San Diego State University on 12/1/21. I have 24 hours of radar operator training and 30 hours of visual estimation of speed to plus or minus 5 miles an hour. On this date, I was stopped on the shoulder of southbound 113, SR 113, south of County Road 27. When I observed the subject vehicle, a white Tesla traveling at a high rate of speed coming from the rear of my patrol vehicle. This vehicle is traveling in the number 1 lane. I visually estimated the vehicle to be traveling in excess of 100 miles an hour in the 65 mile an hour zone. I activated my rear radar antenna in the closing mode. The radar unit indicated a target speed of 103 miles per hour with a solid Doppler tone. I then accelerated my patrol vehicle and positioned myself behind the subject vehicle and made an enforcement stop. I contacted the driver to explain the reason for the stop, speeding at 103 miles an hour in the 65 zone. I asked to see his driver's license, registration, and proof of insurance, which he provided. He was identified by his valid California driver's license as Meng Kuan Yu. I issued Mr. Yu CHP 215 notice to appear for violating California Vehicle Code section 22348, B as in boy. Mr. Yu signed the ticket and was released from the stop without incident.
Thank you, Officer Hernandez. Mr. Yu, do you have any questions for Officer Hernandez about his testimony?
I want to plead not guilty.
You already pled not guilty. This is the trial.
Okay. I actually have a statement of the facts. Can I read this?
Yes, go ahead.
Okay, so the facts of my case are as follows. While driving on the freeway on October 11, 2002, I was stopped by the officer and was charged with violation CVC 22349A. The officer asked that I was driving 103 mph in a 65 mph zone based on radar evidence. I signed the ticket when the officer asked me to do so. However, I know that I was traveling a safe and reasonable speed for the condition at the time of my stop, and was therefore not in violation of the basic speed law. This basic speed law CVC 22350 states, no person shall drive a vehicle upon highway at a speed greater than is reasonable or prudent, having due regard for weather, visibility, the traffic on and the surface and width of the highway, and in no event at a speed which endangers the safety of person or property. The officer did not know that the road was dry and clear. When I was stopped, this freeway is a well-maintained 4-lane freeway, quite safe to travel on at approximately 75 to 100 mph with a favorable weather and road conditions. Section B of the speed law violation CVC 22351B states, the speed of any vehicle upon highway is excesses of the prima facie speed limit, or established as authorized in this code is prima facie unlawful unless the defendant established by competent evidence that that the speed in excess of state limits did not constitute a violation of the basic speed law at the time, place and under the condition that existed. The conditions existing at the time and place of my stop was favorable and made the speed I was traveling safe and reasonable under these conditions. As such, I know that I was not in violation of the basic speed law at the time and place of my citation, and pursuant to CVC 22351B, I contest that my speed and time of my traffic stop was therefore not prima facie unlawful. Further, the traffic was heavy. The traffic was moving at an average speed of 90 mph. In fact, I tried to obey the post maximum of 65 mph at first, even though the other vehicle was going 30 to 35 mph faster. Due to the heavy, fast-moving traffic, I was constantly being tailgated and was almost rear-ended by several cars. Motorists honked their horns at me. My attempt to obey the letter of the law by maintaining a speed of 65 mph was causing a hazardous situation of myself and others. CVC 22400, the minimum speed law, requires that no person shall drive upon highway at such a slow speed as to impede or block the normal and reasonable movement of traffic. By driving at 65 mph, I was certainly impeding the normal flow of traffic. 103 mph at the time of my stop. In this situation, it was safer to obey the minimum speed law by matching my speed to the traffic flow than to follow the maximum speed law and cause a hazard by driving at 65 mph or slower. As a result, I trust in the court's fairness and believe that my citation should be dismissed in the interest of justice. I declare under penalty of perjury under the law of the state of California that foregoing is true and correct.
Thank you, Mr. Yu.
Thank you.
Anything further, Officer Hernandez?
Just the nature of his speed is dangerous and unsafe. Just that he realizes that doesn't have to, it also includes yourself as that you could put yourself in danger by going those speeds, not just other people.
Okay.
All right, well, thank you both. Based upon the officer's testimony and your own admission, I do find you guilty of violating Vehicle Code Section 22358B, going 103 and a 65, where the posted maximum speed limit is 65. So that's what the state has determined is a safe speed. And 103 way over, it goes way over that. So the fine and fee is going to be $1,155, and it will be due by April 4th. Thank you, officer. Thank you, Mr. Yu.
And that, my friends, is your traffic for the day. I hope you enjoyed it. Please take a moment, like, subscribe, and do all that YouTube-y stuff and make my life better, because Mama's got to pay those bills. Love you all. Thanks for everything. See you soon. Hey, everyone. Penny and I wanted to wish you a happy Valentine's Day. I hope everyone has had a wonderful day so far and is getting lots of love and candy and lots of chocolate. Lots and lots of chocolate. And no kisses. No kisses. We don't need kisses for Valentine's Day. I was having a good day today, which has been kind of rare lately. And I thought, okay, I can either do laundry or I can jump on here and hang out with you guys for a while. So Mike was on and had a very interesting case. And then I had a whole bunch of them stockpiled that I thought, well, let's just do them live instead of waiting for, me to edit a video. So the first one I have is a fun little Karen video. She is trying to get, I think, a conviction removed from her record. And apparently no one told her how to dress for court.
There you go. Yeah.
All right, so you filed a petition for an application to have this conviction set aside for breaking and entering with intent. And would you raise your right hand, please? Do you solemnly swear, oath, or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you're asking this court to set aside a felony conviction for breaking and entering, is that correct?
Yes, sir.
The date of your conviction was October 23rd, 2006, is that correct?
Yes, sir.
And that you're only asking the court to set aside this one felony conviction, is that right?
Yes, sir.
Is it true that at least 5 years had passed since the sentence was imposed, or you were discharged from imprisonment, or discharged from probation or parole for the conviction?
Yes, sir.
Have you been convicted of any offense since then?
No, sir.
Have you filed a previous application to set aside this conviction?
Yes, sir.
You've tried to get this set aside before?
No, sir.
Okay. And you've got another application pending on a unlawful use of a license plate, is that correct?
No, that was already taken care of and cleared.
That was granted?
Yes, sir.
Have you been convicted of more than 3 felonies?
No, sir.
Have you had any assaultive crimes set aside during your lifetime?
No, sir.
You currently have pending criminal charges?
No, sir.
Okay, those of you just joining us, she is just trying to get a prior conviction overturned. That's all it is. She's petitioned the court. I think overturned the right terminology. I'm not completely sure, but she wants it cleared from a record. This and one other one. So she's just kind of going back and forth with the judge. It's a little slow at first, but I promise she gets a little Karen.
Did you give the prosecuting attorney and the attorney general an opportunity to respond to this by sending them a copy of your petition?
Yes, sir.
Now is your opportunity to tell me how your circumstances between the date of this conviction and today would warrant setting aside this conviction, and why it would be consistent with the public welfare for you to have this conviction set aside.
Well, sir, I have a child who has autism. And I'm just trying to set good examples for him. And I haven't been in trouble at all since any of this had happened. And honestly, I shouldn't have gotten in trouble, but because I was with the people who actually did it and they got off, the judge had said because I was in college and, you know, being on the right path, that I should have known better to hang out with them. Even though I didn't do the crime, it's because I was hanging out with them and he wanted to make me an example. So in all honesty, I shouldn't have even got in trouble for this, but it is what it is. And I'm just trying to get it cleared off. I'm a really good person. I help my neighbors, you know, my little boy and I, we go clean up our neighborhood. I volunteer. Honestly, I'm a really good person and I don't want that on my record because that's not who I am and I shouldn't have to represent that way, you know?
Are you working?
I can't work, Your Honor. I'm disabled.
What's the nature of your disability?
Seizures.
Any questions, Mr. Stay?
What do you recall being what your involvement was in this, Ms. Jordan?
I wasn't involved. That was the thing, is because I was hanging out with them. I was in the car. They had said that they knew the people and stuff and that they were supposed to pick some stuff up, you know, so I didn't think of anything. And because I was in the vehicle, I got in trouble.
Do you recall turning in some returnable bottles that you got from that residence?
No, not me. That could have been my sister, Shannon.
I'm just reading what you told the police when they interviewed you about this in 2006. Basically, you went over to this abandoned trailer, stole some stuff with other people. You took some of the bottles, they took some of the stolen property. Does that sound like what happened?
Oh, God, this is so long ago. I don't think so. But if that's what's written down, then I guess so.
I don't have any other questions, Your Honor.
Your Honor, I'm Mr. Robinson when she stole stuff from. She's the only one who never paid restitution.
So the victim in this case is indicating that that you never paid restitution.
What? Your Honor, it took 10 years or so for me to pay it. I'm the one who paid it all off. It took like a good, I want to say about 7 years to 10 years to pay it off, because only being on Social Security. And Sarah Gaines, she was also supposed to be paying, but I'm the one who kept making my payments and I paid that all off. For the both of us got paid off.
How much did you pay?
It was pretty much up to $20 to $50 each time because of being on SSI.
Court should have records of whether that payment's been made or not.
Sarah Gaines was the only one that paid.
No. Okay, so what happens when I make my payments is that it's under Sarah Gaines.
All right. Anything else that you want me to consider, Ms. Jordan?
No, sir, I don't do anything except for take care of my kid. I don't have, this is the only thing I've ever been convicted of or even done, considered done. I keep to myself. I take care of my little boy.
Mr. Stay?
Your Honor, I would, I didn't know Mr. Robinson was here. I would ask if he wishes to make a statement that he make one to the court. Would you like to speak, sir?
I would actually.
Go ahead. Why don't you come up here, speak loudly so she can hear you as well.
Judge Thomas, who was the one that was deciding this case, great guy. I will tell you that he never made any of those comments to her that she should have never been convicted. Her and two other young ladies decided to break into our premises while we were in Florida. Stole quite a bit of stuff from our residence because we were remodeling our house in town. We brought everything out to the farm. So they all decided to go out there while we were gone. And they took all my kids' toys. They took brand new saddles. There was right around $10,000 to $12,000 that we had that was taken by these individuals. When the police were coming in on them, they took them out to 2-track and burned it. So the state police came back with a box about this big with burnt items in it. The only person who ever paid anything was Sarah Gaines. And I'll tell you what, she would be the only one to ever say that needs to be deleted from her record. They were like a Bonnie and Clyde type of group where they were doing quite a bit of crime. So I have a real issue with this whole situation.
Your Honor, if I may, I swear to God,
Hang on. Go ahead, Mr.
As a citizen and a taxpayer, we never were fully made whole again.
sir, those payments need to be investigated because I'm the one that paid it off, not her. My payments are under her because it's the same case. I'm the only one that made the payments, not her. She would do maybe $10 or $5 here and there, but it was mainly me.
All right, thank you. Mr. Stady, you take a position on this application?
I guess at this point, Your Honor, I would oppose it. And generally, you need some sort of culpability. She doesn't think she's guilty of this crime. And I'm not here to relitigate that, but I would oppose the application.
Look, I did my time. I did the payments. I did what I was supposed to do, and I have never been in trouble ever since.
Well, I think Mr. Stay's objection is that you said that basically you pled guilty to something or no contest to something that you didn't do, that you weren't involved, and he has information to the contrary. And sometimes, like, to show that someone has changed their ways, that begins with acknowledgement that they did something wrong in the first place. And it doesn't sound like you're even willing to give that acknowledgement.
Look, the thing that I'm guilty about is I should probably reported it. Yes. But I did not steal that stuff and go burn stuff up. That was my sister. That was Shannon Jordan. That was Sarah Gaines. My sister's boyfriend at the time, Jason, I can't remember his last name. But they're the ones that did all that crime. I'm guilty of not reporting it. But on my side is because I didn't know that it was stolen. They told me that they were going to this house to pick up some stuff. Sarah Gaines said that she knew the person and that she got permission from them. If I would have known, I would never even hung out with them. I don't hang out with them. They're not people that are people I would have hung out with normally, you know. But because it's my sister, you know, I didn't think anything of it. I should have, because she was hanging out with Sarah Gaines, but I didn't. Because I never thought she'd put me in a position like this.
Judge, I did look in Sarah Gaines's, and it does look like Chandra paid most of those fines.
Thank you. I mean, I'm really sorry that this had happened to him. If I had more acknowledgement of what was going on, I definitely would have reported it. But because of what they had told me and informed me while we were there, I didn't think nothing of it. I didn't think they would put me in this position. But, you know, I paid, I did my time.
The court is going to deny your application to set aside the conviction.
Oh my God, why?
Well, it's not because you didn't pay. Our records show that you did pay a restitution. We had to issue warrants for you. It took a number of years. It wasn't anything that you voluntarily paid. But at this point, the court is convinced that by you, ma'am.
Your Honor, I never had any warrant.
Stop talking.
Oh, I thought you were wanting me to talk.
I'm issuing my ruling.
Oh, I apologize.
You did pay restitution. It took a while. We had to issue warrants for you to do that. Eventually, it got paid. But you have not indicated that you've had a change of heart or a change of attitude towards this. You're maintaining that you were just an unwitting victim in this case, that you didn't steal, that you didn't do the things that they were said. And based upon that, I don't think that setting aside this conviction is consistent with the public welfare, so your application is denied.
Sir, may I please say something?
No, that's all for today.
Sir.
Oh, where's it at? Oh, this one. Sorry, I couldn't find it. Okay, I was looking it up, trying to figure out how to enable gift memberships. I thought I remembered. You have to click on the name of the channel, and then there's somewhere in there, there's like maybe you go to community. Does anybody know? There's an option somewhere, and I can't find it. Come on, one of y'all know how to do it. There's somewhere in there that you can do it. You have to click on the channel, and somewhere in there, there's an option that says enable gift memberships. It's Valentine's Day, and somebody might drop some gift memberships for you because they love you guys so much. So figure out how to do that real quick while we watch I definitely know how to do it from Apple because I've done it before. I did it on Mike's channel because I only used to use Apple. So I will figure that out real quick while you watch the 2-minute presentation of the Law Talk with Mike, Big and Two, and Viva Las Vegas with Ben Bateman, Know Me Reveal. For those of you who don't know, we had a little crafting stream last week, and this is the results. Do you know what happens when the fabulous Big and Two, the adorable Law Talk with Mike, and the witty Viva Las Vegas with Ben Bateman provide some inspiration to the Crime and craft room? You get some adorable little gnomies. All in, baby. Sovereign Citizen Patrol. And Mr. Georgia Woodsman. Oh, this isn't The Hangover Part 4, man. Despite the delay, the gnomies are done, and I would like to thank the boys for providing their inspiration for our fabulous little gnomes. And thank you all for joining us on our crafting adventure. It was fun. Oh crap, I didn't figure it out yet. But I definitely know that you can do it. Okay, this next guy is this one's out of Texas, I believe. He has some interesting charges. I had to look this one up. So he is going before them because he's supposed to have a lawyer. And just to give you an idea, because they don't talk about it, his charges are, I should make you guys guess, but distribute opiate, opium, narcotic stimulant / heroin dosage 10 to less than 100 units, possession of anabolic steroids, taxation, drugs, no drug tax stamp for marijuana or controlled substance, driving while license suspended, first conviction, and attempted possession of opiate, opium, narcotic, or other stimulant. And then it was amended in some way to change that to include fentanyl as it relates to the tax stamp charge, which was really interesting. I had never seen anything like that before. But he had all of his money seized by the government. And so now he needs a lawyer, and they want him to hire a lawyer. Well, lawyers require payments. How do you get paid if they took all your money?
We'll resume the docket at this time with State of Kansas versus Jeremy Michael Potter. Case number 2023 CR 35. Again, Brett Sweeney appears for the state. Mr. Potter appears apparently without a lawyer. The court's docket notes indicate that he came before Judge Hart on January 20th. That time, the judge determined that the defendant did not qualify for a court-appointed attorney. So it would have been expected that you have an attorney that you hired on board with you today, Mr. Potter.
Yes, Your Honor. I've been trying to get one. I don't have any money right now. I had actually cashed out my retirement through Capers, and they had seized that money. And I have all the documentation showing that that money was from my retirement. So if I could get that money back somehow, I would be able to retain an attorney. But otherwise, none of them will take payments that I've contacted. And they're all wanting at least $5,000 up front, and I just don't have that kind of money, put back. And I can show proof and, my bank statements and all that, I'm actually kind of hurting for money right now, trying to dig myself out of a hole. So.
All right. Well, what kind of job do you have, Mr. Potter?
I work for Spirit as a crane operator.
Pretty good paying job there, Mr. Potter.
Yeah, it is.
So if I were to reset this for an evidentiary hearing in April, you'd have an attorney on board before then?
I'll do my best. Yes, Your Honor. I should be able to, I would hope locate one. I know one was willing to work with me. He said he would take payments, but he wanted at least $3,000 put down to start. And then he said he would work out payment arrangements as we go, just depending on everything that was to come, I guess. But so he was the best one that I could find so far.
So are you going to be able to get this retirement money and get that paid?
How do I know, I'm sorry, I don't mean to ask you. I don't know how I go about that. Somebody told me that I was able to submit I can't remember what it was called now.
A hardship request of some kind?
I think so, something like that. And then I just show them the proof that it was legal money.
Your Honor, I think he's talking about money that was seized as evidence with some evidentiary value in this case.
I see.
I was actually in the process of going to buy a car, and I've got printouts. My mom had actually went through on her phone, and my dad had went through and printed out all the messages and stuff I'd sent him about looking at cars, and I'd pulled out the money to go buy a car because my car's broke down. I've been staying at a friend's house in Wichita so I can get to and from work, and he's been giving me a ride in his truck. So
Okay, well, you can't count on that money being released to you with this case pending at this stage, Mr. Potter. In light of that seizure, the court's inclined to appoint counsel for Mr. Potter. James Watts will be appointed.
Sorry, my phone lost service there for a minute. Are you still there?
And an attorney named James Watts has been appointed to represent you, Mr. Potter. You can replace him with your own lawyer at
Okay.
any point if you want to. But he's going to be court appointed to represent you. I'm going to set this matter for evidentiary hearing at 3:00 p.m. on Thursday, April the 6th.
Okay.
It's several months away. It gives you plenty of time to deal with Mr. Watts and for him to contact the county attorney's office if indeed there's some reason that evidentiary hearing isn't needed. So, Mr. Potter, you've got the responsibility to fully participate by Zoom Thursday, April 6th at 3:00. Mr. Watts generally likes to have his clients in his office with him. I'm sure he'll talk to you about that. I highly encourage that as your Zoom location, so we don't have connection issues. Thursday, April 6th, 3:00 p.m. for evidentiary hearing. Anything further on him, Mr. Sweeney?
No, Your Honor.
Any questions, Mr. Potter?
No, Your Honor.
All right, then your matter's in recess and you're free to leave the meeting.
Thank you.
All right. So I did look that one up a little bit, and crane operators make anywhere from, I mean, just because, you know, we got to know. The average is $30 an hour, but it goes as high as $45.10. And I can't remember what the math was. It's about $93,808 a year. So yeah, but he got a court-appointed lawyer, so he's good. That's good. Yeah. Okay. Since it's Valentine's Day, let's watch some child custody drama. Because, you know, what else do you do on Valentine's Day? Definitely not anything fun and romantic.
All right. Okay. Thank you for your patience, everyone.
So I represent the respondent, Marissa Scrivener. This is actually my client's motion before the court.
All right. I have only just, Odyssey has been acting weird here. I believe I've reviewed everything in the file. So.
Okay, and you do have my proposed orders?
I do.
Okay, great. So on behalf of the respondent, may it please the court, I do represent Marissa Scrivener. This is a midterm marriage. These folks have been married for a little over 5 years, and they have one child born as issue of their marriage, Renier, who is 3 years old, also known as Ren. The parties did separate approximately 9 months ago, and originally my client had agreed to a joint custody parenting plan. The expectation was that that would be in Ren's best interest. And as you see from my client's declaration, upon these party separation, they moved in with her parents. So she's been relying upon her parents for financial assistance. As it relates to this alternating visitation schedule that they have been exercising, my client tells you that it has been really difficult on Ren. He has been very confused by the process. He has been upset about exchange times. And the way that, even looking at Mr. Scrivener's proposed parenting plan, I've been doing this for a long time. I had a hard time making heads or tails of what the visitation schedule was. But it's clear that it's got this little child who needs to have the comfort of his primary parent, it's got him basically living out of a suitcase. So our concern at this juncture is, first off, looking at the statute. One of the factors of the statute is, has one of the parents assumed a majority of the parenting functions? And that's a main factor that the court's supposed to take into consideration. It is undisputed that during the marriage, Mr. Scrivener has been the primary breadwinner for this family, which meant that he was at work. My client tells you about his travel time before work and after work. My client tells you about the fact that historically she's been the one either at home until fairly recently obtaining essentially part-time employment. During the parties' marriage when they were together, she was working at most 2 days a week as a florist for the House of Roses, where she continues to be employed. And that was because these parties didn't have sufficient income or didn't want to commit income for daycare when the mother was available to provide that care. And that meant they didn't have to incur that additional expense. So right from the get-go, we have that mom has been the primary parent. You also have this discussion about the transitions as far as housing. They went from an apartment to his folks' basement to her folks' place. He gets a job up north. He stays up there for a protracted period of time while my client is down here with the child. And so he's basically gone and absent during the week while he's up at work, as well as sometimes during the weekends. So again, these transitions for Ren have been difficult, and hindsight, as we know, can often be 20/20. But we have the ability to provide some more stability for this child by placing him primarily with his mother. Within Mr. Scrivener's reply documentation, he attempts to bring up a number of issues of fault. He argues about suggestions that my client has mental health issues, suggestions that my client has been abusing substances, suggestions that she stopped medication against medical advice. All of these concerns, and suggestions that she wasn't managing the finances. When you actually peel back the onion and look at the factual documentation, you see that Ms. Scrivener provides responses to each one of those allegations and provides supporting documentation for some of those allegations. First off, in regards to the finances, Mr. Scrivener claims that my client was the one that wasn't handling the finances appropriately, and that basically made things precarious for them as it relates to housing, having to rely on family and the like. And yet look at the text messages. It's Mr. Scrivener who's been the one to handle the finances, who's been the one to express frustration because he's missed payments, who my client has had to turn to ask for financial, or to ask for money to be transferred to her so she could pay bills. And again, she's doing the right thing. We're here not because of that type of fault. His allegations about substance use. My client did use marijuana up until about 2021. Mr. Scrivener has continued to use marijuana, and you can see from the documentation that we provided that even he acknowledges that he needs to stop so he can provide clean UAs. And there's information out from his own text messages that acknowledges that he was denied an employment opportunity because he was unable to pass a urinalysis. Again, the court should provide absolutely no weight to those allegations. He then goes on to argue that my client has mental health issues. My client goes through and discusses with you the miscarriages that she endured, the symptoms that she was experiencing after the birth of Ren, her actions of engaging not only with her doctor, but with a counselor, following those recommendations, taking her medication as prescribed, weaning off of the medication as prescribed and when recommended by the joint recommendations of both her counselor and her physician. And she did all of those things appropriately. And she continues to be in counseling. As she tells you, she's trying to fathom through this whole process, which in and of itself can, as the court is well aware, throw individuals through the trauma akin to losing a close family relative to death. So she's doing the appropriate things. And she wants to make sure that she continues to be the full-time and appropriate parent for her child. So the arguments that Mr. Scrivener raises, I think the court should provide little to no weight to those, particularly when it comes to the parenting concerns. My client provides you photographic evidence and text messages of their communications regarding the conditions presented in Mr. Scrivener's house, particularly continuing to expose Ren to allergens and the negative impact that that has upon him. Ren is allergic to dust and pet dander. Ren is not only allergic, but he also suffers from asthma. It is shockingly concerning that when you have a child who not only has allergies, but has asthma, that you continue to expose a child to a known allergen. And clearly, this child is reacting negatively because he's coming home to my client with active flea bites, with active hives, and it is extremely concerning. He had a bout of impetigo. What's most concerning is that Mr. Scrivener fails at times to transport Ren's medication with him. If there's anything that is more concerning, is to have a child with asthma who has an asthma attack and you don't have his rescue inhaler. Asthma kills. Asthma kills children. Asthma kills adults. And that is no game to forget that your child needs to have his rescue inhaler. Mr. Scrivener again attempts to suggest that my client was inappropriate in not caring for Ren's either impetigo or the flea bites with antibiotic ointment and Band-Aids. The child's allergic to the substance that makes the Band-Aids, to the adhesive on the Band-Aids. My client's allergic to the adhesive on Band-Aids. And again, you can see the text message where he acknowledges, oh, he must have the same allergy that you do as it relates to a Band-Aid adhesive. But let's go ahead and throw it in a declaration to make this mother look inappropriate and to see what sticks on the wall. That's not in this child's best interest. Just as his decision to run ahead with his relationship, and that's fine for adults, and my client tells you she doesn't care that he's involved in another relationship. What she cares about is that this whole process already has been extremely confusing for Ren, compiled with this demanded visitation plan by Mr. Scrivener. And then to add into that is a whole new relationship, and that these are going to be your brothers, and that's just too much for a 3-year-old. Parents need to ratchet it back when we're going through this process so that the child, on the child's timeline and that the child's ability can understand what's going on. But regardless of my client's expressed concerns, and regardless of Mr. Scrivener's promises, verbal promises to my client that he wasn't going to do that to the child, he in fact is doing that behind my client's back. And this again has been concerning for the child or confusing for the child. And so he has questions and the like. And when you have a parent who's lying to another parent, it makes it really difficult to provide accurate information to a child or to help them through that process. So it's very concerning as far as these allegations. I believe that we've provided as best as we could on the short timeframes that we have for these hearings to produce valid documentation and information that thwarts his information. We are asking for the court to adopt our proposed parenting plan and provide some consistency for this 3-year-old child. We're asking that he be placed primarily with his primary parent, Mrs. Scrivener. We're asking that visitation be provided to Mr. Scrivener on 1st, 3rd, and 5th weekends from Friday at 6 to Sunday at 6, and every Wednesday from after work to 8 p.m. The proposed parenting plan also provides for holidays and I believe summertime. Let me just confirm that. Yes, and a summer schedule, so it provides for that. One thing that I think that I forgot to put in the temporary order, however, was this issue in regards to medications. And it's just unfortunate, but I think we need to have language added to the proposed temporary order that provides that the child's medication shall be transported at all times with the child in the medication bottles. I don't want people to start getting into a situation where they're transporting medication outside of the prescribed packaging. Moving on to finances. Obviously, as I outlined at the commencement of my argument, Mr. Scrivener has always been the primary breadwinner for this family. He continues to have superior earnings compared to Ms. Scrivener. And my feeling is that probably a lot of what's driving this parenting plan issue is the fact that it would mean potentially an argument for a reduction in child support. He acknowledges that his mom watches Ren while he is at work. And again, my client works at most 32 hours a week and has more availability for the child. Currently, Mr. Scrivener's net income is $4,730 per month. Ms. Scrivener's net income is $1,852 per month. I note that Mr. Scrivener's proposed orders impute my client's minimum wage at 40 hours a week. She does not work 40 hours a week. She works 32 hours max at most between 2 different employments. And we do not believe it's appropriate to arbitrarily inflate her income. My client's need, according to her financial declaration, is $2,569 per month. And we are asking the court to order a spousal maintenance transfer payment of $750 per month and a child support transfer payment of $788.02 per month commencing January 1. Each party should pay their proportionate share of, work-related daycare. If there is work-related daycare, they've been, I can't remember the name of the agency that they have had some daycare expenses. We did provide that under our sealed financial source documents. I'm sorry, it's We Care Daycare. That should also transition into preschool expenses and proportionate share of agreed extracurricular activities expenses. Unfortunately, or maybe true to his history, Mr. Scrivener has provided no financial support to his wife for either herself or for the child since their separation. And in November, he told her he was removing her from the phone account. So he's not even paying for her phone bill anymore, which one would assume was probably shortly after he consulted with his attorney, since this petition was filed a week later. We are asking the court, in addition to the child support and spousal maintenance, to provide for an award of temporary attorney's fees of $2,500. Again, the last 9 months, he's provided no support. He also received the 2021 tax refund, and we are asking for the court to order that he provide 50% of that to Ms. Scrivener because she's not received any of that. In addition, there is so my client provides in her declaration that they had been paying his mother $400 per month while they were living in his parents' basement. The plan is that those monies were going to be deposited into a savings account for them to be able to use for future housing. Of course, now that's disputed, and the evidence that my client does have is a text to her Aunt Becky back in 2021, which represents her present sense impression of what they were doing and how wonderful that was to basically allow this young family to get their feet under them. Of course, when my client comes in and requests to receive half of those, now all of a sudden that wasn't the plan. We were actually paying rent. But again, going back to 2021 and having that text, I think is significant to show the present sense impression of my client and what the discussion was and what the agreement was at that time. Finally, we are asking that the parties file a joint 2022 tax return. They should share 50-50 in any preparation expenses. From assuming that there is a refund, as they received a healthy refund last year, assuming that there is a refund, the first $819.06 should be applied towards that collection bill for the balance of the birthing fees for Wren that were incurred 3 years ago. And thereafter, I'm assuming that there's probably additional interest and fees on that since it is in collection. So whatever it is, $819.06 plus. And then the net balance thereafter would be split 50-50. So I have provided for the $2,500 in attorney's fees in my order, as well as additional language related to the splitting of the monies that are being held by his mom and the 2021 tax return. You'll note that the temporary order, proposed temporary order at paragraphs 14B and C outline those, but they don't set them as judgments. I've basically set a payment date by April 15th for those. I guess we can reduce those to judgment ultimately if he fails to pay those. And then finally, we are asking that the court appoint a guardian ad litem in this matter, that fees be split proportionally based upon their incomes. And then I've proposed a final GAL report review on June 27th at 1 p.m. If the court is not inclined to adopt our proposed parenting plan by placing Wren primarily with my client, we would ask that the court consider an early review so that a guardian ad litem can provide some feedback on that issue.
All right, thank you.
Thanks.
Ms. Bliss.
Thank you, Your Honor. For the record, Carly Bliss on behalf of Jordan Scrivener, the petitioner, but non-moving party for the purposes of today's motion. Let's address the parenting plan first. It's ironic that counsel's argument is my client's motivation to maintain status quo is financially based, when in fact, if Your Honor looks at the pleadings that have been filed, that couldn't be further from the truth. What my client provides for you is a proposed parenting plan that adopts what the parties have been doing since their separation in April of last year. Granted, I agree with Ms. McLean, it is unorthodox. Trying to throw that schedule into a parenting plan was rather difficult on my part as well. However, the parties came to this agreement when they separated, and this is the schedule that Wren has been operating under since that time. My client provides for the court that this is in his best interest to spend equal time with both parents, and that he's been adjusting well with the schedule. Contrary to mother's allegations that he has struggles going to and from each party's home, my client provided this declaration that's not uncommon in cases of split parents and new surroundings. He provides for the court that while he also shared those emotions and frustrations with my client when going to mom's house, that quickly changed. And that was on the part of my client encouraging Wren to be excited to go to mommy's house. And then as soon as that conversation happened, Wren became agreeable and no longer shared those emotions. Looking to the allegations and his mother's basis for this motion and changing the child's status quo, looking first to the allergens. My client goes in depth in his declaration to tell the court that the child is moderately allergic to pets and pet dander. My client provides for the court that the at his home, were in his home when the parties were still in a relationship and still residing in the home. He provides that he has 2 German Shepherds who he grooms regularly, and a cat. He disputes any allegations that they have fleas, indicates that they've been medicated and cared for, and again are groomed regularly to prevent fleas from occurring. Similarly, he provides and swears under penalty of perjury that he dusts his house daily, which I think is admirable. I don't know many folks who do dust their homes regularly. So I would tell the court that my client is adequately addressing Bren's allergens, and to suggest that he's not is disingenuous. Looking next, and again, speaking of the Band-Aid issue, my client provides for the courts that he utilized ointments and Band-Aids for injuries. What's interesting, if Your Honor looks at the text messages provided by mother, the parties just learned that this child had allergy to Band-Aids in November. So for 2 months now that it's been known that this child now has an allergy to Band-Aids. Since that time, my client obviously has addressed the issue differently. However, at the time he was using Band-Aids as he believed that it prevented the child from scratching and continuing to have these issues. Looking next to the concerns regarding my client introducing his new significant other. If the court looks at the declaration presented by mother, it seems that this is more of a concern that she has that he has moved on, more so than its effect on Bren. Even in her own text messages and photographs, she shows that Bren is well bonded with my client's new significant other's children. My client provides for the court that him and his significant other are expecting a child at this point, are going to be living together at this point. So to suggest that my client's introduction of this significant other is in any way detrimental to Bren is simply not supported by evidence. Looking next to my apologies. My client disputes the fact that mother claims that she has been the only party that has undertaken parenting functions. My client provides that during the relationship, he also participated quite frequently in caring for the child when he would come home from work. Again, it's undisputed that he was the financial breadwinner for this family. However, his job did not end when he came home. He provides for the court that he also took care of the child, cleaned up after the home, took care of meeting the child's needs, bathing, feeding, clothing, and that has not stopped since the parties have engaged in the equal residential schedule that they're currently operating under. So to suggest that removing the child from an equal residential schedule with both parents, whom he is closely bonded to and well taken care of, is somehow in his best interest, I think is inappropriate, and I don't think that the court should make that determination without getting some input from a guardian ad litem if Your Honor is inclined to make any change to the residential schedule. At this point, we are asking the court to adopt our parenting plan, as we do believe that it A, adequately reflects the status quo that the parties have been operating under for almost a year at this point, and B, we believe it is in Bren's best interest. I believe if the court wants to appoint a guardian ad litem to investigate, my client doesn't have any objection to that. However, as the court can see from the text messages, the parties do co-parent relatively well for this child. I don't believe this is a case where a guardian ad litem is necessary, but again, I'll defer to the court. Looking next to the finances, this is a 5-year marriage. My client's income for purposes of the child support worksheets is around $4,300. Mrs. has always worked as what my client was under the impression of is a minimum wage type position. We are asking the court to keep her at minimum wage at full-time hours. There's nothing that's been provided other than her history of not working full-time hours as a basis why she cannot. So we are asking the court to adopt our child support worksheets. Again, if Your Honor is going to approve of our proposed parenting plan, the parties are spending equal residential time with this child. My client is asking to be awarded a residential credit. Using my worksheets with that equal residential credit would require a transfer payment of $198.90. My client is asking the court to approve of that order today. As it relates to spousal support, again, this is a 5-year marriage. Although my client was the primary breadwinner, during the marriage, he does not earn significant income. If Your Honor approves of our child support worksheets, you'll see that the parties' incomes are relatively similar. He simply does not have the funds to provide spousal support, and I don't think an award of spousal maintenance is appropriate, given the length of this marriage, given the fact that Mrs. has been living essentially on her own since April of last year and has not received, with the exception of one payment, which I will discuss here in a moment, has been self-sufficient in supporting herself since the parties separated. As such, we are asking the court to deny the request for spousal maintenance at this point. Same with fees. The parties just simply don't have excessive funds to pay for attorney's fees. These are both young individuals with modest means. So we are asking the court to order each party pay their attorney's fees. Looking next to the tax issue, the 2021 tax issue, Mrs. is requesting some monies be paid to her. My client provides in his declaration that the refund for the 2021 taxes was received while the parties were still in a relationship and prior to separation. He provides that with that $3,276 refund that they received for 2021, he paid rent, he paid Mrs. Payments directly in the amount of $1,080. He provided for the child's needs and was solely responsible for paying daycare since separation. As such, there simply is no money left of that refund. So to request the court to order something prior to the party separation now be awarded to Mrs. I don't think is appropriate, as we are asking the court to deny that request at this point. Looking next to the distribution of assets and debts, counsel didn't go into much discussion of this simply because I think it's undisputed that the assets that are in each party's possession at this point should be awarded to them. My client agrees to continue paying his credit card with regard to the child's birth collections account. My client provided that he was unaware that this was there was still an amount owing from 3 years ago that it had been sent to collections. At this point, he agrees that money needs to be paid, and he would agree to having that come off of the top of the party's 2022 taxes. Lastly, as it relates to this theory that my client's parents were charging them $400 in rent, but essentially saving the money moving forward, my client provides in his declaration this simply is not true. Mrs. provides not only self-serving statements in her declaration, but a self-serving text message between her and a third party that this was an understanding. There's no documentation from my client's mother at this point. There's no documentation other than that one text message that this agreement actually occurred. My client provides that his parents allowed him to live in the home and were charging $400 per month in rent. This is not saved. My client doesn't have access to this money, and therefore it should not be ordered to be paid to Mrs. Within the time period asked by Mrs. As such, we have provided our own temporary orders for today's hearing. Your Honor, I have before you a temporary family law order, a parenting plan, a child support worksheets. At this point, we are asking the court to approve those orders.
Thank you. Ms. McLean, anything else?
Just briefly in response, again, as it relates to my client's work hours, she outlines for you on page 5 of her original declaration that she works for the House of Roses every Monday from 9 a.m. to 5 p.m. and Saturdays from 10 a.m. to 4 p.m. And then she works at McMinimans Tuesdays, Thursdays, and Fridays from 8 a.m. to 2 p.m. She works 32 hours a week. And that is allowable under the statute. It would be inappropriate, again, to inflate her income above that figure as is being proposed. In regards to the allergens, the suggestion that he dusts every day doesn't address necessarily this dog dander issue. Look at the photos that we've provided under sealed health. You have consistently a child who is in hives, and that's not healthy for him. The consistent exposure to an allergen can lead to worsening allergies, can also lead to worsening exacerbations of his other complicating factor, which is asthma. The photos show that he came back to mom on April 25th of 22, July 31 of 22, September 17 of 22, October 6 of 2022. He had the impetigo on October 16 of 2022. He's got multiple flea bites on November 30th of 2022. And also we've got the continuation of those on December 1. He's got more flea bites and welts on December 26th of 2022, December 29th of 22, and January 2 of 23. This child is consistently under pressure for his allergies. A child shouldn't have to undergo this. Those allergens need to be taken care of, and dad just is not doing that.
Quick question. Were those dates outlined in the declaration? Because I'm looking at index 20, the text messages, and then in the text messages are some of the photos. Were those dates somewhere else as well?
Yeah, under the sealed health. If there's a sealed health, and I'm sorry, I don't have I can look up an index for you.
It's 18. I got it.
Okay.
Perfect.
All
I
right.
just I looked at that,
Just
but then it
because-
didn't sound familiar when you were relaying it. So okay.
And
Now
that
that I'm
also,
looking
that
at it.
also has his albuterol prescription for his asthma.
Okay. Thank you.
Yep.
I just want to jump in real quick because my ears need a break from her talking. Wow, they both are long-winded, and they said they had almost everything worked out, and they do have everything worked out, and they still had to talk that much. But anyways, I wanted to tell you guys about a new channel that one of our amazing community members has started. It's called Looking at Legal Stuff, and I'm going to put a link in the description for you. So if you get a chance, go check it out. And she's just getting started. She just got her first 2 videos up just in time for her birthday. So everybody wish her a happy birthday and give her channel a quick little like and help her get off the ground so she can get in that algorithm and get some views to get her channel going as well. And back to the drama. I mean, it's not a lot of drama, but this kid obviously has a ton of issues, health issues, and needs to be taken care of very carefully. And when you're young, especially younger men, don't tend to be the most observant when it comes to, you know, small things like that. Oh, it's just a scratch. No, it's not a scratch. It's eczema or something along those lines that really needs to be taken care of. And this kid has severe allergies. So I just thought this one was interesting because of all the health issues involved. And mom is trying to get dad to do things the right way, and dad wants to do things his way. So back at it for you.
Anything else?
Oh.
All right. Just give me a moment here.
Sorry, little dead air. I did just throw this one on here. I didn't have a chance to edit it out. But while they're having some dead air, I want to talk about the first lady who had the Playboy bunny tattoos. Do you realize she was wearing
So starting with what's agreed.
she was wearing a camisole. And I know some people wear them around the house in Florida. You know, younger girls will wear them out and everything else, but generally you wear those underneath your clothes. You don't wear that as your only shirt, especially when you're going to court. It's kind of meant to be an undergarment more than like a wear out, especially to court garment. And that really, wow.
Sounds like the 2022 tax refund, which, and I guess maybe it wasn't agreed, but is it agreed that they can file joint for 2022?
Yes.
Okay. So we'll get that taken care of. And I would agree that taking care of that amount in collections, so the 819 plus whatever fees should be taken out of that return, and then the remainder split 50-50. I just have Miss McLean's order up here, so I'm just gonna go through this. It says it's asking that those be completed and filed no later than March 10th. That seems like a reasonable amount of time to get that filed. And then it does indicate the Credit Solutions account. And then the remainder split. I think that seems reasonable. I'm going to order $1,000 in attorney's fees, not $2,500. So I'm making that change.
You also need to make the change at paragraph 12.
And
paragraph 1.
With the due date 4/15/23. As to the, and I'm going to go back to, I'm sorry, I'm jumping around here, but paragraph 14.
Yes.
I am striking section B and C. I, at this point, do not feel I have sufficient information to address those two things. So parties are free to raise those issues later, but at this point, I'm not going to order that the rent money or the previous tax be split. It does sound from the declaration that those may have been used to pay some mutual expenses. If it proves otherwise, I'm happy to readdress that. But at this point, I'm not going to address B and C.
Would you just indicate that those are reserved?
I will.
Thanks.
I've struck them, initialed, and indicated reserved.
Okay, thanks.
And that is, you're being very generous, assuming that I'll make it through all these orders without you having to redo them all. But
oh, we have faith.
so I'm kind of working my way backwards here. The money judgment language in paragraph 12. Well, I won't change any of that. No change.
The 2,500 needs to be changed to 1,000.
I changed that, but
Okay,
as far as
all right.
the interest rate and the due date, I didn't make any changes there.
Okay.
No one changes to insurance. Vehicle and credit card, and I know, Ms. Bliss, you indicated that. I think you indicated the same two things. Is that correct?
Correct.
All right, so that's good. I think at this point, a GAL is probably, I'm not hearing anything super concerning. I understand mom's concerns with the allergies, the Band-Aid issue appears to have been addressed as soon as it was made aware to Mr. And I'm going to assume that the animals that he has, as he indicated, are the same that existed when they all lived together. But we do have some of these pictures are hard because for me to really see too much because they're only in black and white for my view. But in several of them, I can see that there's something going on. And frankly, I don't have the schedule of when the child was coming or going from dad's or at mom's to kind of compare these two. So and I would agree with Miss Bliss that a lot of the interactions seem to be relatively pleasant between the parties. So I am gonna authorize a GAL and 0.1. But I think we can probably do a relatively quick review unless something pops up. But I don't know that we're gonna need a super in-depth GAL, but I will appoint a GAL. As to the parenting plan and child support worksheets, well, first off, the request for spousal maintenance. This would be considered a short-term marriage. Mr. was primary breadwinner during the marriage, and Mrs. is clearly engaged in employment and has expanded on that employment, working up to 32 hours per week at this point. I just don't. I think it's appropriate for Mr. to make an initial and potentially another judgment towards the attorney's fees, but at this point, I don't know that spousal maintenance is appropriate. So I'll reserve on that, but I'm not ordering it at this point.
You're striking 5B and just indicating reserve.
Yes.
Okay.
And
then as it relates to the GAL, may we have the next 3 on the list?
yes, I have Vashti Langford, Ann Height, and Twyla Corey.
I'll strike Vashti.
I'm fine with, I think Anne Height was next. She's fine with me.
All right, so it'll be Ann Height.
If you'll just interlineate that at paragraph 3 on the order appointing guardian ad litem. And then that order sets up a final review on June 27, 23 at 1 p.m.
June 27, 2023 at 1 p.m. And then you address, I guess, depending on what I order in the parenting plan, potentially a quicker review. So I'll just kind of mentally note that again. Okay. This is listed private pay by the parties, 72% petitioner, 28 respondent. Ms. Bliss, any concerns or objections to that?
I guess I think first we should probably address whose worksheets you're adopting, because I think those percentages might change depending on your ruling, but otherwise.
I assume it'll be somewhere relatively close to that.
Okay.
Just keep this out of the way. All right.
Well, and so the court asked as it relates to private pay. Technically, I don't think that Mr. Scrivener qualifies for county pay, given his level of income at $4,700 a month net. I think arguably my client could qualify for county pay on her 28%.
Okay. And I'm going to go and finish the temporary order first. So section B, no, it's okay. I'm jumping all over the place and I apologize. It's been kind of a funky day. So section B under number 5 on Ms. McLean's proposed temporary order, I've struck and just indicated reserved. And then I don't believe there's any other changes to that other than the $1,000, and I'm striking B and C.
Okay.
Perfect.
So I can move that out of the way. The GAL order is done, but for the worksheets or in the numbers. So it appears that Mr.'s income is really not disputed. He ultimately ends at a net at around 4,700. So I am gonna, and the mom's, Mrs. is 1,800 on, Miss McLean's net and 2,300 on, Miss Bliss's net. I'm gonna follow Miss McLean's worksheet. However, I'm gonna throw a wrench into the works here. And that being, so I'll adopt the net amounts that are in Miss McLean's worksheets.
So then there wouldn't need to be a change to the percentages. I don't believe, unless that throwing the wrench hasn't disclosed something else.
No, so yes, you're right. That wouldn't change the percentages. I'm gonna indicate private pay within 2 weeks. Ms. McLean, if there's a concern with your client being able to do that, then hopefully my cap is large enough that you can get it added on sooner rather than later.
Okay.
So I'll enter that order. I am gonna just making sure that I have what I need here left. Okay, so then I'm gonna go to parenting plan. And this is a super convoluted parenting plan, but I have nothing that indicates, and this is Miss Bliss's proposal that I'm looking at. And I reviewed it a couple times, so I'm kind of with everybody else on that. But I haven't heard any dispute about this not being kind of the status quo for the past several months, 8 months or 9 months, and unless I missed that. Is this how it, Ms. McLean, do you agree that this has kind of been the schedule they've been following while not being before the court?
So my understanding was that there was about a rotation every 2 or 3 days. My client will shake or nod her head if that's not accurate. That's accurate, about every 2 or 3 days. And I guess just so that maybe it wouldn't be so convoluted if the court's inclined to maintain sort of a joint parenting plan. Is that where the court's going?
That's where I'm going, yes.
I guess I would like to suggest maybe that we look at transitioning to one parent, again, because this child's going to be matriculating into a preschool here soon. And so it'd be nice to have sort of some consistency for him as far as his weeks, so that maybe dad has every Monday to Wednesday, mom has Wednesday to Friday, and we alternate the weekends, Friday to Monday. That way there's 3 transition days, Mondays, Wednesdays, and Fridays.
Ms. Bliss?
I don't necessarily have an opposition to that. I agree with both Reporter and Ms. McLean that this is rather confusing for us, let alone a small child. My position obviously was that this was what parties have been doing, but I do agree that maybe limiting the amount of exchanges or making them on a consistent day may be more appropriate moving forward.
And then sorry.
No, I was just saying, I don't know my client's position, obviously, but I imagine he wants whatever's best for Ren, and I think he would agree that maintaining some consistency is probably in his best interest.
So I guess just for the parents, if this is something, if, you know, it's not likely this case will get resolved super quickly. Is Ren transitioning into preschool this coming fall, or do we have another year?
Technically, he started the preschool program at We Care Daycare already.
Okay.
It is 3 days of, sorry. It is like, I do schedule them every day or every week for 3 days a week. For Tuesdays, Thursdays, and Fridays. That way, when I'm working on Wednesday, my mom can watch him. And usually Marissa always ends up with him on Monday, and that way her dad can watch him while she's working on Monday.
So they've really been thoughtful about this so far. And I appreciate that. Thank you very much. I appreciate that you've been able to work together on this. And I like that there's grandparent built-in time. I guess, Ms. McLean, Ms. Bliss, do either one of you want to have an opportunity to just chat with your clients? Because if this kind of weird thing works best, then maybe changing it up. I don't want to put their lives in a blender any more than they already are. So I don't know if you want to.
I would like the opportunity to chat with my client, and then if Carly and I can't work it out between ourselves, then maybe we'll just email you for some additional input.
Okay, so do you want me to just set aside the parenting plan then? And because if there's, okay, I'm gonna set aside the parenting plans. There's really no other issues in there that I think we need to address, I think, before we get that kind of basic parenting plan stuff out of the way.
Are you inclined to add the language about ensuring that the child's medications transport with them?
Yeah, yes, I think that's appropriate. And with the language that, you know, all the medicines are in their actual containers. I know while I believe I recall hearing that now both parties have an inhaler. Is that correct? They're shaking their head. So I don't know if that needs to go back and forth, but obviously if the child's at daycare or somewhere else, they need to be responsible for having the medications available for the child when they're not in their care. So what, yes. Okay. So, and I don't know if this decision if you want to work together on a potential new child support order based on that, with me adopting Ms. McLean's worksheets.
I guess my pitch would be that given the disparities in their incomes and the clear need by my client, that deviation in child support would not be appropriate. And clearly that's discretionary with the court.
And I guess my pitch, Your Honor, if you are adopting Ms. McLean's worksheets, just pull those up. It's mine have a disparity of about $2,500 differences of their incomes. Obviously, Ms. McLean's is slightly larger. My pitch obviously is that if they are spending equal residential time with the child, my client is incurring substantial costs associated with that. If Your Honor is not inclined to order a complete residential credit, which still provided Mrs. nearly $200 per month in support, we would ask for some sort of credit so that he's not, I guess, ordered that full $788 as Ms. McLean's orders have reflected.
The only additional comment that I would note is that Mr. Scrivener has not submitted a financial declaration. He's obviously acknowledged that he's sharing expenses with his new significant other. So he clearly has sufficient finances within his own housing. I will tell the court also I did look at what the residential credit would be if you did order a deviation. On my numbers, it's 240. But again, we're asking that the court not deviate.
And with your numbers and no deviation, it's how much?
I think it's 788, 788.02.
So mom wants $700 a month. Dad's attorney says $200 a month. They go back and forth about how messy the numbers are for 5 more minutes. And then that's it. So pretty much that whole hearing was all about, let's talk about all these things that are wrong. And in the end, it's like, oh, well, we'll just go talk about it and work it out together. Really? Like, couldn't you have done that before?
We had a PCC last Tuesday. At that time, the discovery was not available. I requested it. The discovery came last night after hours at 5:33. It's paper discovery only.
That's all you're getting. I'm sorry.
Judge, there's body wear camera.
You're going to have to wait for that. This is a probable cause hearing.
I understand my client is entitled to effective assistance of counsel even at this
I
level.
understand.
It's a
So
very
they can lay it on the judge. You're entitled to paper discovery on this, on the domestic. And if there's something with a body cam, you're entitled to that for trial. Are you asking me to adjourn the case?
I'm asking you to continue, yes, to continue the exam so that I can properly prepare. And again, this came in after hours last night. It wasn't like I got timely paper.
You know what I used to do when I was a lawyer? I used to read them the day of, and I did felonies. I'm not going to adjourn this. I'm sorry. We're going to go forward.
Can I at least finish the record? There's also reports that are reflected in the body of this report regarding prior incidents, and I believe to be prior false reports that are going to be, important for your honor's credibility determination. And I don't understand. I believe that to be good cause why the people should be allowed to.
Listen, I don't like it. They should be getting you the discovery earlier. When did you get it to him, Mr. Kazak?
Your Honor, I redacted it last night. I sent it to counsel after I got his email, and I redacted last night. I sent it to him last night, Your Honor.
I had another hearing this morning, Judge. I actually zoomed from, your conference room. I don't think it's fair to Mr. Crane that I have to fly by the seat of my pants on a felony examination. It's just not right.
How long is the report?
18 pages. And to the extent that, we've got the proper precautions in place and he's been ordered to stay away and that's been adhered to. We got a family law court presiding over the aspects of parenting time and custody. Every precaution is in place. He's adhering to his GPS tether.
I don't think you need the adjournment. I'll give you 1 week. You're going to try to get the body cams, but it's not going to be grounds for an adjournment or whatever else there is, but we're going to do it next week. So I'll adjourn it 1 week. I mean, it's an ongoing problem. I'm not going to deny that. It's an ongoing problem. It has been. They don't have enough resources. So I can do this at 10 next week. This will be in person. You got to give it to him quicker than that, Mr. Kazak. I know you're overwhelmed. I get it. I understand. But you got to get it to him before the night before. I personally, well, I'll just let it go with that. We'll set it for 10 o'clock in the morning. That'll be in person.
And just one last matter, it's my indication that, my understanding rather, that the victim is no longer residing in the property. She does need to stand by to get some personal effects out of there, but I'd ask you modify the bonds so we can return to his house.
Is that true, Mr. Kazak?
And Your Honor, I don't believe she's currently residing at the residence. We're going to ask, I believe she needs to return there to remove some additional property, but I think that can be facilitated today with civil standby from the police department, Your Honor.
Wait a minute. He wasn't to return to 32 Roerig. Who's living at 32 Roerig right now?
Nobody, Judge. She moved out.
Is that right, Ms. Duco? Yeah. Come on back up here. Come on up here if you would. Okay, your name? Did you move out of the residence?
Yes, I did. I just have something left there that I would like to get.
Okay. All right, here's what I'll do. Give me a bunch. Let me see here. I have it. Yeah. Can you get all of those items out of there today, ma'am? Well, you got a GPS tether on, right?
Yes, sir.
So that complicates things.
Yeah, that's why I have 2 daughters that go to review schools and they're uprooted with this as well. That's why I just would try to get some stability back for my children by going back to my house. So I didn't know if we can modify something with the tether unit or. Like I said, Your Honor, I am not here to cause any problems for you.
What's that?
I am not here to cause any problem for you, Judge. Whatever you can do, I appreciate
You're not causing any problems for me. I'm just trying to figure out how I'm going to handle this. Who owns the residence?
I rent, Your Honor.
You rent?
Yes, sir.
You're not on the lease?
No.
My concern here, frankly, is I don't want, did you spend any time, you were in custody?
11 days, Your Honor.
How long did it take you to post the bond?
The day after I saw you, it was.
And you were in custody on that?
Yes, sir. And I.
Which I've
within a half-
expressed is completely inappropriate. I mean, it just is. So you're telling me the Wayne County Jail took 10 days or thereabouts to fix the GPS tether, right?
Yes, Your Honor.
I mean, that's just, it's not right.
Yes, sir. Your Honor.
But here's my concern.
Yes, sir.
I start playing around with the tether now, you might find yourself in that predicament again. You might find yourself in that predicament again. So I'm going to suggest strongly that we leave the status quo as is until next Tuesday. Lisa, in the meantime, we can the prosecutor can provide you with the victim's address so that the tether unit can modify the tether requirement, because one of the conditions is he's not to be within 2 miles of the victim, her residence, or her place of employment. If I let him go back there, counsel, right now with that tether, there's going to be a violation. If I make him go downtown right now and get the bond terms the GPS tether modified, he might find himself in that predicament. This is beyond my control. I've expressed my displeasure with it repeatedly.
Well, I understand the concern and find it to be most unfortunate that that's the reality.
So do I.
But it apparently is. And
so here's what I'm going to do. I'm keeping this bond in effect until next Tuesday. I'm hoping that the victim's advocate, your name, please?
Rachel,
You're the victim's advocate.
Laura is
Well, wait a minute. You're kind of the victim's advocate, right?
correct.
Okay, so I'm just hoping you guys can work with the tether unit. I'm asking you to convey whatever information about where she's going to be, because somehow it's got to get conveyed adequately to the tether unit so that he's not sitting in jail for multiple days while they try to verify where the victim is. That's the issue. If it weren't for the GPS tether, I'd let you go back there right now, or at least after today was my initial plan. This is, let me check something here. Yeah, and I don't feel comfortable without this in light of the fact that he has 2 priors, counsel. That's what I'm doing. I'm holding this, I'm going to continue the bond as is. I'm going to ask you to try to get with them and figure out a way so that this tether isn't, when he takes it down, isn't going to require him to sit in jail again. And I sympathize with you. It's not fair. It's absolutely not fair.
And Your Honor, there was one other concern that people wanted to address regarding a potential contact violation involving.
If he had contact, we're talking about a whole different ballgame now. You know he wouldn't have done that.
No, sir.
You're not suggesting the defendant had violated the no contact.
Yes, Your Honor.
Because the defendant violating a no contact on a third offense domestic violence would know that any judge between here and Tuscaloosa would have a big problem with that. So you're going to put on evidence of this right now, or are you going to simply bring it up?
Your Honor, if the court would take evidence, yes, the plaintiff here.
Okay, who do you want me to hear from?
Your Honor, the people like to hear from the complaining witness in this case.
Raise your right hand, Ms. Duco. You solemnly swear or affirm under penalties of perjury, the testimony you'll give in these proceedings will be the whole truth, so help you God. I can't hear you.
Yes.
Okay, you got to keep your voice up.
Okay.
I don't want you to be nervous. Prosecutor's going to ask you some questions. Defense is going to have the opportunity to ask you some questions, and then we're going to go from there.
Okay.
Counsel, I'm gonna ask you to step back a second here, so defense lawyer and defendant can have a seat at the council table. Ma'am, why don't you have a seat at the witness chair here? Go ahead.
Thank you, Your Honor. And good morning, Miss, how do you pronounce your last name? Is it
Duclos.
Duclos, okay.
Yeah.
So my understanding is that you had that you currently, your children go to a elementary school in the area?
My oldest.
And were you there recently picking up your child?
Yes.
All right, and did you see anyone there at the time you were picking up your child?
Yes, I seen his mother, Gail Crane. She parks on Ray Street in her white Jeep, picking up both of his children.
And you see, and what day was this?
Monday
And that's Monday of this week?
of last week.
Last week. And did you see anyone else there at the time?
As I went to go around to skip the extra line on the backside of Memorial, Stephen is there driving, waving at me as if he could still find me.
Now you
Say that again.
His mother parks on Ray Street every day to pick up his children. I am on Coaster. I park at my mother's house. I walk up to the corner and my daughter comes to me. I see his children go to his mother. I walk back to my car, and as I go, I turn left, as she did that day too,
Who's she?
his mother. And as I go straight and I hit that stop sign, he's right there, just smiling and waving at me.
Now were you on the sidewalk at the time or you were
Driving my car.
And now was he in the vehicle at the time as well?
Yes.
And now you say he, are you referring to Mr.
Crane.
And and how far was he away from you when you did that?
We went side by side cars.
And about did he turn his whole body towards you and wave, or is it just?
I just seen a smile and a wave, and I didn't want to look any further.
And he was directed, and he waved towards you?
Yes.
And and was he driving at a slow rate of speed or high rate of speed at that time?
Just slow.
And Your Honor, I don't believe this time I have any further questions for Ms. Duclos.
Any questions? Yes, Ms. Duclos, you said you walked to your mother's house up to the pickup area?
Walk from my mother's house? Yes.
And then now, but you said that you were in a car when you encountered.
Yes, after the fact that I got my daughter.
Wait a minute, keep your voice up. I'm not understanding either.
Okay.
So you walked up there?
Beforehand, when you have to go pick up your children,
Right.
you walk up to the school and get them, and then you go back to the car with your child to leave. I was leaving.
I see. So you parked your car?
Yes, I had my car parked, and as I went to leave, as I got back in my car with my children, and I went to drive away, that is when I encountered Stephen.
Okay, and you don't dispute that Mr. Crane had a right to be there to pick up his.
No, he didn't.
But his mother was there that day.
His
right?
mother was there on Ray Street.
And if
Yes.
she were to testify here in open court that Stephen wasn't in the area with her, that she would be lying?
She passed right by him.
Okay, so she would be lying then, if that were the case.
I believe so, yeah.
Okay, you don't know what he was smiling at or why.
Yes.
We had a hearing last Tuesday. Were you aware of that?
No, I'm not aware of anything. I wasn't told
You have a
anything
victim's
until,
advocate. You weren't aware that this case was up for hearing last Tuesday?
no, I just got a call yesterday saying that I had to be here.
Okay, and did you bring it to anybody's attention last Monday when it happened?
Yes, the Review Police.
Okay, to what police?
Riverview, because that's where it
You made a
happened.
report?
Yes, I made a
Okay.
report.
I have nothing for the judge. Excuse me.
In the car vehicle you were driving, you had that vehicle for a while?
Yes.
Do you have the vehicle at the time you were initially in the relationship with Mr.
It would have been after school, so it was around 3:50 to 3:55.
Okay, no, I meant,
Oh,
had you had the vehicle that you were driving for a while?
do I have it here?
No, at the time this happened, I'm just trying.
Yes, I have the same vehicle.
Okay, all right, and you had the vehicle when you were in a relationship with
Yes.
Mr. Duclos, all right. And is this, do you pick up your daughter on a regular basis? at
Every
school?
day.
Your Honor, I don't have any further questions at this time.
Anything else?
No, Your Honor.
You can step down, ma'am. Thank you very much. Do you have any other witnesses?
No, thank you, Your Honor.
Do you have any witnesses your
I do
client
not.
wishes to testify?
I'll call my client's mother, Gail Crane, to the stand.
Okay. Come on up here, ma'am. Right up to the witness chair there. I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes, I do.
Have a seat, please. Could you state your full name and spell your full name for my recorder, please?
My name is Gail Crane Atkins, Gail. Last name is CRAYNE-ADKINS.
Thank you. You can proceed, Mr. McCurry.
Thank you, Your Honor. Ms. Crane Atkins, what is your relationship to the defendant, Stephen Crane?
His mother.
Okay, and you heard the testimony this morning of Ms. Duco, did you not?
Yes.
Okay, and do you recall the circumstances last Monday when you picked up your grandkids?
Yes, I pick him up every day
Okay,
because he's usually at work.
he's usually at work. When was Mr. Crane at work that day?
Yes, he was.
Was he with you or near you at the time you picked up your grandchildren?
No,
Did you see Ms. Duco when you were there?
no.
So as far as you're concerned, there would have been a factual impossibility for Mr. Crane to be there and smile and wave at Ms. Duco.
Well, I can't really say if he did or not, sir, because I was going towards Fort Street on Longsdorff after I picked up my girls. Because if you go on the school side, it's very crowded. So I go down Delayed and come up Longsdorff to avoid the traffic.
Okay, but Mr. Crane wasn't there. Your son wasn't there.
He wasn't picking up the kids, no.
You said he was at work?
He goes to work every day. I don't know, I'll never know what time he gets off.
But that day, that afternoon, you didn't see him there.
Not at the school.
I have nothing further.
Any questions, Mr. Kazan?
Yeah, and then you indicated that he wasn't there picking up his kids, but you don't know where he was at, would that be fair?
Well, I'm not understand.
You indicated that you said he was at work, but how do you know he was at work?
Well, that day I passed him because he was going, I believe he was going to his sister's house. She lives also in Riverview.
Okay, so you passed him when you were going to school or coming back from the school?
After I picked up his children.
Okay. You passed him going from the school then?
Mm-hmm.
Okay.
Is that a yes?
Yes, sorry.
And so it was nearby the school at that time?
On the back side of the school.
I have no further questions.
Anything else, Mr. McCarty?
No, Your Honor.
You can have a seat, ma'am. Thank you very much. Any other witnesses?
No, thank you.
Great. Do you have any other?
Call Mr. Crane, Judge.
Come on up, sir. Raise your right hand. You solemnly swear or affirm. You solemnly swear or affirm under penalties of perjury, the testimony you give in these proceedings will be the whole truth, so help you God.
Yes, sir.
Okay, have a seat. You can proceed.
Sir, you've heard the testimony this morning, have you not?
Yes, Your Honor.
Did you
Yes, sir.
see Ms. Duco that morning?
No, sir.
You didn't smile and wave at her?
No, sir. I have not seen her since the day of this incident here, sir.
Okay. Did you have any reason to violate your bond?
No, sir,
You
not at
spent
all.
11 days in
Yes, sir.
custody?
And my kids are uprooted from this. I would not in any shape or form compromise this case, sir.
And do you believe Ms. Duco may know what to say or to do to get you into further trouble?
100%, sir. She was with me when I was going through some other stuff with my ex, and she was my witness, and she knows this unfortunately very well.
Okay, and so, and that day in question, you were en route to your sister's house?
I never even seen her. I got off work after my daughters were out of school. It wasn't even in the same time, like it was, I'm not sure exactly the time, but it was nowhere near Kayla, sir.
Nothing further.
Anything, Mr. Kazak?
So you were at the school, were you at the school on Monday, this past Monday?
No, sir.
You weren't at the school?
No, sir.
You weren't nearby?
This Monday or the,
2 weeks ago.
no, sir, I was
Wait a minute,
not.
let's slow down. Yesterday was Monday.
Yes, sir, that's why I was confused.
Slow down.
Oh, yes, sir.
A week ago yesterday, that Monday, were you anywhere near that school?
No, sir, I was not. My mother takes them every morning. This week I've taken my daughters because I started a little bit later, but I'm nowhere near Miss Duclos. I've not saw her since the day of this incident, sir.
That's not the question I asked. Were you at the school where Miss Duclos picks up her children?
No, sir.
Not last Monday?
I'm pretty sure I wasn't, sir, because my mom picks them up every day, so I wouldn't be there.
When's the last time you went to the school to pick up your kids?
I don't pick them up. My mom does. I drop them off once in a while, depending on my work schedule, but I never there. I don't.
When's the last time you went to school after school?
That's my point, Your Honor. It has been such a long time. My mother and my
What's a
sister.
long time?
Months, Your Honor. Actually, probably since last winter. Because I usually work until around 5, 6 o'clock until dusk. In the summer, it's even later. And unfortunately, my work, I have sole custody of my 2 little girls, so I don't have the freedom to be able to accommodate that time schedule.
Okay.
And so, sir, you weren't anywhere near the school that afternoon?
I was driving through, not at the same time as school was letting out.
That's not what I asked. Were you at the school all that afternoon?
Oh, no, I was not at school at all. No,
You
sir.
weren't in the area by the school?
I'm not at school time, no, sir.
That's not what I asked. Were you at school, were you at near the area of the school at the time your children
No, sir.
leave for the day?
No, sir, I would say, I don't know, at least a quarter mile away. And I wasn't even at the time of school getting out here, sir. It was
So you
after.
were a quarter mile away, and what time were you at, what time were you a quarter mile away at?
To be honest, I'm not sure.
Did you hear your mom say that she passed you on the way home from
On
school?
Sibley Road, at Sibley Road, where 4th Street is, at Sibley, my shop is on Sibley Road. I was coming down Sibley Road to go to my sister's house to get some of my clothing for today. And
Last Monday?
no, this was, I guess it was last Monday. No.
Last Monday, you were worried about getting clothes for
Well,
today?
because I never use my overnight, what's it called? Where the police come to the safe visit. I never use that. So my sister was getting stuff from me cordially as I needed it. And then I didn't have this shirt with me or my tie.
Go ahead, Mr. Kazak.
Judge, we had court last Tuesday.
No, I realize that. But we're talking about last Monday.
Right, for last
He wa-
Monday in preparation. for-
Okay, fair enough. Go ahead.
And so how far were you away from the school at about the time your children get picked up at?
To be honest here, sir, I mean, I don't even recall the exact time. It would be, I never went close to the school. I would say at the closest, a quarter mile. And I don't even believe that would be 100% accurate, sir.
And so your mother's statement that she saw your vehicle at the backside of the school being accurate, would that be fair?
Because Sibley Road is like
Just
the back.
answer his question.
Oh, I'm sorry.
I said, so your mother's statement that she saw your vehicle at the back, near the back side of the school being accurate?
Well, I mean, it would be, for her perception, it might be accurate on the backside of the school, but the distance to the school is not accurate. No, sir.
And so where exactly were you at the time your children get picked up from school?
I was at work and when they got out of school, sir. And then after their time, I'm not sure exactly the time, I was going down Sibley Road and it is the backside of the school, but I mean, there's a longevity of blocks that I was nowhere near the school. I'm sure the tether unit can verify that, sir.
And you're familiar with the vehicle that Miss Duclos drives, that be fair?
Yes, sir.
Can you see Miss Duclos' vehicle near the school that day?
No, sir, not at all. Like I said, I have not saw her since the day of this incident. I haven't seen her vehicle since the day of this incident, and I do not even look for her, sir. I have no reason to violate my bond. I do not want to go back to the county. I have no reason to put a hiccup in this, sir. Let alone smile or wave, whatever she said. I mean, that's just pretty immature, to be honest with you, sir.
I have no further questions, Your Honor.
All right, anything else?
No.
All right, you can step down. Thank you.
Thank you,
Any
Your Honor.
witnesses?
No, thank you, Your Honor.
No further witnesses. Well, short of,
I'm just asking if you have any other witnesses.
well, again, it would be from the tether unit verification to determine where he was last Monday. I think they would bear out that he was on Sibley Road, which I suppose in some people's understanding.
Get the victim in here. So I don't need any argument. I don't want the victim to, I want the victim to hear what I'm going to say, though. If you want to argue, you can argue. You want to argue? You want to argue?
No,
You
Your
can
Honor.
argue. You want to argue?
I don't want to argue, Judge.
I want you just to hear what I'm saying. Listen. If I was going to decide, you can shake your head up and down, side to side, scream and kick, do whatever you're going to say. If I was going to decide whether or not you waved at her and smiled at her, I would say you did. Don't shake your head. You are risking a lot. Because I'm serious about this bond condition. Very serious about it. You could lose $10,000, 10%. You could have that bond forfeited, and about $100,000, 10% bond would be set. I'm just telling. I think you wait. I think you smile. Your mother herself, your mother, not your enemy, your mother, said she saw you when she was on her way home from school. I think this was a bond violation. I'm not going to forfeit your bond. But I want to reiterate, apparently I did not do a very good job the first time. I want to reiterate how serious I am about this bond condition. You're in deep water right now. I mean, you're presumed innocent, but if you're convicted of domestic violence third, you're going to have a big problem. And you're not going to make things any better by having any kind of contact. Ms. Duco, if he has any contact with you again, you contact the officer in charge. You tell him exactly what happened. He will then come in and he will swear out a bond violation. And then I will immediately revoke the release, forfeit the bond, and issue a warrant pending a hearing. And then you're going to have a big problem. I wouldn't go anywhere near the school. I told you not to be within 2 miles of her residence or place of employment. There is nobody, certainly not as intelligent as you, that would misunderstand that order. There is nobody that would start thinking it's okay to wave and smile and drive by somebody doing so. I'm telling you, I'm not going to take any action today. Next time, if there's anything like this, you're not going to be this lucky, I promise you. If you think 11 days was bad, the bond, I hope you have a lot of money because it will be high. She would have to have filed a false police report. Maybe she did. I'm not going to comment any further. But I'm telling you, I can tell when people are testifying. You like to go on. There's no doubt that I'm right about this. Don't do it again. Do we understand one another firmly and completely?
Yes,
okay. All right. I'll see everybody here for the exam next week. This will be in person at 10 o'clock in the morning.
Thank you.
Thank you. I'm going to do it. He can either plead or we'll give you the hearing right now. The witness is here. I see in the back. She can testify. You can cross-examine. He can testify. He can remain silent, whatever you choose.
Well, I appreciate that, Judge, and he'd like a hearing. And
Come on up here, ma'am. All right, good enough. No problem.
Well, I mean, it just, my concern is Your Honor, in a sense, prosecuting.
I'm not prosecuting. I'm going to ask this witness to tell me what happened. I already heard from an officer. He was either, She either lied to him, in which case she's gonna have a big problem with
No,
me.
there's not a lie, there's no lie.
Okay, state your name, ma'am.
Kayla Duplo.
Raise your right hand. You solemnly swear or affirm under penalties of perjury the testimony you will give in these proceedings will be the whole truth so help you God.
Yes.
Have a seat.
Your Honor,
Yes, sir.
if I may, I do have a little bit of information that just came to light since we've been here at court to add to
Okay.
this that I'd like to share with you, so you're aware.
Mr. Crane, you can have a seat, sir. Sure.
Since I entered the courtroom, the victim advocate wanted to talk to me along with the victim. It was brought to my attention that the victim received a phone call at 1:46 since she was here at the courthouse.
No way.
This is what's reported to me, Your Honor. It was from a phone number other than the defendant, but it was the defendant's voice recognized by the victim that said one word, the word leave.
All right. You can have a seat right there.
Thanks.
Tell me your name again.
Kayla Duplo.
All right, so you were in court on Tuesday, right?
Yes.
We had a hearing regarding a possible violation of a no contact provision, correct?
Yes.
Have you had any contact at all with Mr. Crane since that date? And I'm talking about since he was in court and you were in court with me and the prosecutor and Mr. McCarty and the officer in charge on Tuesday.
I haven't had contact with him, but he tried to get contact with me.
Tell me what happened.
I went to turn my phone on to check if, in the
Nice and
morning,
loud for me. They have to hear you too.
to check if my daughter's dentist called me back because she had a dentist appointment that I found out on February 21st. And when I turned the phone on to look, there was a text message from Tuesday at 6:06 saying, "What are you doing?"
AM or PM?
PM.
And do you know what number that text was from?
Stevens,
Are you certain of that?
100%.
And what did it say exactly?
What you doing?
Do you have your phone?
It's here.
You still have the message?
Yes. Can I get it and show you?
Yes.
Can I get it to you?
No, you just stay there for a second.
Thank you.
And you're telling me that was at 6:06, correct?
Yeah, 6:06 PM on Tuesday.
In the exact words were, what are you doing?
What you doing?
What you doing?
Mhm.
WHATCHA.
And then doing, DOIN.
Did you have any other contact?
No, I didn't answer it. I did what you told me to do, which was contact. I tried contacting the court and got a hold of Laura. I contacted Rachel, and then I went to the Trenton Police Department and made the report.
Did he, to your knowledge, did he attempt to contact you in any other form or fashion?
Today, when I was sitting in the courtroom,
What time was that?
this was at 1:40.
What phone number did that call come in from?
734-508-2766.
Did you answer that phone call?
This phone does not let you answer on just the speaker, so you have to put it on, the loudspeaker, and I had Anna Duclo answer it because I was nervous. No one's been calling this phone except the court. So I had her answer it, and blank full day, Stephen's words, leave.
Is there any question in your mind but that it was his voice?
No. It
And
was
this
him.
happened at what time?
At 1:40.
Give me that phone number again. Read that into the record, that phone number.
734-508-2766.
Did you, when the person told you to leave on the other end, who you're identifying as the defendant, Stephen Crane, did you respond in any form or fashion?
It hung up the moment after it said leave. It just
Where were
hung-
you sitting at the time?
I was sitting in one of the little rooms outside, right next to a vending machine.
Next to what?
It's like the room next to the vending machine out there. I was already in the courtroom, already in the court.
Any questions, Mr. McCarty?
Oh, yeah, certainly. Ma'am, you testified that there was a text sent to you at 6:06 PM this past Tuesday saying, "What you doing?"
Yes.
And what was the most recent text before that one?
Sir, I went to text him on Monday, January 23rd at 7:40, and
Okay.
it didn't go through.
So that Monday, January 23rd was the morning of the alleged incident, correct?
Yes,
In fact, roughly a half hour or so before the alleged incident, correct?
yeah,
So between Monday, January 23rd, and when we were in court on Tuesday, there was absolutely no text whatsoever
until 6:06.
until 6:06. What you
After
doing?
court.
Okay,
What
I
you
understand that. Okay. And if you look in your history as it relates to texting with Mr. Crane, your recent history, it goes from blue to green to green to blue to blue to green. Can you explain to the court what that's all about?
Stephen has full control over this phone. And when it's not on a Wi-Fi, it will show up green and it will not go through. So that means the text I sent him January 23rd never went through.
Okay. And you have also a capacity or capability anyways to block him.
And he's not.
Okay. And so the fact that he's not blocked, at least evidence is there was no attempts to contact you between January 23rd, before charges were ever even filed, and Tuesday, correct?
Except at the school.
Well, and then that wasn't a text, ma'am.
No, but that was an
Okay.
attempt.
I'm sorry?
That was an attempt in my form of finding me.
Well, it's certainly no secret where you were. I mean, you go to the school every day, right?
Yeah. As the mother of my child.
Right,
yes.
okay. Okay, so going back to 1:40 this afternoon, you say that call came in?
Yes.
Or 1:46?
140.
1:40, okay. And you lost me a little bit about your testimony. How did you answer that call?
This phone, the speaker doesn't work, so it has to be on speakerphone.
Okay,
Anna answered it on speakerphone inside of that little room.
okay, Anna being the victim's advocate?
No, as a
Okay.
witness.
Okay. A witness in this
Well,
case?
if she needs to be, yes.
Which I
She's the one that answered the phone when that number came through.
is Anna Sophie's aunt?
Well, yes,
So she's a listed witness in this case.
yes,
Judge, wait, you gotta keep your voice.
yes.
Can we sequester that witness, Judge, if she's?
Sure,
Thank
I'll
you.
be happy to order that. No, sequestered. You're gonna have a seat out in the hall, man. Let me clarify one thing. You said 508-2766. What were the first numbers? The area code.
734.
Okay, I just wanted to be sure.
Okay, so because your phone has a certain malfunction, you have to put it on speaker to hear the caller on the other end.
Yes,
Okay, and when that happened, you overheard somebody say leave.
and yes, and then it directly hung up. They did.
Okay, and it's your testimony that you recognize that as being Steve's voice.
Yes,
Okay. So you attribute Steve to be the caller behind the 734-508-2766 number.
yes.
Do you know where Steve was at 1:40?
No, I was in a room.
Would it surprise you to learn that he was in my vehicle in the parking lot?
No,
That wouldn't surprise you.
I don't know where he would be.
Okay. You ever sent anybody a text by accident or have an unintended recipient?
No,
No, you've never done that? Never meant to text one person and then accidentally text another?
No.
Okay, thank you. No further witness, or no, further questions of this witness.
And there's no question in your mind, but that was Mr. Crane. This is really important.
yes,
I'm talking about the phone call this afternoon.
yes, I believe it was him. His voice, just the direct words of leave and then hung up. Like there couldn't even be a word said after he said leave, and it was just hung up.
All right. You can, unless you have another question, you can step down. Do you have any other questions? You can have a seat.
you.
Do you want to call somebody?
I do, Mr. Crane.
Okay. All right, so now I have Detective Cavazos. You can go ahead and proceed, Mr. McCurry.
Thank you, Judge. Mr. Crane, can you say your name for the record?
Stephen Michael Crane.
Mr. Crane, I want to focus your attention to the circumstances on Tuesday of this week, that being February 14th.
Yes,
You
sir.
recall that day?
Yes, sir.
You recall being in court that morning?
100% I do, sir.
Okay, do you recall having a bond violation hearing relative to whether or not you saw the complaining witness in this case and smiled and waved at her?
Yes, sir.
Okay. And
to the
you
court.
understood the court?
Listen,
Sorry.
listen. You're not going to help yourself if you don't just answer his questions.
Yes, sir. Yes, sir.
Okay?
Yes, sir. Thank you, Judge. You heard the judge's ruling in that regard.
Yes, Your Honor. Yes, sir.
That, I mean, to paraphrase it quite a bit, if you so much as like fart in her direction, you're going to jail.
Yes, sir.
You understood that?
Yes, sir.
Okay, what'd you do later on that afternoon?
I left court. When I left court, I went to work, got out of work. I got home to my mother's house at about 5:50, 5:55-ish.
Okay, when you got to your mother's house, what did you learn?
I found out that my youngest, my 7-year-old, had 101.5 fever, and my 12-year-old had a massive ear problem, ear infection, earache.
Okay, and your oldest daughter, what is her name?
Kylie Crane.
And how, Kylie's 11?
12.
12? And your younger daughter is?
Kristen.
Kristen, how old's Kristen?
7.
Does Kylie have an iPhone, an Android, or none of the above?
iPhone, sir.
And how about Kristen?
An Android, sir.
Okay. And where were you when you learned of their illness, for lack of a better term?
When I came home, as soon as I walked in the door, when I got to my mother, she had let me know. So I walked in to see my daughters, and Kristen was laying down sleeping still, and Kylie was laying in a dark room. And then I went downstairs, sir.
Okay. So you learned of their situation a little before 6 p.m.,
Yes,
correct?
sir.
Okay, and then you went down in the basement.
Yeah, to get my work clothes off.
Okay,
Yes, sir.
and at some point, did you text either one of your daughters regarding whatever was on your mind?
Yes, sir.
And who did you text?
At first, it was Kristen asking what she was doing upstairs.
Okay, and you recall exactly what your text was?
Yes, sir.
And what was it?
To Kristen, it was what you doing upstairs, and then I believe it was you have to wake up, because she was laying down and I didn't want her to sleep through the evening.
Well, would it refresh your recollection if you were to look at your phone and see exactly what you texted and when?
Yes, sir.
May I approach the witness, Judge?
Sure.
And what did you text Kristen on Tuesday?
Oh, what you doing upstairs? You need to come. You need to get up, sweetheart.
Okay, at what time did you text Kristen that?
6:08.
Okay, so at 6:08, you texted what you doing upstairs?
Yes, sir.
Okay, and then when was the next text rather?
Counsel, wait a minute.
6:11.
Slow down, 1 second. I just noticed the victim back in here with the victim's advocate. I just want to be clear, you only wanted the other person out, right? Or not?
Well, no, I think they both should be.
Well, I don't disagree. You're gonna have to go out. I'm sorry. Go ahead, you're out.
Oh, thank you, Judge. So at 6:08 p.m., you texted Kristen. How do you spell Kristen?
Kristen.
How do you spell Kylie?
Kylee.
How do you spell Kayla?
Kayla.
Okay. So at 6:08, you texted your daughter Kristen. Let me just get it. What you doing upstairs? And what you was WATCHA, doing upstairs, correct?
Yes, sir.
And then 3 minutes, you didn't get a response to that?
No, sir.
3 minutes later, you texted, you need to get up, sweetheart.
Yes, sir.
Okay. Now, did you also text your mother as it relates to that particular time period when you didn't get a response from Kristen and she was sick?
Yes, sir.
Did that concern you?
Yes, sir.
What did you text your mom and when?
I believe it was around 6:11.
Let's not believe. Look at your phone
Oh, yes,
and
sir.
tell me when you texted your mom.
I texted my mom at. Sorry, sir. I texted her at 6:11. Is Kristen up?
Okay. And your mom replied when?
At 6:12 and said, yep.
Okay.
And then I wrote at 6:12 also, I was gonna come up to wake her up. Sorry.
Okay. So at least by then you understood whatever you were inquiring about Kristen, or whether she was up, she had to get up. You were satisfied in your mind that that
Yes, sir.
situation was taken care of. Now, I want to take your attention back to 6:06.
Yes, sir.
2 minutes before you tested Kristen, what you doing upstairs, you texted what you doing to Kayla, didn't you?
I'm asking, yes, sir.
Did you tell the judge the circumstances of how you texted Kayla? You haven't texted with her since January 22nd, how all of a sudden after court you texted what you doing?
Your Honor, I, excuse me. I was very shook and distraught with court. I went to work. I seen my daughters. They were sick. I went in, excuse me. I went in my phone. I hit K. I was trying to text my daughter. I realized, wrote what you, and I seen doing. I realized it went blue. So, and I seen it wasn't Kristen. I honestly tried to hit X to erase the message, and I hit return. It sent the message. I immediately freaked out, went into my phone, tried to delete the message, thinking that it wouldn't send because it did not say delivered. And then that's when I proceeded to text my daughter to make sure my kids were okay. I thought I caught it in time.
Okay, so you screwed up at 6:06.
Wait a minute, I'm not quite understanding though. You went to text your daughter.
Yes, sir.
You saw that you accidentally texted Kate.
Well, as I was texting her.
Am I right or not? I want to understand.
Well, after I wrote what you're doing, I realized that it was Kayla and not Kristen.
Okay.
And I tried, if you look on an iPhone, so where the X is, there's a blue bump below it. I instantly started shaking because I realized I was not Kayla. And I promised to the court, I tried to hit X. And I sent it on accident. And then I went into my phone trying to stop it because it did not show delivered. So I thought I was still blocked, like I had been on the phone. I did not know I was even unblocked. I tried to erase it to stop the message from going, Your Honor. I did not intentionally. I was more worried about my kids and I was shook. Your Honor, I heard what you said loud and clear. I have full custody of both my daughters and I was not trying to make you look stupid or anything. I did not mean to disrespect the court. It was 100% accident because my kids had 101.5 fever. She was laying down and it was just a very bad day, sir.
Sir, and if you were to give your phone to this detective right now, would you be okay with him doing a forensic analysis of that phone?
You can have my phone,
you
sir.
You can dump it right this afternoon and find out
100%.
what exactly you did in that regard.
100%.
So you sent a text to Kayla, correct?
Yes, sir.
You didn't mean to?
No, sir.
Okay.
I have too much to lose right now. I would not disrespect you, Your Honor. I promise you.
Okay. It's not a question of disrespecting me.
No, I understand, Your Honor. Well, I know I didn't.
It has nothing to do with it.
No, I meant or to even contact her. Is what I meant, sir.
Point well taken. Again, aside from any respect, you did not intend to contact Kayla. In fact, your intention was to the absolute contrary.
I promise.
Not to have anything to do with her. Okay,
100%.
I'd like to draw your attention to the circumstances of this afternoon. Okay, you and I were speaking by phone as I was heading to this court from my location in Holland, correct?
Yes, sir.
And I told you my estimated arrival time, correct?
Yes, sir.
And when I pulled up, I had you come in my vehicle, correct?
Yes, sir.
And we discussed how it is that when you went to text somebody with a starting initial.
Listen, I know there's no prosecutor here, but still, you can kind of not lead quite as much.
Okay. So we discussed the allegation of an unintended recipient of a text.
Yes, sir.
Letters with a K, correct?
Yes, sir.
And using your phone, we showed how you could go to text John, but hit me instead.
Honestly, you're leading.
Okay, so you sent me a text from your phone in my car? That's still legal. Okay, what did you do in my car?
When you pulled up, sir, it shows on camera, you pulled up next to me and my mother. I got in your car. We started discussing. There's text right here that you texted from my phone at 1:39 saying, "Hey, John," just to show it go through your phone so you can understand the green and the blue, or yes, the green and the blue matter of the text messages.
And how somebody could mistake John for Jeff or Jay.
Yes, sir.
And that is at what time?
1:39, sir.
Okay, so your phone says 1:39 and my phone would say 1:39.
Yes, yes,
And
sir.
supposedly a minute later, you called Kayla?
Counsel, come on.
Well,
I know.
okay, so you were in my car for how long?
Roughly 5 minutes, and then we're on camera coming in,
Okay,
sir.
so whatever the camera shows out there as to when we pulled up and when we entered the court was how long you were in my car, aside from the time that you texted me at 1:39.
Yes, sir.
Okay. You didn't cause anybody to call Kayla? You didn't call Kayla?
No, sir.
In fact, if you look at your phone, there's not going to be any phone calls since the time you were in my vehicle.
No, sir.
I have nothing for.
Do you know who's the owner of the phone by any chance? I'm just asking.
No, sir, I do not.
Listen, you haven't even let me finish.
Oh,
my
I'm sorry.
question. Of 734-508-2766. Do you know?
No, sir, I do not.
Are you sure?
I use number. I do not recall anybody with that. I can look in my phone contacts, but I do not know that number. No, sir. I would never have anybody call either,
You're
sir.
telling us that you did not call Kayla and say leave.
No, sir, I did not.
Do you know who did?
No, sir, I do not.
Your Honor, at the,
I was going to call you as a witness, but you could probably do it right here.
yeah,
No, I want him to be a witness. I want him to be a witness.
Okay, well, I have no further questions. If Your Honor has.
No, I don't have any other
We
questions.
can recall or whatever.
Yeah, you can have a seat. Do you have any other questions?
No.
You want to come on?
sure.
Raise your right hand. You solemnly swear affirm that the penalties of perjury, the testimony you give in these proceedings will be the whole to yourself you got.
I do.
I have a good mind to call that phone number right now. I might just do that.
Yeah, please do.
I will. Go ahead and tell it.
Your Honor, at the defense's request, I looked into that phone number, contacted one of the other detectives at the police department. We put it in our investigative tool to find out where the number came from. The number is registered as a bandwidth number, which in my experience, and training and experience, is commonly used to masquerade. These are unregistered numbers that people can grab the number and masquerade that the number is actually coming from a different device. It's not attached to a device.
So somebody can use that to disguise the fact that
Absolutely.
they're calling from, they're the one calling even though it's not from their phone.
Absolutely.
Well, if I may, Judge, so it would, let's assume for the moment that Steve used this phone to call her, it would instead of showing up Steve's number, it would show up this masking number, correct?
I can't say that that device would record, would depict that a phone call was placed from that using a bandwidth number. I don't have the expertise to say that.
Well, you can certainly tell whether a phone call was placed from this phone.
Absolutely not.
No. Whether a call was made at 1:40 this afternoon from this phone.
I cannot.
Well, you might not be able to determine whether it was from 734-508-2766, but you can tell whether a phone call was placed.
No, I cannot.
Okay, so you don't have the expertise or it's impossible?
I'm saying that I don't have the expertise.
You know where Mr. Crane was this afternoon at 1:40?
I do not.
Okay, so you don't have any ideas whether he was sitting in my car?
I don't.
Is that parking lot surveilled?
I believe so.
Would you care to look at the surveillance tape and determine when he entered my car and when he exited my car?
I would look at it if that's what the judge would like me to do.
Well, I think it's pretty important if the suggestion is that my client made a phone call and told the complaining witness to leave. And I think that's a crime. That's not just a bond violation. This is a witness intimidation. That's a crime. And lying about that.
I know, but finish your question.
Okay, so if we could take a break in this here and you could go to a resort and look at the cameras and find out when he got in my car, when he got in my car, when we both came into this courthouse.
I believe that it would say that. I don't know for sure. But even if he was in your car, that wouldn't tell me whether he placed the call or not.
Unless I took the stand and testified as an officer of the court as to what happened in my vehicle. Judge, you know, we're so far afield now on the realm and the cusp of perjury that I think that this is vitally important. And I'm willing to have this detective do whatever is necessary for as long as necessary to determine when Mr. Crane was in my vehicle and for how long and when we exited. And I will testify as to what took place in that vehicle. The suggestion that I suborned a crime, that someone was going to party to.
Suggesting that you suborned perjury or suborned any type of, were a conspirator to commit a crime, obstruction of justice, intimidation of a witness, whatever you want to call it.
Okay, well, I appreciate that. Okay, I appreciate that.
So,
but
well, I mean, come on.
Well, it's very, you know.
Wait a second. Do you have any other questions?
No, I don't.
Do you have anything else?
I don't, Your Honor.
Go get those witnesses in here.
Okay.
Well, I don't know, I necessarily want anybody to testify, but I suppose we could recall Ms. Ducal if the court wanted to hear from her relative to, you know, she did hedge her bet at the end, I believe.
Well, you asked that the witnesses be sequestered. I'm just wondering who you wanted me to call, bring up for you, whatever you wanted me to do.
Well, and again, this is how we're getting approaching the realm of, you know, burdens of proof and discharges of saying, I don't know who's.
You let me worry about that.
Okay. But
I could have done one of two things, just so this record is clear. I did not have to afford him a hearing immediately. I did not want to wait till Tuesday. The Wayne County Prosecutor's Office is so incredibly overstaffed, they could not have sent me anybody unless I made jurors wait in the juror assembly room tomorrow, because it just so happens Mr. Kazak will be here. Well, I was trying to get to the bottom of this as quickly as I could, so I could make a decision as to whether or not there was a violation of the bond without having to have him sit in jail for 5 days. So I just need this to be clear.
Judge, I respect that. And
Okay.
I'm with you, and I thank you.
Okay, so you asked when Ms. Duco,
I suppose in light of the testimony, we can ask her, we call her to the stand and ask her how sure she is about the voice that she claimed she heard. Because I believe at the end, she hedged a bet of it and said, I believe so.
But she was, hang on, but you asked, I just want to make sure we're on the same page. You asked when she was testifying that the victim's advocate, that both of them leave, right? That's what you asked. You asked to sequester witnesses. Ms. Duco was already on the stand.
Correct.
So did you want to call one of them?
Well,
if you don't, you don't.
We could call Anna Duco to the stand, but then that would have Kayla Duco be sequestered.
Okay, is that what you want? I want your client.
Yeah, I think if we're gonna get to the bottom of what
Come on up
did or
here.
did not happen at 140.
Ms. Duco, Kayla, why don't you have a seat out there, please?
Would you like me, Your Honor?
Come on right up here to the witness chair, please. I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury the testimony you will give in these proceedings will be the whole true self you got.
Yes.
Can you have a seat and spell your complete name for me?
My name is Anna. Last name is Gardner. Now I got married last year, so it's Gardner.
And what was your maiden name?
Duplo, Duclo.
And so Kayla is what relation?
She's my cousin.
All right. Were you were initially in here
Yes.
when Anna testified that there was a phone call received sometime around 1:40 or 1:46 this afternoon
Yes, sir.
from a phone number 508-2766. Were you not?
Yes, I answered the call.
And why did you answer the call?
The phone was next to me. She was talking with Rachel and going over stuff and it started ringing and I said, should I answer it? Because it was a number we did not know. And you have to put that phone on speaker. So I answered it and hit the speaker button. Because if you hold it to your ear, you can't hear anything. That speaker on top is broken. So I hit answer and hit speaker. It was on the table in front of everyone. And it was like you heard chatter for a second and then leave. And then it hung up.
Do you know Mr. Crane?
I know him, not like close with him, but I know him. He's been in my house. I've been in his house. He's been with my cousin for years. So yes.
Okay. And do you recognize his voice?
Yes.
Can you identify who the caller was?
It did sound like him, yes. Of course, I can't say 100% because it was not his phone number, but it did sound like him. And nobody has called that phone except for the text she got from him and the dentist office and the courts. So I answered it because I wasn't sure if it was going to be someone from a police station because she was called from the police station that we had to come here today. So that's why I answered.
Do you have any questions of her?
I do. You indicated that there was chatter for a second?
Yeah, it was like you just heard like a background noise, like just noise in the background when you answer a call. Like it wasn't dead silent in the background. And then you heard leave and then it clicked.
Chatter in the sense of people talking in the background?
I don't know if it was people talking. It was just noise. I guess chatter was the wrong word, but just like noise in the background for a split second. I said hello. Noise in the background, and then all you heard was leave, and then the phone hung up.
Hello.
Yes, I said hello
Okay.
when I answered the phone call.
So it wasn't, Anna didn't take control?
I am Anna, yes.
I'm sorry. Kayla didn't take control of the phone?
No.
Once you answered?
Correct. It was just on the center of the table
Okay.
on speakerphone.
And would it surprise you to learn that Kayla didn't mention anything about chatter or any other noise besides leave?
No, it would not surprise me. She's been very flustered these last couple of weeks, so.
All right. Do you know where Mr. Crane was this afternoon at 1:40?
I do not know.
Okay, you came here with Kayla or no?
Yes, I drove her here.
Okay, and when you got here, did you see Mr. Crane's mother's vehicle?
It was not here yet. It pulled in as we were walking in the door.
Okay, so you did see Mr. Crane pull in?
I saw his mother's vehicle, if that's who he was with, yes.
Okay, what time was that?
I'm not sure.
Okay, thank you.
We got here at about 1:30, I think it was about then.
Okay, you don't know when I got here?
No, I do not.
Nothing further to.
Is there anything you would like me to ask him, Sergeant? Ask her?
I don't think so, Your Honor.
Ma'am, thank you very much. You could step down. I'd like you to do me a favor and send Kayla back in.
Yes, sir.
Yes, ma'am. And you are still under oath, okay? The phone that you have now, when did you acquire that phone?
Which one? The one that I'm
The one
using?
that you were called on this afternoon?
We're on the same plan. We got it maybe 3 years ago. I've had that number for maybe 3 years now.
Okay, I thought you said something to the effect, the only one that's called you was, I think you said the court and your dentist. Didn't you say your dentist?
Yeah, no one's been calling me. I've been by myself. I haven't,
Did you see Mr. Crane on your way into the courthouse today?
as I was walking in, he pulled in his mom's Jeep. Like he was pulling in right as I was walking in.
How long have you two been together?
Would be almost 5 years.
And you said, Ms. McCarty's correct, you did say, I believe it was his voice.
Yes,
I don't know what that means. I want to be sure. Are you certain, 100%
just
certain?
the tone, the way it was said to me, like I believe it was him. Just the way it was said, the tone in the voice, the sound.
Do you have any other questions?
What did you hear before leave?
It was just leave
Nothing else?
and then hung up.
Anything else?
No, you don't have.
You can step down.
I can.
Do you have any other witnesses that you want to present? Any other witnesses you want me to make come up here and testify?
Well, to the extent necessary, I'd like this detective to look at the surveillance camera, unless you want to take judicial notice of the fact that we were in my car at the time in which this call was allegedly made to this witness. I think a follow-up in that regard would be do a dump of the witness's phone to determine who called her, when, and on what frequency. If she's had that phone for 3 years, her testimony this afternoon, and nobody calls her but the court and the dentist. And I think that stretches the bounds of credulity. I mean, the upshot of this, Judge,
I'm really concerned about this at this point.
yeah, I am too.
Hang on.
The upshot of what.
Hang on, let me finish. Anybody who was listening to me on Tuesday, well, I never really said I find that there's a bond violation. Anybody who was listening to me would have known, or I did a horrible job out of explaining myself, that there was no doubt in my mind, but that Mr. Crane had contact purposely. I wanted to give him the benefit of the doubt. I did not want to revoke the release. I did not want to forfeit the bond. I don't know that I used the word that you used in court or about anybody who was listening, but I do know that I made it abundantly clear I wanted there to be no contact. To say that I was shocked this morning when I'm receiving this testimony. And now, so what I'm left with, Mr. McCarty, is two things. I'm left with somebody now telling me that they texted her accidentally. Which I can't imagine doing after a judge just talked to me 8 hours early. And that somehow, some way, somebody called right when she's in court and said, leave. It was neither Mr. Crane nor anybody else affiliated with Mr. Crane. I'm 64 years old. I don't know how long I've had a cell phone now, but I don't ever remember just having somebody call me up, say, leave, and then hang up. And how ironic it happened when somebody is in a courthouse. Now, Mr. Crane, I found to be very unbelievable the other day. I really did. He pushed all the buttons. He pushed all the buttons of what I've learned in my career here as to why and how people lie or how I can detect liars. So somehow, some way, within 4 or 5 minutes of the time that she's supposed to come in, maybe 10, I think I initially told everybody to be here at 2, but I don't remember. Or 15 minutes while in a courthouse, while within a few minutes of driving through the parking lot into the courthouse and sitting in the courthouse, I either have to be that she's totally contrived the story, which has been corroborated by her cousin to the tune that somebody called and said leave, or suddenly, somehow, some way, somebody called and said leave, even though she probably has never received such a call. At least I had. At a very crucial time when everybody knew that I was summoning everybody for a bond violation. I would have thought, I don't want to know what he told you, that's attorney-client privilege, but I would have thought if I violated a no contact provision that a judge said, and I can't imagine doing that accidentally, that I would have called my lawyer. In other words, his defense seems to be he was intending to text somebody else and accidentally texted this young man.
and tried to unsend it. I thought he did.
And then somehow, some way she gets this call leave while she happens to be in the courthouse from the phone.
And Mr. Crane.
So I'm gonna let you argue, but I'm not directing this detective to do any investigation. If you want to do that, you can do that. If you want to ask them to get the surveillance video, you can feel free to do that. But I'm gonna make this decision now. I think it's that important, that serious, that when somebody was told not to have contact, did have contact, the judge chastised them for 5 minutes. And 10 hours later, he's going out and having contact. And then so incredibly, she gets this call leave right when she's in the courthouse to testify regarding the bond violation. Now, I grant you don't have a smoking gun where there's 20 witnesses watching somebody pull a trigger. But if that isn't circumstantial evidence that he committed a violation of the no contact provision intentionally, I don't know what is. So I'm going to listen to your argument, and I'm going to make up my mind. But he scares me. Put your hand down.
Sorry.
You know, I've been doing this a long time. I've seen every type of person come in here and try to tell me things that just aren't true. Now, I thought I was pretty good at determining who was a liar before I got here. And I got to tell you, you cannot sit and listen to 250,000 cases over the course of 29 years and not become exceedingly good at it. It's almost impossible. So just let your lawyer do his job. So that's what you've got to contend with. This is not personal with you, Mr. McCarty. It's your client. Your client is not listening to instructions from judges. And this is not personal. I mean, I love it when people say your court. Nobody's ever here. Never one time in 29 years have I sat here and said MYCOURT, not once. Nobody's ever heard me say that because it isn't mine. I don't see a deed on the wall. Nobody's gifted me, willed this, and this is not about me. I just happen to be this guy that somebody trusted 29 years ago, and people continue to trust to sit here. This is about our system, though. And I'm not going to put up with people that think they can make their own rules. So you got a lot to argue and contend with here because I'm not changing my bond unless you do some real fast talking here. I'll listen to whatever you have to say.
Well, certainly my intent is not to talk fast or slow or anywhere in between, but to try to arrive at the truth and justice here.
Of course.
And the truth of the matter is my client sent a text to Kayla at 6:06 p.m. on Tuesday, the day we were in court. Now, another truth is, if you look at that phone and do a forensic dump that I've offered, and I'll consent to release of it this moment while he's in custody or anywhere in between, that he attempted to unsend that and thought he had done it. Otherwise, he might have called me and said, hey, I just screwed up. But he didn't. What he did do is after he sent an unintended or a text to an unintended recipient, he immediately then turned around at 6:08 and texted his daughter. And then again at 6:11, and not hearing from her, texted his mother. Now, what he's now establishing like an alibi for this. He's establishing a defense when he gets called into court on a bond violation. Oh, I've got it all figured out. I'll show him this is why I did it. That's preposterous. The man plows snow for a living, but he's sophisticated enough to use some robocall as he's sitting in my vehicle. As we're told about a hearing about an hour and a half ago, he put it all together and figured out how to do a robocall and called this complainant and said, leave. How is that even possible?
I didn't say he did it.
Well,
I did not. If you listen to me carefully, I said him or somebody else.
Well, okay, but they didn't say somebody else's voice. They said it was his. And this witness sat up there and told you on the basis of one word. And while she hesitated to say she can't be completely certain, I believe it's him. Now, Judge, we didn't even find out about this until later this morning.
Well, no.
And right. And so, but you have to understand, so how is it that he established this timeline of text back at 6:08 and 6:11 and then 6:15 with his mother, thinking that this was going to come up. I mean, that's like creating the alibi, before the crime is even reported. This doesn't make any sense, Judge. It just doesn't.
So all these were just a mistake. It's your
No, absolutely. Hey, Judge, the other day, I went to text an opposing counsel, Chris, and sent her a copy of the Michigan Bad Government regarding surrendering of your license. And you know who I sent it to? Chris Creighton, my son's head football coach at Eastern Michigan. Now, that was embarrassing. That I sent a private communication between me and opposing counsel, Chris Anderson, and I sent it to the head football coach at Eastern Michigan. And I'm a lawyer, and I'm here to tell you I make mistakes.
Of course.
And so he's got 3 Ks in his life, Kayla, Kristen, Kylie, and he sent it to the wrong one. And as soon as he realized it, he tried to undo it and thought he did. And then he went and took care of what he tried to do, his business, so to speak. Now, and that's all in that phone. And it can be analyzed and be discovered. I'm not trying to hide anything.
You can feel free to have it analyzed.
But Judge,
I'm not ordering them to, and the court's not about to undertake that.
Okay, I appreciate that. But what I'm suggesting is to entertain the possibility that this was unintended. And he did it, but he didn't mean to do it. And it doesn't make any sense, not having any contact since January 22nd. All of a sudden, you read him the riot act, the come to Jesus speech on Tuesday, and then he's gonna text her, "What you doing?"
Well, he did have contact with her since the nature of the hearing happened. That was contact since January 22nd.
Well, to the extent
I'm
you're
talking about the contact that had occurred that I heard about on Tuesday, which was what, the 14th?
Tuesday was the 14th, and I think
I
it was
believe
the
the
week.
contact. Now, listen, you probably I'm sure you're busy, but I probably only had 100 people in front of me since he was in here Tuesday, if not more. But my recollection is that the contact had happened the day before.
It was the week before.
Okay, well,
that's close.
So that's not truthful when you're saying that he didn't have any contact with her from January 23 until the night of the 14th.
Well, let me clarify that and specify. He didn't have any text conversation with her since, it's frankly, like the majority of us how we communicate. And to me, it doesn't make any sense how he would go from January 22nd to Tuesday, the 14th.
I know a lot of this doesn't make sense. Every day.
I know, but
every single day.
I think
no, I agree with you. A lot of it doesn't make any sense.
Right. But it further doesn't make sense that my client is somehow sophisticated enough to create a defense to a violation of probation that's not even been, asserted yet. And we don't even know about it until this morning. And then somehow, between getting off of work and having his mother give him a ride here and me coming down from Howell, he's sophisticated enough again to create this robocall and a message of
The court's convinced. Did I let you finish?
Hey, Judge, I'm not going to stop the train.
I know.
get it.
I'm just asking if I let you finish. The court is convinced somebody called and said leave. The testimony was that the belief was that it was the defendant. I told the defendant not to have contact. He was told that by my co-judge here, my colleague who set the bond, I believe, initially, not to have contact. He had contact last week. I admonished him on Tuesday. I didn't forfeit his bond. I didn't revoke the release. And I'm just convinced he had contact, not on one, but on 2 occasions, now 3, if you include the one last week. The bond's forfeited. I won't set 10,000 cash. It is going to be 4,000 cash. Do it again, and we're going to have a big problem. Take her out of your phone. Do whatever you got to do. 4,000 cash. Bond conditions otherwise continued. I will see everybody here. Counsel, I signed your order.
Yeah, thank you.
You have a funeral. I understand. I'm sorry for your loss. We're going to do it March the 7th at 10, but you can't ask me for another adjournment, okay? Good luck, sir. You're going to have to post your money or have a seat over there.
That's fine. Thank you, Judge.
March 7th at 10, okay? And I'm sorry for your loss. Good luck, everybody.
St. Francis.
You're gonna be able to, you're gonna post a $4,000 bond. We have a conference call, yes.
Oh,
Dan, Tony. You did your phone with.
Oh, I can? Oh, I
This,
didn't know.
hey, this.
Oh, this one.
So I'm gonna take one back, I'm gonna transfer, it's gonna get transported on the front. You can either hear it till 4 o'clock or. You got anything you wanna give to them, like sign any packets or anything? Right.
His name is Kenny.
Oh, damn.
Dan.
I had something I did done first, then
I've called the governor's office. They're doing an
Speak again, ma'am. I'm just going to remove you from the courtroom. I expect this to be followed. So you missed 4 weekends since
I
you
can't
insisted
hear.
on your time? Four weekends shall be made up, so he gets to see the girls
hear
every
anything.
weekend from now
I
until those
can't
are
hear
made up.
anything. Your Honor, please, I beg you, please listen to me, please. I have things that need to be said. I'm not being listened to. Please listen to me. Please listen to my
Ma'am,
kids.
I've listened to you ad nauseum for more hearings than I care to hear about again. I'm removing you from the courtroom.
Get in the car. My children will.
Hey everyone. So I have been accumulating a folder full of clips with freakouts, meltdowns, and hissy fits. And these should be all new clips, hopefully, except for, the classic that I had to throw in there. So I hope you enjoy them.
Call Cody Eichler, file 230115. Mr. Fry is his attorney. Please place your appearance.
Alex Bayoneto for the people.
Mr. Eichler, your attorney, my understanding, is in a trial. Obviously, I'm not going to require you to go forward without your attorney. This was scheduled on the 23rd, and of course, the court was closed on the 23rd due to significant inclement weather, both the 23rd and 24th. So Mr. Fry most certainly did not schedule something when he knew he was going to have an attorney. I don't find it his fault, but I also, I'm not going to proceed with Mr. Eichler not represented. Mr. Eichler, you're muted, so if you want to say anything, you have to unmute.
I don't know if that trial went forward, Your Honor. I just know it was scheduled. And when I left, Mr. Fleming was preparing for it as if it were going. So
is there any way that I can wait until he gets out of the trial? Because I'm on parole, so none of this time counts. So the more, this gets prolonged, the more, I don't get time served. Like I'm already on the sentence. They brought this charge up 6.5 months after I've already been in jail.
Mr. Eichler, what I show on this case is a $500 cash or surety bond.
Okay, but I'm on parole though. And with me being on parole, none of my time counts.
Well, this does show a $500 cash or surety bond.
I know, but I'm telling when I go to get sentenced for this, I just got sentenced for my felonies. I got a year in the county. Well, I did 3 months, fighting my case. And they gave me a fresh 10 months because with me being on parole, my time counts. My parole, but it don't count.
Then we'll set this as quickly as we can, all right? You said Thursday? What time?
You crazy, bro.
Okay, we'll set this, the fastest the court can get you in is Thursday, March 2nd, you said 10:30? At 10:30 in the morning. Okay?
Wow, man, they're all right. Shit crazy.
As I said, we'll get you in as fast as we can.
I know what I'm saying, but why is my court date keep on getting prolonged? Like this ain't my fault, you know what I'm saying?
Unfortunately,
Mr.
Eichler, unfortunately, we can't control the weather. It was scheduled late last week, but due to ice storms, the court lost power. So we will set it for Thursday, March 2nd, 2023 at 10:30. And that is all for today.
Sir, you're here on a writ of bodily attachment out of Marion County. That means a child support hearing officer and a circuit judge there determined that you owe some child support, and they set a cash purge of $1,684. Unfortunately, because it's a Marion County writ, I can't do anything about that amount. If you had that much cash, you could get out of jail here. If you don't have the cash, then Marion County will have 5 days to come pick you up. When you get back to Marion County, that judge would have an opportunity to lower that purge amount for you, all right? Thank you.
I don't have any money.
All right, sorry. Sarah, have a seat. Leonardo Morales?
you. So, Ms. Vivian, prior to court today, I had a chance to review a probable cause statement on a protection order violation. I did indeed find there was probable cause to have the answer to that charge. As a result of that, you have several very important rights, including the right to remain silent, right to an attorney, right to a court-appointed attorney if you qualify, the right to hear witnesses testify for or against you, and the right to an appeal after a jury trial. Do you believe you qualify for court-appointed counsel, or do you plan on retaining your own attorney?
I just don't think it matters. I think you already have a decision, so there's no point in fighting it.
Well, you do have
The world that hates women, so it's fine.
I'm sorry,
That's what you do.
I can't hear you.
Scoot closer to the microphone.
Why can't the microphone be moved closer?
Well, it can, but if you scoot closer also, then he can hear you better.
Ma'am, did you say you do or don't want court-appointed counsel?
I mean, there's no point. You've already made a decision. Having someone represent me doesn't change that. My brother broke my finger, and yet he's the one who has a restraining.
Ma'am, I would recommend not speaking about the facts of the case at this point.
So I've made a decision that there's cause to have the answer to this particular allegation. I'm not indicating that you're guilty by any stretch of the imagination. But you do have the right to an attorney that may be able to assist you in presenting a case to the court or a jury that would benefit you more than trying to do it on your own.
It's just this whole thing is a waste of time. My brother broke my finger. He then gets a restraining order on me. I came for clothing because if I'm not supposed
We're not
to
going
be
to
there,
try your case today. So I'm going to go ahead and.
all of this is just to waste fucking public money. How much money is being spent on this? It's very clear. If they don't want me at their home, just let me have my things so I can go. By holding my things hostage and then breaking.
Ma'am, we are on the record. I would just. This is not the time or place to be getting into that.
So I'm going to go ahead and point the Office of Public Defense to represent you. You're going to get their contact information. If you bail out, you need to contact them and meet with them. If you don't bail out, they'll be over to see you in the jail. I'm going to hear from the state now with respect to your potential release.
The state requests standard conditions of release.
Okay, so Ms. Vivian, you're going to be released later today unless you're being held on something else. I'm going to give you 3 dates to return. You're also going to receive these dates in writing. The first of which is a pre-trial date of March the 16th. That'll be at 1 o'clock in the afternoon. I'm going to set a readiness hearing of May 11th. That'll be at 9 a.m. With a trial date of May the 22nd, that would also be at 9 a.m. The first 2 of those dates will be on Zoom in courtroom 5, and the last one will be in person at the Hall of Justice. Since it appears that you're probably being released, I suggest call the Office of Public Defense today and set up an appointment with your attorney. Do you have any questions, ma'am?
No.
Okay, thank you. That'll be all.
Good morning.
What's your name?
Shannon Walker.
Mr. Walker, you're here under probable cause affidavit. It looks like, and then I'm going to set your bond today. Looks like possible charges are criminal threat, aggravated battery, and then interference with a law enforcement officer. What's the county attorney's position on bond for Mr. Walker?
Your Honor, I would notify the court that I would have a conflict as to any cases moving forward filed against this suspect or defendant. With that being said, I certainly could handle a portion of this hearing without notifying the court of any like confidential information I may have or may not have. It appears from the 48-hour affidavit that the possible charge could be a level 4 aggravated battery. That'd be the top count. The state is also aware from our internal record system that he's currently on probation with CSO. Given those 2 pieces of information, the state believes that it is appropriate for the court to put in place a $50,000 cash or commercial surety bond. I think Ms. Greenwood could speak to whether or not court services intends on putting a hold on him for his current probation case.
Ms. Greenwood?
We will do a hold.
Okay.
Is there any way to do a not court services, but corrections bond? Because I've got 2 cats and 2 dogs at home that
There
Haven't been
actually
taken care of
isn't,
since Friday.
actually isn't any way to do a corrections bond as of right now. I'm gonna set your bond, there's a hold already, or there's going to be, I'm gonna set your bond at $50,000 cash or commercial surety. If you happen to bond out, make sure you follow the bond conditions, that you make all your court dates, stay in contact with your attorney. If you have an attorney, or if you get an attorney for this case, stay in contact with them. You can't possess or consume any illicit drugs. You're gonna be, hang on a second, you're gonna be tested randomly. If those random tests come up positive for illicit drugs or alcohol in your system, you're gonna be arrested, because you'd be violating your bond conditions. There actually will be a hold, so even if the bond were an OR bond, you wouldn't be able to get out because there may be some violations on some probation. Did you have questions? And I'm going to caution you as to what you say, because you're not represented by an attorney, and sitting, the county attorney's office is sitting here, it's being recorded, so you don't want to implicate or talk about the case in any way. Go ahead, though.
But how is there gonna be a hold, Teresa, just out of curiosity? Because I really actually didn't do this. I want to be able to.
She's not going to be able to talk about that. It's not going to be litigated today. You'll be seeing about that here in a next day or two to talk about what the next steps are, okay? That's all I have for you today.
Well, then, since this is the case, then I'm gonna catch more charges, because I'm gonna fuck up your guards in here at the same time, because I didn't do a fucking thing.
You'll probably get another charge on that
Good.
statement. Thank you.
Well, it sounded an awful lot like a criminal threat.
Trying to repeat this one moment for the last one.
All right, got you guys. How are you?
All right, there we are. All right. This is a citation that was issued on January 24th of this year on US 131, Door Township, Allegan County, State of Michigan. This is a civil infraction for improper lane use. Mr. Joyner, you are here on this citation to do one of three things. First is you could admit responsibility to the citation, or two, admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened. Or three, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
Contest.
All right. Then even though I cannot see you, I'd ask that you to raise your right hand the same way I would ask the officer to raise her right hand. Swear you in.
All right, no problem.
And Officer Shipper, you want to raise your right hand?
Sorry, is that of you?
Swear or affirm that anything you testify to here today would be the truth, the whole truth, and nothing but the truth.
Yes.
I do.
All right. It makes a lot more sense, Mr. Joyner, for me to start with the officer. She has the burden to establish to me why she issued you a citation in the first place. But after that, you'll have the opportunity to either ask questions or testify on your own behalf. All right?
All right, I appreciate it. Thank you.
And with that, officer, you want to pick up the narrative somewhere where it makes sense and explain the issuing of this citation.
You might want.
Yep. On January 24th.
Okay. I'm done.
I was sitting just off of 129th Ave.
Mr. Joyner,
And
we're in the middle of a hearing. I can't have you talking to someone else while the officers testify.
I apologize, sir. I'm at work. I'm just walking out. I had to. Yeah, I'm ready. I'm all here.
Right. All right, officer, you want to start all over again? Sorry about that.
All right. On January 24th, I was sitting in an empty lot on 129th Avenue. I observed a vehicle go by at a high rate of speed. I and enter the highway going northbound. So I got on and tried to pace it. It was going the speed limit, so or a little bit over, whatever. I slowed down and was just conducting patrol northbound on the highway there. When I observed a vehicle in front of me that was in the left lane that seemed to be moving at a higher rate of speed, and I observed it go over the center line. It was in the left lane. I believe it was like close to the 6 mile marker. So I caught up to the vehicle and I observed it again go over the center line with both passenger side tires. And at that point, I made a traffic stop at the 6-8 mile marker on the vehicle and made contact with the driver, who was Mr. Giner, and spoke with him. And ended up giving him the civil infraction for the improper lane use due to him being in the left lane and going over the center line multiple times. Gave him verbal warning for speed as he admitted to going 80, and a verbal warning for no proof of registration, or no registration, because he was unable to provide me with it.
Okay.
All right. And then Mr. Johnny, what is it you'd like to tell me?
So, wow, a couple things. One, the reason I'm here today, I've never contested a ticket in my life before. I understand it's $100 ticket, and I would have no problem paying that if it weren't for certain facts of the matter here. I was leaving the Gun Lake Casino, watching a basketball game and having dinner with my girlfriend on that night. I had not drank anything. I was leaving the gas station, actually right off of the highway. And when I pulled onto the highway, apparently this officer was parked at the gas station where I was. So she saw me get my gas, get back in the car. I think we grabbed some stuff some snacks out of the gas station, but she told me she was parked at the gas station when I left. I pulled onto the highway, onto the ramp, and I came down onto the ramp. As soon as I got onto the ramp, I saw an officer had someone pulled over. So that kind of was like a red flag to me, like, dude, they're out here tonight. Be careful. Don't be speeding, drive like you got some sense, right? Although I do that anyway. But I passed this officer who's got his lights on. As soon as I get on the ramp, I see this officer. Apparently, this officer here, Mrs. How do you say your last name? Skipper?
Skipper.
Ms. Shipper was on a different route. How she found herself. Just take a message. Just take a message, and we'll call them back. Sorry, guys. So, Your Honor, we're taking this. I'm jumping on the highway and I'm headed home. This officer, Ms. Shipper, gets on the highway behind me, follows me for over 2 or 3 miles. Okay. I had no idea that there was an officer behind me. I wasn't drinking. I was very aware of my surroundings. I was driving a brand new car, and it does go fast, and I could have been speeding. However, I wasn't. I was maintaining the speed limit and driving like I had some sense. This officer pulls up behind me with her bright lights on, and she's blaring her lights into my back window. I'm in a Camaro, so the back windows are so small, I can hardly see. It's a brand new car as well. I just bought it 3 days ago. So I'm not used to driving in this car. I see these bright lights in my eyes. And so I go to switch lanes to get that car from behind me. Okay, she's right up on my tail. The lights are hitting me in an uncomfortable spot. I go to switch lanes, and as soon as my tire cuts the lane to go to the left, I was in the right lane, driving the speed limit because I just saw this officer pull someone over on the highway. So I knew not to speed. When I saw the officer, and when I saw these lights behind me, I pulled over to the left lane. And as soon as I moved my tire, I wasn't even in the lane yet. I didn't signal. I'll say that. I didn't signal, but I did pull my tire to go left, and she hit her lights. And then I pulled over and let her, approach me. This is a formality. When she got to the door, my window, she asked me if I was drinking. I saw you speeding onto the ramp. Did you clock me, ma'am? She said, no, I didn't have a speed limit on you, but it looked like you were going fast. I said, well, I saw the cop right there as soon as I got off on the ramp, so I knew not to speed. Here's my driver's license. It's a brand new car. So, I never got registration. You know, here's my license, here's my insurance. And so she cites me for reckless driving and tells me that she didn't have a speed on me. But when I came
All
onto the ramp,
right.
I was going too
Now,
fast.
listen to me. I'm going
It's
to let you
ridiculous.
keep testifying, but I'm going to stop you before we get too far in the weeds. You do not have a citation for reckless driving, sir. That's a criminal offense. You
Well,
would have gone
that's
to
what
jail that night.
well, she told me it was for driving, careless driving or something, reckless, careless, going over the line. Me going over the line was me trying to get out of the lane and switch lanes so that I didn't have
And
her
that's
lights in my
why I want to stop you before we get too far. That's not the testimony from the officer at all.
What's the testimony from the officer?
The testimony from the officer is that you are in the left lane and that your tires on the passenger side crossed the center line multiple times. What
And
you
that's
just
incorrect.
testified is that you were in the right lane and that as soon as your tires, which would be your driver's side tires, crossed the
Correct.
center line to go to the left lane, you got pulled over.
Correct. The officer she's misconstruing that. We were in the right lane. I was driving the speed limit. When the officer pulled me over, I was in the right lane, not the left lane. That's where the testimony is backwards. I was in the right lane. The officer was behind me and I was getting ready to switch lanes and take off in the speeding lane because I didn't want her bright lights behind me. If I was already in the right lane, then there would have been no reason for me to switch back into the left lane. If I was in the left lane, there would have been no reason for me to switch back into the right lane to get in front of the officer.
Okay. And so let me pause you there because a lot of times what people do is drive in the left lane. You're not allowed to drive in the left lane unless you're passing cars.
And
That's
I wasn't in the left lane.
Listen to me. That's a real technical thing for an officer to pull you over. So I want to go back to the officer's testimony, which was fundamentally different than your testimony. And I'm just going to have her double down now on what the improper lane use was that you actually have a citation for. Like I said, you don't have a citation for reckless. So officer, can you repeat what it is you saw that you cited as the violation?
The vehicle driving in the left lane.
No, that's not true.
Sir, I want her to testify right now.
Go ahead.
For an extended amount of time, and it also went over with its passenger side tires over the center line, all the way over with two tires one time, and it went over the center line another time before that.
Yeah.
And then
that's why
he moved
that would
over
make
into the
sense
right
of why you pulled over and asked if he was drinking.
No. She asked me if I was drinking.
That's okay.
I'm just gonna be quiet because this is her testimony. I'm sorry.
Okay, so in other words, I have testimony under oath from the officer why it's improper lane use. And then, sir, this is your time to testify, but you're telling me an entirely different story.
I'm telling you that she's lying, unfortunately. I'm telling you that I was in the right lane. She traveled up under me for over 5 or 10 minutes and had her lights in my eyes. I switched lanes to the left, and that is when she gave me the ticket.
All right, hold on a second.
I'm telling you that
Schiffer,
this is
what mile marker is the ramp for the casino?
The 6-1.
All right. So, sir, what I have to do is take what I consider to be like the objective evidence here, the third-party testimony. What you just said doesn't make any sense. What she's testifying to is popping on at 61. She already testified around 66 is where she saw this, pulls you over at 68. You're talking about her following you for 5 or 10 minutes?
Officer,
on 131, you'd have been in Grand Rapids.
Your Honor, I'm new to Michigan, so I don't really know where I'm at. All I know is I jumped on the ramp. I saw an officer as soon as I came on the ramp with their lights on, and I drove like I had a lot of sense because I didn't want to get pulled over. I knew I was in a sports car, so I did not want to get a ticket. So I drove like I had some sense. I noticed a car behind me driving and traveling behind me for at least 5 minutes.
Okay. So based on the testimony I've heard here today, I would find you responsible on the improper lane use. What I want to make real clear to you, Mr. Joyner, is because you had a contested hearing, you do have every right to say, I don't agree with what just happened in there. I want to take this to what's called formal hearing. That's the next type of hearing in front of the district court judges with the prosecutor office.
Your Honor.
But you must do that within 7 days of today's date, and you must ask for that in writing. Otherwise, you would accept the judgment of finding a responsibility here and make arrangements
Your
with
Honor.
the district court for fines and costs. Do
May
you
I
understand
ask you a
your
question?
options?
May I ask you a
Yes.
question?
Yes.
I understand that this is a business, right? But what I'm telling you is that
What is a business, sir?
this is the court's business. This is a judicial system that's designed for this type of thing. When this officer, I guess it's a he say, she say scenario. But if I'm telling you that I wasn't traveling in the left lane and she's saying that I was, but what other proof do you have? I mean, she can tell you
Well,
whatever she
sir,
wants. And she didn't
exactly,
tell you
sir.
that.
That's
She
why I
didn't tell
said
you.
I have to base my evidence on what I heard that doesn't make sense as a third party. In other words, your timetable and where you're at on mile markers is completely different from what the officer said. And I find yours to be incredible and hers to be credible.
Oh, you're
And
okay.
so
So
therefore, if I have to
because
make
I
a
don't,
probability decision
so
on
because
who's
but I stated to you that I'm not testifying to the exact amount of time it was. I'm not saying that I know exactly how far it was. I know that I was
Sir,
traveling.
you testified. I made my decision. You have rights on appeal, but we
Absolutely.
wouldn't get back into this. All right. I'm going to go ahead and release parties. Thank you.
So where do I make this in writing? I'll see
The
you in
same
court,
district court,
Ms. Shipper.
the same district court that you would be paying the fine if you accepted the fine.
So where do you do that at?
You can call right on your notice there, that 673-0400 number, and they'll explain to you what to do next.
Your officer's a liar, Your Honor, and I want you to know that. It's not $100 ticket that's disturbing me. She lied and can come to court and use whatever information she has to testify, and then we just get stuck paying a bill. It's ridiculous. It's not fair. Court system is just not fair. It's not okay. You're welcome.
Play in during trial.
Mm-hmm.
They didn't.
Good
We didn't do anything else. Need to ask them. Good morning. What is your name?
Good morning. My name is Xavier Jackson.
Mr. Jackson, would you please kind of lean forward? If there's that microphone right there, I need you to speak loudly and clearly into it so we can hear you. This is cause number 36552 on Datavian Jackson.
There's no paperwork, Judge. I think we need to go through the motion, but I'd like to inform the court. I've talked to him at length about his case. He keeps wanting to refer to some other cases that were dismissed, and this one should have been dismissed. And that he went to ISF, but he was told he didn't have to complete ISF, but that's why we have no agreement.
I had a question about my cases.
So listen, pull your mask down and then speak loudly and clearly into that microphone. But here's the thing. So Mr. Jackson, you're on probation for one case. It's for a theft of a firearm.
Yes, ma'am. They dropped. I had a question. They dropped 2 of my cases, time served, and the other case that they have left was from that same action, and it has something to do with one of the cases.
Listen to me, Mr. Jackson. None of that matters right now to me at all. So you were placed on probation for this case back in October of last year. So maybe some other cases were dismissed, but you entered a plea of guilty on this case, and I put you on probation. I sent you to ISF, and they're saying that you didn't complete it. So here's what I need you to do. I need you to raise your right hand first so that I can swear you in, please. Do you swear or affirm that the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. You can put your hand down. And so what we're going to do, Mr. Jackson, is I'm going to go through this motion, and then you're going to enter pleas of true or not true if you violated your probation, and then we'll figure out what to do from there. Mr. Parker, will he waive the formal reading of that motion?
Yes, Your Honor.
So again, Mr. Jackson, you were placed on probation October 26th of 2022 for the offense of theft of a firearm, and that was a 4-year deferred adjudicated probation, right?
Yeah.
Okay, and so it says in here that you violated your probation. Count one alleges that you did not successfully complete the the ISF cognitive track. Is that true or not true?
True.
Okay. Count two alleges that you didn't give them verification or probation verification of completing your community service hours. Is that true or not true?
I've been in jail.
All right, I'm just going to put not true on that one. Count three alleges that you have failed to pay your court assessed fees as you were supposed to. And then as of October 26th of I guess that'd be 2022. You were $1,750 behind. Is that true or not true?
I came back to jail and they didn't say nothing about they didn't say nothing about the fines and stuff when I went to court.
Have you paid any fees or fines or any money at all?
Not yet.
Okay, so we'll put true there. Obviously, I know you've been incarcerated. So did you enter your pleas of true to counts 1 and 3 freely and voluntarily?
Yeah.
All right, then I'm going to find that you entered those pleas of true freely and voluntarily. Mr. Parker, is there any evidence that Mr. Jackson's not competent?
No, Your Honor.
So what I'm going to do, Mr. Jackson, is reset your case so that the probation department can do an updated report. That's going to give me more information about you, what's been happening since I placed you on probation, and then we will come back later. And that's the date that I'll determine what to do. If I leave you on probation, if I revoke your probation, send you to prison, probation will come out and talk to you before then, okay?
They dropped the two cases that they dropped. They left one case. And I was supposed to either get that case dropped or be on probation for it. I was waiting to get out to go to work.
Okay, you're on probation. I already told you those other cases don't matter. Maybe they did drop some cases, but you pled guilty to this case. I have one case in front of me. It's a theft of a firearm. It's a state jail felony. You were put on probation for it last October.
Okay, so my question is, so they kept the theft, but they dropped the possession of a firearm. But they said they dropped the time served.
I don't care if they dropped a case. You're on probation for the theft. So you have to follow the rules of probation. Go back with the bailiff. Unagreed. Go back with the bailiff.
John, I have a warrant for you today. It was signed by Judge Heineman. He found probable cause for 2 charges, stalking and trespass after warning. As to those charges, you wish to represent yourself. You're going to hire private counsel. Would you like the public defender?
I would like to handle it now. I didn't do anything.
Okay, well, that wasn't one of the options I gave you. You're going to represent yourself. You're going to hire private counsel. Would you like the public defender?
No.
Pardon me?
No.
What are you saying?
No, I can't say it.
Okay, I'll find you not participating in first appearance. I will hold you without bond because you won't participate. You'll be back in court on the 20th of March.
I'm trying to
Sit down, you're done, too late. You missed it.
How you doing, young man?
Fine.
All right.
People versus Nicholas Mercer, 23 F5-5020 and 21.
Dennis Sinatra, First Assistant Prosecuting Attorney on behalf of the people.
Good morning, Your Honor. Stuart Collis on behalf of Mr. Mercer. This is time and date set for a preliminary exam. It's my understanding that the alleged victim in this case is not here, and we would move to dismiss at this time.
Sinatra?
Your Honor, that is correct. She is not here, but I do have some information that I would like to put on the record and share with the court, specifically that the people's understanding upon information and belief is that the defendant had been in contact with the victim in early February via jail calls, which were a violation of bond conditions, and the substance of those jail calls in part were that He did not want her to come to court. And that if she didn't come to court, the cases were going to be dismissed. Based on that information, Judge Simpson revoked the defendant's privileges to make jail calls. Furthermore, the prosecutor's office charged the defendant with witness intimidation. That's a felony. He is set for a probable cause conference on March 2nd with Judge Simpson. Cash bail is $25,000, surety, cash surety on that. So last thing I'll say is I just served counsel, Mr. Collis, and the court with a forfeiture by wrongdoing motion with the people's intent to use statements based on the defendant's actions of preventing this witness from coming to court, coercing her from coming to court. And I don't know if Mr. Collis is ready to proceed today. I just literally gave it to him this morning. But that's the reason for people's position on not being able to proceed with that witness, but we do have a valid motion.
Mr. Collins.
Your Honor, I appreciate the people filed this motion. However, they've had the opportunity to file this motion for 3 or 4 weeks, and they have not done so. They've instead filed the witness intimidation charges and served this motion today. The witness intimidation charges were filed a couple of weeks ago, I think, and I was appointed to that, which is again to be heard on this Thursday. In listening briefly to the phone calls, because Mr. Ganatra provided me with the phone calls a week ago Friday, and then of course we've had a power outage that has knocked me out of commission for basically Wednesday through Sunday, and I had a jury trial on Tuesday and Wednesday. Obviously, I haven't been able to do much more than cursorily review them, but in reviewing them, it doesn't sound like to me that Mr. Mercer is in any way trying to coerce Ms. Dunis from showing up here today. In fact, it's her asking him what to do. I've had no fewer than 5 or 6 phone calls from Ms. Dunis about essentially asking me what to do. And of course, I've not returned those calls because of course I can't advise her as Mr. Mercer's attorney on what she or should not or do. It does not appear that Ms. Dunis is going to be a cooperative witness. And here's the end run story about this all, Your Honor. Let's assume for the sake of argument that we do get through and the people get their wish and they get a forfeiture by wrongdoing. Get to trial, none of these statements are going to be admissible anyways, and then the case is going to get dismissed. So it seems like a long end run to get to the same place. So if the people feel that they can go at some point in time, let them go at that point in time. But today, as it stands, and after several adjournments, I would ask that this case be dismissed.
Your rebuttal?
Well, actually, the forfeiture by wrongdoing carry over into circuit court as well, the motion. Furthermore, there'll be I would expect a 27B(c) motion as well to be filed by the prosecutor in circuit court because the defendant does have a prior DV conviction with the victim that's listed on this case, on these 2 cases.
Based upon the information the prosecutor has shared with the court, I will deny the motion to dismiss. You're requesting an adjournment.
Yes, Your Honor, it's going to take time to respond to this motion. Obviously, I just got served with it this morning. May we approach, Your Honor?
Sure. All right, my understanding is that the witness is not available on the 28th, and the defendant is going to have a PCC Thursday. So it was suggested that the best date to adjourn this, not making him wait that long, would be 2 weeks. And Judge Burke is here 2 weeks from today. So I'm going to adjourn the matters to Judge Burke's docket 2 weeks from today at 9 a.m.
Your Honor, my client, as he indicated and I indicated at the bench, now also wishes new representation.
That's the way it works, Mr. Mercer. Everyone is entitled to, if a person's indigent, meaning has no cash, everybody's entitled to be represented by an attorney.
Right.
However, the Constitution doesn't say you get to choose your attorney. Mr. Collis has been in practice a long time. I know him to be a competent criminal attorney. So your request for a new attorney is denied.
May I tell you my reason?
No.
I-
What you mean your reason why you want to?
Yes, sir.
Go ahead.
Okay, now here's that, sir, I was aware that this was going to happen since the last court date that I came to. Now, I'm very, very confident and sure that he was aware of this as well.
What is this was going to happen? What do you mean this?
Forfeiture by this motion.
Forfeiture by Ron.
This motion. This was discussed at the last,
Well,
which was 2 weeks ago, sir.
that doesn't have anything to do with the fact that basically that was one of the things that Mr. Ganatra mentioned, but he also he mentioned the fact that he alleges, it's the people's position that the witness isn't here because of your having asked her or told her not to be here.
Right.
So
This motion,
regardless of whether this motion was filed, I'm stating regardless of whether this motion was filed, the court would exercise its discretion and I would have adjourned it anyway based upon the representation.
Absolutely, and I'm not denying it, sir. My thing is this, sir, is that 5 minutes ago was that's the last time he has talked to me. I've been incarcerated for over a month. This gentleman has seen me a total of today and then the last court date. I have been blindsided by all of this stuff, but he's been aware of everything. So I'm just sitting in here, and I understand that you would have made your decision regardless, but you know what? I understand where you're coming from. And the fact of the matter also, sir, is that what he's saying about, it's my understanding that the accused victim has actually said that they I'm pretty sure that they've he's just not saying everything that needs to be said. He's not sticking up for me, sir. He's not doing his job, in my opinion.
All right, I stand on my ruling. Mr. Collis will continue to be your lawyer. I'm sure that if he needs to see you between now and the next court date.
I really hope so.
See you.
I definitely hope so.
We're done discussing.
Thank you.
that.
Have a nice day.
Gentlemen, council close on an unrelated matter.
You may.
What's your name? What's your name?
Cody Allen.
Okay, Mr. Allen, you've been charged with stalking. That'd be a Class A misdemeanor if convicted. You've been charged with evading arrest. That'd also be a Class A misdemeanor. You understand what you're charged with?
Mm-hmm.
Would you like me to read the allegations?
No, because it's bullshit, honestly. Like they tell me to come up and get my car. They tell me to come up and get my car, but then they hit me with stalking. I don't get that.
Stop talking. I didn't ask for all that. I just want to know if you wanted.
You asked me my question. I gave you your answer.
That does not answer my question, and I did not ask for that. And we're very.
So what's my hold to North Carolina?
All right, we're done here. You can bring him back in the morning, officer. He's not ready to cooperate.
I didn't know I was asking you a question. I didn't know, sir. It's my
Nope,
first time.
we're done. You can come back in the morning. We can try again when you're ready.
Thank you. I'll just refuse it in the morning too, and I'll just wait for North Carolina to come get me.
So Leonardo, first thing I have is a grand theft auto and resisting with violence. There's probable cause for those charges. As to those charges, you wish to represent yourself, you're going to hire a private counsel. Would you like the public defender?
No, public defender, sir.
I'll point the PD, State.
Yes, Your Honor. He has a possession of a controlled substance, possession of paraphernalia, unlawful possession of 5 or more personal ID information. In 2021, all adjudications. Criminal mischief, 2020 adjudication, resisting without.
If I can get a second, Your Honor.
If you would learn basic manners and shut your trap until you were spoken to, yes.
Yes, sir.
You were interrupting, right? Someone else was speaking, and then you started talking. That's called interrupting. We don't do that, okay?
Yes, Your Honor.
All right, go ahead, counsel.
Yes, Your Honor. Petty theft, in 2016 adjudication, possession of controlled substance without prescription, possession of drug paraphernalia, 2016 adjudication, a battery in 2015 adjudication, driving on suspended 2013 adjudication, criminal mischief and assault 2012, both adjudications, and 2 batteries 2012 adjudication, false report commission of a crime 2009 adjudication, DUI, and leaving the scene 2008 adjudication, assault 2008, withhold, possession of cannabis 2007 adjudication.
And Mr. Morales, I have an address for you on Bromley Avenue. Is that where you currently live?
Yes, Your Honor.
How long have you lived there?
I've been there about 15 years, 20 years.
Are you working these days?
I was taking care of my grandmother because she's on oxygen right now.
Okay.
And I've been her caretaker and trying to figure out how I could be able to get some kind of credit for doing that. And that's why I had the car.
Okay.
Allegedly.
Stop. Let's not talk about the facts anymore.
Yes, Your Honor.
All right.
But I've been taking care of her since she's been on oxygen and basically.
Okay.
just
So
been
how
at
long?
home.
So you haven't been working while you've been taking care of your grandmother, right?
No, I've just been taking care of her, man, making sure she's all right. and
How
doing
long
everything for her.
how long have you been doing that?
I've been doing that for about since Thanksgiving.
Okay. All right. On the criminal charges, I'm going to set your bond at 1,000 on each count. That's a total of 2. The other thing I have for you, Mr. Morales, is a writ to bodily attachment. And this is a child support writ, so the child support hearing officer and the circuit judge determined that you owe some child support. Obviously, you'd have to come up with some money to bond out. What I'm going to do on the writ is I'll find you in contempt for the failure to pay child support. I'll set your cash purge at $50, all right? So you have to come up with the money for the bond, then you'd have to come up with $50 cash on the child support writ. If you get out, Leonardo, then you have to also go visit with the folks at child support to make some kind of arrangements with them, because if you don't do that, these folks will start this process over again.
I know you're talking. I apologize. I have to get that worked out. I'm so sorry. I have a court date for child support on the 15th, and I was supposed to modify my payment that they had put the bodily attachment out on. So I apologize.
Okay, well.
But that's what. But I've been contacting them. So
you need to take care of that. That's all I'm reminding you. Okay.
Yes, sir. Yes, Your Honor.
Okay. All right. So we'll have you back in court on the new charges on the 9th of February. Make sure you go see the PD when you get out, okay?
Yes, Your Honor.
Thank you.
Thank you.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
All right, good morning, Mr. Katz. Mr. Mills, tell us your name.
Mills.
All right, good morning. Mr. Mills is scheduled here for a summary proceeding for 9. He did appear at the first pretrial. So Mr. Mills, did you have the opportunity to find any assistance since the first pretrial? Did you apply or did you receive any assistance with your rent?
I haven't received any assistance. I got to go to the place. I got to get on the bus and go. I had a slip and fall out here Sunday, and I'm re-injured. I had one a year ago too, and I'm just in a lot of pain right now. But I'm not getting a response. And then the attorneys that the Shore Lake, the guy I called. Yeah. His phone ends. We talked maybe 1 or 2 times, and now when I call, it goes in. It ends. And then he gave me a message saying that my email or something is not going. I never had no problem like that with anybody. And then I'm trying to call this morning, and it ends. It rings a couple of times and it ends. And I'm just so tired, man. Really.
Okay.
Sick.
Well, let's find out how much rent is actually due through March.
Your Honor, currently there's a balance due of $5,152 of past due rent, $165 of costs, for a total of $5,317.
All right, so you got $5,317 now due, which includes the court costs, sir. Do you disputing that amount in any way?
Some of it,
Why?
yeah.
Why?
Yeah. Why you hollering at me?
Sir, sir, listen, sir, will you please stay on track? I'm on a Zoom call. I'm on a Zoom call and people have trouble hearing. So I have to talk loud. So I'm hollering at you. So I'm waiting for you to answer the question. Are you disputing the amount? And if so, how?
Because I'm using all my electrical energy, all my utilities are out the door because they cut the doors almost. All my energy is going out the door. I pulled out a dead animal out my vent, you know, and the wall is black. And since I walked in this place, I have nothing got done. I told them about the slip and fall last year. Nothing.
Okay,
you
so
know, and then it just happened.
we want to hear from you about things that affect your
The carpet is, I had sawdust all over here. I'm saying I owe them. My sister ran off with $2,000 on this lease that I just signed because she didn't give my mother a vaccination. So I didn't, from the right off from the rip, and I shouldn't even have a lease, really. My credit score is under 500. My sister's paying people to look the other way because her stupid money that she has, her and her husband. I had a co-signer on the first lease, you know, and so when I walked in this door, they were sawing that front door.
Okay, sir, I'm trying to find.
I'm not trying to dispute what I owe here. I'm not, Your Honor. I'm not trying to dispute what I owe here. My sister ran off. I panicked. All this kind of stuff. You know, I still got a freaking D-boy right here that I got a person that robbed me. I don't even want to be here. I was supposed to be gone since August. My sister had me sign her off and left with $2,000. Play 28. I only get $1,200. I just got a raise. I only get $1,200 a month.
So are you
my utility like about $600 or $700 a month? So you do the math. They know I was gonna fall like the Titanic. This was gonna sink like the Titanic. And she ran and I ain't talked to her. She ain't, and then I just heard from her and she got my mama posted up and she fucking got fucking dementia. She don't know who the fuck I am now.
Okay, Mr. Mills, Mr. Mills, hold on, Mr. Mills. We can't have all that swearing in the courtroom. We appreciate the circumstance that you're under, but we can't have that.
I didn't.
So are you saying that you're not disputing the amount that's due?
Not all of it. You know, I can't even breathe in this place, man. Don't even let them stay lit. That's how bad this is. I've been calling the housing commission. They ain't even picking up the phone.
How much?
I would have been.
Mr. Mills, you have to calm down. I can't get anywhere with you just going off the deep end here. We need to get a few questions answered. And so my question is, how much rent is it that you think you owe?
Minus what my sister ran off with. You know,
but why is it the apartment? Okay, Mr. Mills, the apartment
I don't want to be there.
The apartment complex cannot make up for money that your sister ran off with. They can't.
I'm talking about, I've been living in a place that's not even clean or sanitized. And so they threw old carpet on top. It's dirt underneath it. I got pictures to send you. I can show you the animal that I put out the vent. I can show you the carpet damage from water that's leaking through the wall.
Okay.
When the last time they checked on mildew? Yeah.
Your Honor, it appears that Mr. Mills doesn't even want to live there. I'd give him until the end of the month to just move out. We could do a judgment, all occupants, not even list his name.
Yeah.
And then he could just move out.
I'll sue you too. We're gonna do a class action lawsuit against you. Do whatever the hell you want to do.
Mr. Mills, listen, you're being very disrespectful.
No, you just heard what he said.
But he's not.
If I don't want to live there, get me out of here.
Mr. Mills,
you're right. He's right.
Mr. Mills. First of all, Mr. Mills, you need to stop walking and sit down and pay attention to the court hearing. And
that shows you that he don't care about my health.
Okay.
But I've been to the doctor twice. I
Mr.
can't even drink.
Mr. Mills, until you can calm down, you're gonna have to be muted. Okay, and we'll just have to come back to your case until you calm down. So that's what we'll do. All right, we're gonna pass that. Give him a chance to cool off. Let's go back to Mr. Mills. Denise, ID 12 Franklin versus Mills.
Ready, Judge.
Okay, so this is case number LT 225296, recalling ID 12 Franklin Investor LLC versus Mills. All right, Mr. Katz.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
And Mr. Mills is here. He's on mute right now. When we passed the case to allow him to calm down a little bit, we determined that the amount of rent was $5,317. He wants to contest that amount. As he says, some of the, I guess, parts of his apartment he feels are in not habitable. He wants a rent credit for something that his other tenant roommate didn't pay. I don't think that can happen. But if he wants to have a trial on the premises and whether or not he's entitled to some amount of a rent credit.
Your Honor, if I can ask the court, it seems like Mr. Mills doesn't even want to live there. I would have no problem converting this to a termination case, giving him until March 31st. He said he doesn't want to live there.
That'll be fine. Hey, can I say something, Your Honor?
Mr. Mills, would you like to move out by March 31st?
I need time. I have no problems, but like I said, I've been sick a couple of times because of the conditions in here. I've been in the hospital twice, Ascension. I'd like to get some of this stuff tested because it's been in there for decades, and under the lease, they can charge me for these things. So I just don't want to turn and say, okay, I want to get credit for that. And I also want to find out what my grandkids has been breathing in here. There's
all right,
dust
Denise,
storms, literally.
we'll have to set it for trial then, sir. If you want to go into those.
We absolutely do.
Then you would have
be
to
astonished to find out what's going on in here.
Okay, but make
you
sure
will be astonished.
Mr. Mills, you're gonna have to call some.
Sorry.
You'll have to call your witnesses for your defense. So just know.
Well, how can I get my sister who ran off with the money?
And if you're saying there's mold, you might want to get a professional to testify as to what it really is, because sometimes you think things are something and they're not. So if you've had somebody.
I can't breathe. I mean, I had heart palpitations in here. That's serious. And other people are going through it. I mean, it's not just me.
Your Honor, this case was filed in November. If Mr. Mills is having such issues where he's concerned about his health.
Listen.
I fell asleep right over here, man.
I need him to stop and I need you to stop. All I want is a trial date. If we have all this arguing, we're going to do it in person. We're not going to hold up everybody else's case today. So Denise, what's the trial date?
April 17th, 2:15.
All right, that'll be in person.
Honorable Judge. Can you hear me?
April 17th, Mr. Mills, at 2:15. You can bring whoever witnesses you want, but you do have to show that what you're doing is actually mold. So.
And Your Honor, I'm requesting a escrow order on this case.
I've said animals. It could be, and it's definitely there. That's not. But my problem is what's going to be done about the slip and falls.
Your Honor, that's not relevant to this matter.
There's no reports.
It's not, sir.
I have witnesses.
Sir, that's not relevant to this case. This is simply.
Okay, but okay. So what do I do about that? I'm just asking.
You have to get a lawyer, sir.
Who can I talk to about it?
A personal injury lawyer, and let them handle it.
I don't want a lawyer. I want somebody from here till I want to report it here first.
I can't help you on that.
Yes,
Your Honor, I'm requesting an escrow order on this case.
All right, how much is the rent?
Your Honor, the monthly rent is $890.
You're not gonna get no escrow. I can tell you that now. It's a waste of time.
$890 is the escrow amount, is the monthly rent, Your Honor.
$890 is the rent. Okay. I know we've got 23 days left. Let me do my little math. Okay. 890. All right, here we go. So we have 890 and we'll divide that by 31 and then times that by 23. And the escrow for this month is $660.32. This is a court order, Mr. Mills, pursuant to the law, says that I have to enter an escrow order if possession of the premises is an issue, and if the court date is put off more than 7 days. So you have to pay this, whether you like to or not. You pay it to the court. Do not pay it to your landlord. Then I decide at the end of the case who gets it. So it's going to be $660.32 paid within 7 days of today. And then the normal rent of $890 is to be paid on the first of the month. But it does have an escrow, a grace period, 7 days. So by April 7th, pay $890, and within 7 days of the day, pay the $660.32.
Tag light. Shop tag light. I don't have nothing in here. Nothing.
And Your Honor, what was the time on that court
I can
date?
be out of here.
2:15 p.m.
All right, thank you.
All right, I prepared the escrow order. You have the trial date. We'll get a notice out on that.
Tag light.
All right. So that concludes this matter for Mr. Mills. We'll see you
Thank you, Your
on
Honor.
Thursday. And pay your escrow, sir. That'll conclude this matter.
Want to thank you for coming in. It's a weekend in Austin, and so everybody wants to come to the jail. You managed to get here before we got too full, so thank you for doing what it takes to get here. Now, if you want to get out, you can either contact your lawyer or a bail bond company and see what they would charge to put up your bond to get you out. Do you need a court-appointed lawyer?
I don't know.
I'm going to put you down for one. You got 2 charges. You got a Class B misdemeanor driving while intoxicated with a $3,000 bond. And you got a 3rd-degree felony possession of a controlled substance with a $15,000 bond. And you got my advice that you really, really, really need to leave PCP alone. It will fry your brain to the point you don't know you're pissing.
Yeah, that was my first time doing it and my last time doing it.
I used to work out at the state hospital, and I watched a guy who did PCP. The first time he came in, he was a normal person. By the time I saw him the last time, he didn't even know he was pissing when he tried to talk to me.
Yeah, that was
Brad, you got to get evaluated for a drug situation, submit random urinary samples.
Am I available for PR?
And you may not drive without a valid license and liability insurance. Yes, you did get personal bonds. So you will get released tonight. You'll have a week to pay pretrial $40 on each one.
Yes.
Don't screw up, okay?
I won't, Judge. Thank you so much.
All right. Did you have any other questions about any of this?
No.
All right. Thank you.
Thank you.
Next. Red Exo, state your name.
Joshua Nolan.
Good morning, sir. You're here for your first appearance, Mr. Nolan, the purpose of which is to determine whether or not there was probable cause for your arrest. You have certain rights, including the right to remain silent. You have the right to counsel. And for purposes of today, I'm going to appoint the law office of Henry Mark Sims to represent you. You have the right to communicate with your attorney, your family, and your friends, and if necessary, Mr. Nolan, I'll provide you a reasonable opportunity to do so. You've been charged with providing false ownership to a pawnbroker, third-degree felony, dealing in stolen property, a second-degree felony, grand theft. It doesn't state at least on the face, but that's at least a third-degree felony, and burglary of conveyance is a third-degree felony, all punished by up to 5 years in the county jail, sir. Any criminal history on Mr. Nolan?
Got him on probation in 22-3745 CF.
Yes, Your Honor, if I just wanna, I just had a question. All of this right here, it says that it was a burglary of a conveyance, and then the case, sir, it was an alleged vehicle that, how can I be?
Mr.
All
Nolan,
of this, it was left
Mr. Nolan.
it was left in my possession.
Listen
Your
to me,
Honor.
Mr. Nolan, listen to me. I know you want to talk. We're recording this proceeding, and it's probably not in your best interest that you talk about the facts of your case, all right?
Absolutely, it is, Your Honor. I just want to say that she gave me the keys and everything to this vehicle, and it says in this case that they did. She went to jail the day before, left everything in my possession. I can't burglarize something that was left in my home and given to me, sir. That's what I want to say.
Yes, sir, thank you. I'm gonna find this probable cause for your arrest. For the false information to a pawnbroker, your bond will be $2,500. Your dealing in stolen property, your bond will be $5,000. Your grand theft, $2,500, and your burglary of conveyance, $2,500. Your next court date will be April 24th at 9 a.m. Sir, you're out on bond in case number 22 CF 3745. What I'm gonna do based on my determination that probable cause for your arrest, I'm gonna revoke your bond. Excuse me, I'm gonna issue a capias for your violation.
It's the probation. It's yeah.
Yes, and you'll be held without bond for your VOP, okay, sir?
Mr. Medina, do you need a court-appointed lawyer when you get to Val Verde County?
Yeah, I think so.
All right, I think so too. You have got felony warrants for possession of a controlled substance, 10,000. And then smuggling of persons, 10,000 each for 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 cases. Any question about any of this?
No.
All right, so that's 120,000 altogether. And if you don't bond out, well, then Val Verde County has 10 working days to come get you. All right, thank you, sir.
All right, State versus Travis Bowling, 22 CR 56. So you, Mr. Bowling?
Yes, sir.
All right, looks like you failed to appear for court. Your bond was revoked. A bench warrant was issued. Your new bond is 5,000 cash professional surety. Special condition, no contact with Priscilla Fox, and GPS tracking with court service officer supervision. It looks like you already have a court-appointed attorney on this one. And then I will set this over to his next time in court on my docket, which is March 16th at 2:30. If you make that bond, you need to be back in court at that time, okay?
Yep, Your Honor. I have a question about my bond. And I talked to my dad on the phone today. He wanted me to talk to you about maybe getting my bond lowered a little bit. I was never running away or trying to miss court or anything. I left to Indiana, and because I had nowhere to go. I lost my apartment, I lost my job, and then I lost my apartment in Enid. And so I had to go to Indiana to go live with my mom. And my dad wanted me to talk to you about lowering the bond. I can pay that bond, but it just makes it a little bit harder on him.
Honestly, after hearing that, I feel like raising your bond. So you've got connections to other states you could choose. And you've already shown you would run and not show up for court. So I think I will raise it.
No, sir. I wasn't trying to run from court, sir.
I don't care if you were trying to or not, you did, and your bond's now 10,000 cash and professional surety. You've got out-of-state connections. So if you make the bond, the same conditions apply. If you make that bond, you need to be back in
Oh,
court.
no, sir, I don't have the out-of-state connection.
Want to debate this hearing?
Got anybody left? Oh, we do, don't we? Is there a Terry Don Washington left?
How you doing, Judge?
All right, I apologize, sir. You were the last one I was getting to tonight, and I have not reviewed this yet.
No, that's fine.
And there's 1, 2, 3, 4 charges, and they're all the same. Second-degree felony, aggravated assault with a deadly weapon. And let me see.
Excuse me, Judge, how did assault by assault nobody?
I'm sorry, what was your question?
I said, how that an assault if I didn't assault nobody?
Well, let's see. What they claim is that you ran into somebody's car.
No, somebody ran into my car on the way coming home from dropping off a friend for his birthday. They ran into my car. I got outside my car.
And they claim that you pulled a Glock out.
A Glock? Wow, no, that is not how it happened. Apparently it was 5 against 1 because I was the only one that was out there, but they all surrounded my car trying to jump me.
And that you pointed the pistol at them. And it looks like you said some threatening things, and they have 4 witnesses who claim they saw it.
Wow.
And so it's going to be 25,000 on each charge. You may not own or possess firearms. And
so I'm sorry to cut you off, Judge. So it's he say she say thing basically, since they didn't find no firearm on me.
no, it's a he said, she said, he said thing, because they have witnesses.
But no weapon.
Yeah. So there's second-degree felony, aggravated assault with deadly weapon, no contact with the alleged victims, stay 200 yards away from them. 25,000 bond on each one, no firearms. And
That's crazy.
do you have any other questions about it, sir?
Yeah, that's crazy because I never owned a firearm my day in my life. But what about was I available for the PR bond, sir?
No, sir, by law, because there's a charge that you were using a gun to point at people and threaten them. By law, you cannot get a personal bond.
Well, how is that true if they didn't find no firearm, sir? Just because he said, she said, he said type of deal that you just said?
Yeah, with the witnesses, that's what they're basing it off of.
Oh, so just because the witnesses, that's what they're going off of.
Yeah.
And you said it's 25 a piece?
Yeah, so that's 100 total.
Yeah. Just for a quick question, how much time, if I'm not able to pay that off, how much time is that?
Talk to your lawyer and see, what the current timeline is on getting to court on stuff like this. I don't know.
Cause I might need a court appointed.
All right, I'll put you down.
Mr. Bell, you're here for your first appearance, sir. The purpose of which is for me to make a determination whether or not there's probable cause for your arrest. You have certain rights, including the right to remain silent, the right to an attorney. I'm going to appoint the law office of Henry Mark Sims to represent you. You have the right to communicate with your attorney, your family, and friends, and if necessary, I'll provide you a reasonable opportunity to do so, sir. You've been charged with driving while license suspended, canceled, or revoked. It says hit and run. I'm assuming that's leaving the scene of a crash. False information to a law enforcement officer, attaching a tag not assigned, and failure to register your motor vehicle. The last two are second-degree misdemeanors punishable by up to 60 days in the county jail. The first three are first-degree misdemeanors punishable by up to 1 year in the county jail. Any criminal history on Mr. Bell?
He shows nothing since 15, and that was a hit and run involving injury, and he had a couple of batteries in 13. That's it.
All right, Mr. Bell, where do you live at, sir?
Washington County. I live right there in Greenhead by the prison.
All righty. Mr. Bell, your next court date is going to be March 22nd. Your bond on the driving while license suspended, canceled, or revoked will be $1,000. The hit and run will be $1,000. False info to a law enforcement officer will be $1,000. The attaching the tag not assigned will be $500, and the failure to register your motor vehicle will be $500. Your next court date will be March 22nd here in Bay County at 8:30. You understand that?
Yes, so you said that I feel that I got a ball.
Yes, sir. 4,000 total.
I got that.
All right, you can step out.
Thank you.
Ready?
All right, Mr. Lampkin, my name's John Yeager. I'm an Austin Municipal Court Judge, sitting as a magistrate this evening. Magistration, I'm going to let you know what your charges are, give you your constitutional rights, set a bond in your case if it's allowed by law, explain bonds to you, so that might help you get out of jail. And also I'm going to issue what's called an emergency protective order.
Hey, but
These cases involve assault, family violence. So, Mr. Lampkin, you're here because a credible person, usually a peace officer, has filed a sworn information or complaint alleging the commission of a criminal offense. That complaint has been reviewed by a magistrate. Probable cause has been found to exist. This is probable cause only. It doesn't mean you're guilty. This is not a trial. It's just probable cause exists for the continuation of the charges.
that law said I was supposed to be out of jail this morning.
I'll let you speak after I'm done, okay? Once again, there are charges pending. We don't discuss the facts of the details of the cases here because I'm not the judge that will be hearing your case, Mr. Lampkin. You're charged with a Class A misdemeanor offense, assault, bodily injury. You'll be in county court at law number 4, the court that deals with family violence cases. Since there are charges pending, that you have the following constitutional rights. You have a right to remain silent. That means exactly what it says. You don't have to speak to any law enforcement officials about the facts or details of your case. If you do make a statement, that statement can be used against you in court. You have a right to have an attorney present during any questioning. And if you can't afford or don't have the resources to hire an attorney, you can request that one be appointed for you. You qualify under the economic guidelines. There, you will be afforded court-appointed counsel within 72 hours. You will have a reasonable opportunity to consult with that lawyer, as well as a right to terminate or stop any interview at any time. This is a Class A misdemeanor offense, but the bond in your case, sir, is set at $10,000, and there'll be an emergency protective order entered in your case. Do you have a lawyer, sir, or do you need to request court-appointed counsel?
I mean, I do have one, but I mean, sure. Yeah, I'm in to hire my own lawyer, but I just request a question. Hiring a lawyer, but
okay.
I had the whole apartment complex. Like, it was people all out there. My mom and my nephew. I didn't, but how can I come to jail if I never touched somebody?
I'm not the judge that will be hearing your case.
No, but I'm saying the law said that last night. They say, man, look, we're just gonna write a report. We gotta take you to jail because She know what she doing because she talking about, she ain't, I didn't even touch her. I like literally physically touch
Sir,
her.
you're gonna have to speak with your lawyer about that. You don't want to be making statements.
No, what I'm
in
saying
front
is,
of the-
I don't care because I know I didn't do nothing. Man, look,
Okay,
the lawyer told me last night.
I'm going to.
Be out of jail in the morning. He goes, we gotta take you to jail because she's reporting of hurt. I said,
Well,
I
we're
didn't
gonna
tell
have
you.
a protective order as well, Mr. Lampkin. The bond is set at $10,000.
How much?
$10,000, and the emergency protective order will be entered right now. So listen carefully. I'm going to indicate you're requesting a court-appointed lawyer, and if you hire one later, then you can certainly do so, and that lawyer will be discharged.
Yeah.
There's a protective order in place, which means if you violate this order, then you'll be immediately rearrested and charged with violation of a protective order.
I ain't worried about her. All I want to know is if I can.
Okay, so you are Donald Lampkin, correct?
Can I see my kids?
Listen, he'll explain it to you.
You are, your date of birth is November 22nd, 1983. Is that right? Sir?
Yeah.
Okay. Now, the protected parties under this order are Heather Gonzalez, Neva Abdullah, Tanaka Lampkin, and Donnie.
I should put my kids on there. They ain't even there. They wasn't even there.
You're not to commit family violence against any of these parties, and that means you may not assault or commit any offensive touching against these individuals.
Did you say
not to communicate directly with them or in a threatening or harassing manner, or have anyone else threaten or harass.
I'm asking
You may not
come to my house.
Can he explain it? And he's trying to, you keep cutting him off.
I can't hear him right.
You keep talking. He said all the names. Stop.
No, he didn't even say my kids' name right. Bro, I want to know if my kids, if I can see my kids.
You are.
Look, I'm not even getting you loud with you. I asked you.
Sir,
listen.
You're not to go within the residence that includes your children's residence. 787-45. You're not to go within 200 yards of that residence during the pendency of this year.
One of my kids stay with me though. That's what I'm saying. Is that name on there?
What name is that?
The Donica. She's at my house with my mom right now. She stays at my house. DONAKALAMPKIN, Donica Lampkin. She shouldn't even be on there. She at my mama's house right now.
Well, you'll have to. She's on the list, so you're not going to be able to go within 200 yards of that residence if she's staying there.
She don't stay at that house. She stay at my mama's house on Aiken Street.
Well, this order applies to that residence.
So long as I ain't at that address.
That's right.
All right, so my kids can come to my house.
As long as you're not at that address.
I bet.
And that you can't commit family violence against
her. She can stay the hell away from me. She better.
Okay, now this goes into effect immediately and is in effect until May 18th. Okay. All right. So that's the protective order. Make sure you don't violate it, because if you do, you can be rearrested, Mr. Lampkin.
She better just stay. Long as what does she come around me? I call her laws on her.
Okay.
On her.
Now, you do have one old possession of drug paraphernalia case out of the Austin Municipal Court. I'm willing to grant you jail time so you can take care of this if you wish to plead no contest.
No contest.
Okay, I'll do that. And you'll have to sign an order saying no contest, but they'll bring that to you later. So good luck to you, Mr. Lampkin.
So do you know if I'm gonna get my personal bond now? Or if I seen him, I won't get it on.
That's not the case. He's here to magistrate you, let you know why you're here, issue your bond amount. He didn't relay a personal bond to you, so therefore you didn't qualify, or they didn't approve a personal bond.
So I didn't get it.
No, sir.
All right.
The bond amount is, Judge, are you there?
Yes, I'm here. No, he's not approved for personal bond. Basically, he has a significant criminal history that
I understand. And the bond amount was 10,000, you said, sir?
10,000 and an EPO, yes.
All right, thank you.
Mhm.
You can.
Good morning, everyone.
Good morning, Your Honor.
Good morning. Calling, thank you. Calling case number prosecutor's order number 23-02687. Tyler James Zalman. Names for the record, counsel.
Good morning, Your Honor. Nick McIntyre appearing on behalf of the people.
Good morning, Your Honor. Cecilia Karen Dongo up here on behalf of Mr. Solomon. He is present on Zoom, Judge, and we have no objection.
Okay, make sure you move back a little bit to
Yep.
counsel.
I don't know
Just
what it is.
give you a heads up there, so you won't be muffled. Sir, would you state your name for the record?
Tyler Lohman.
Okay, counsel, how would you like to proceed at this time as race to your client?
Yes, Your Honor. For purposes of arraignment, I would waive reading of the charges, stand mute, ask the judge to not guilty pleas on his behalf. I did inform him of the nature of the offenses. Some of them have mandatory prison sentences, but the maximum possible penalties as well as his basic constitutional rights. He is requesting a court-appointed attorney moving forward.
Okay, I'll indicate that your client stands mute and they're not guilty plea on his behalf. I will grant court-appointed counsel going forward at this particular time. Waive the formal reading. Any thoughts, any comments on bond you have, counsel, as it relates to your client?
Well, he's not eligible for a personal bond, Your Honor. He's already on release status for a misdemeanor. I would just ask for a reasonable cash bond. I happen to be familiar with Mr. Solomon, but I don't have any comments, just that it'd be a reasonable cash bond. I don't think he's in a position to post any cash bond, but I know he's not eligible for a personal bond.
Okay. Thank you, counsel. Prosecutor's office?
Yes, Your Honor. I just wanted to appear today to bring a few matters to your attention. First off, I don't know if you have a report has been generated for Mr. Zalman. Per my records, I believe he has 5 active bench warrants, which are now being addressed since he was taken into custody. But at the time he was arrested, he had 5 active warrants for failure to appear. They are minor traffic issues. However, I do think that shows a flight risk. Your Honor, and the facts of this case are highly concerning to the people. It is alleged that defendants stole at least 12 handguns, 14 long guns, as well as an AR-style rifle. He sold nearly all of those. Unfortunately, some of the weapons he didn't steal were left around the house. So when his home was searched, there was a 1.5-year-old child and a 4-month-old child in the house. There was 1 loaded handgun with a round in the chamber between the cushions and the couch, another loaded gun on the floor, and another one in the bedroom, all within reach of those children. Which is, of course, quite concerning because there are various pictures and videos on this defendant's phone that he took of himself holding his 1.5-year-old child, who was holding a Draco-style assault weapon. So these, I think, show that the defendant is a grave risk just because of his irresponsibility in handling these firearms. I think that he poses a significant risk there. Also, while the defendant was in lockup, at some point, he cut his forearm with a piece of tile that he somehow found in the jail, and he indicated that he should have killed himself the day before. So I think that he has shown that he is a complete danger to the public as well as a flight risk, and I'd ask for an extremely high cash bond, at least $500,000 cash surety, no 10%.
And Your Honor, may I just address one other thing? Yes. So when I'm looking at the complaint, and I did bring it to the court's attention, but I think since the prosecutor's here, so count 1 is the home invasion, which has count 2 attached to it, the felony firearm, but the offense date, so the offense date for count 2 was roped in with the March 16th date, and I don't think that's correct. I think count 2 should have been with an offense date of January through February if it's attached to the home invasion, not the March 16th date.
We can correct any of those issues going forward. I did not write the warrant. I know that he was alleged to have stolen the firearms while in the house, and I think that's why the felony firearm had the same offense date as the home invasion.
No, it does not. On the complaint, it does not.
If there are any errors, I'll make sure that's reviewed and corrected. I haven't reviewed that specific issue.
Okay. Counsel, thank you for that. Prosecutor's office, I'm sure you're going to make a note of that. We'll make a note of it here as well to make sure that whatever the date adjustments, if any need to be made, they will be. I'm sure they'll be made by your office. I appreciate that. Yeah, I'm gonna issue a bond amount in this matter, $500,000 cash surety, no 10%. I'm gonna order that the defendant not have any direct or indirect contact. The defendant shall not return of Pontiac. Defendant will not assault, beat, molest, or in any way verbally harass or intimidate any witnesses or complainants in this matter. The defendant will personally appear for all court proceedings, shall not leave the state of Michigan without permission of the court, immediately notify the court in writing of any change of address or phone number. The defendant will not possess any firearms or other dangerous weapons. Shall refrain from using any form of alcohol, marijuana, THC, illegal drugs, or abusing any medication. Going to order that the defendant, upon his release, if he should bond out, to test for alcohol and drugs 2 times per week. Contact pretrial services. If you should bond out, you need to contact pretrial services at Pontiac within 24 hours of your release on this matter, and pick up no new criminal offenses. You have a probable cause conference in this matter, which is scheduled for 3/28 of 23 at 1:30 p.m. That will be at the 50th District Court in Pontiac. Your preliminary exam date will be scheduled for April the 4th at 9 a.m. Okay, any additional thoughts, defense counsel?
No, Your Honor, thank you.
I will grant court-appointed counsel going forward if I didn't mention that. Mr. Prosecutor, anything further?
No, Your Honor, thank you.
Okay, I appreciate that. Thank you very much.
Thank you, Judge.
All right.
All right, Mr. Stallman, you're all set. Okay, you can go ahead and go knock on the door, okay? Your Honor, I'm gonna log back in on the Polycom and I'll come back when I'm done with the rest.
Okay, thank you.
Do you need a court-appointed lawyer?
Yes.
All right. You got 2 charges. You got a Class B misdemeanor criminal trespass. Your bond on that is $10,000 with the condition that you stay 200 yards away from 901 East 5th, the target. Get a GPS in jail. And same conditions for a state jail felony theft of property, and the bond on that is $15,000. Any question about any of this, sir?
Why is the bond so high, 10,000 of missing?
Because they are claiming in the affidavit that since May of 2022 until now, you've been documented with 80 thefts from that particular target with a total value of $7,000 in items taken. So you apparently are well known at that establishment, and they'd like to know you a lot less.
So I have a total, what's my total in bonds?
25,000.
So 10% of 25,000, 2,500.
Well, if you can do math that well, you should be able to understand, stay away from that target.
All right, thank you.
Thank you.
Your Honor, on behalf of Ms. Addis Mike Brown, I just put in dictation a letter for her to make an appointment. Unfortunately, it's probably not going to go out till Monday because my secretary, one of them's gone today and tomorrow because of spring break.
Okay, when do you want this set over?
Oh, I'm sorry, calendar.
1 or 2 weeks or?
No, I'm pretty well booked. I'm going to ask for April the 6th, please.
All right, any objection?
No objection, Your Honor.
April 6th at 2:30.
Where is Ashley? Oh,
All right,
there's
State versus Jose Arevalo, 22 CR 337.
Judge. I'd like to have March 30th with the understanding that Mr. Arevalo will be joining us.
All right. Why is he not here today?
Well, I don't know. I've written to make an appointment back on March 1st. I'm still waiting to hear from him.
Well, that's almost, you know. State's position.
I believe I have an author, well, I do. I thought I had an authorization on file. I sent it to him.
No, I don't see one.
You don't have one? Okay, well, I answered that question then.
I don't see it. No.
Nope, I don't have a stamp file copy in my file either.
The state would propose a 2-week continuance for Mr. Brown to get in touch with his client with him.
All right.
Being ordered to appear in person.
Bond revoked. Do you have a request on bond?
Oh, double the previous bond, Your Honor.
Yeah, I'm in the note taking section. Can you give me a number?
I'm sorry. I don't know what his bond was originally set at either, Judge. I apologize.
Okay.
I see 1,000 OR.
OR bond, of course, nobody goes up on it. All right, I'll set the new bond at 10,000. Cash, professional surety. And see if that works. All right. All right, State versus Luke Baker, 22 CR 140.
I got a council and I communicated, and I just replied this morning to send me that play offer you were contemplating. So I think what, March 30th?
That should be sufficient.
All right, continue to March 30th at 2:30.
Where in the heck is Luke Baker?
State versus Travis Bowling, 22 CR 56.
Your Honor, Mr. Bowling's up there in the upper right-hand corner.
Right here, Your Honor.
And I put in dictation after visiting with counsel an application for diversion. So let's see, he'll probably get it next week. I don't know why we couldn't get it back to the county attorney's office by March 30th.
All right, continue to March 30 at 2:30. Mr. Buchanan, you need to go put a shirt on, okay? You're in court.
What?
I had to move and I don't have my clothes with me. I had to move real quick because I got kicked out of the house I was staying in, so I don't.
Well, we'll wait on you. Go get a shirt or wrap yourself up in a sheet or something.
You don't have, well, he's got a blanket. You don't have a shirt, seriously?
I was just in the, you know what? I got it. Hold on, I got it, Your Honor.
All right. State versus Joseph C.R. Molly, that's 22 CR 191 and 22 CR 199.
Judge, we have those resolved. We could come in on March 30th to enter our pleas, please.
All right, any objection?
No objection, Your Honor.
At 2:30.
Oh, here he is. Okay.
All right. State versus Charmaine Keith, 22 CR 126.
She's in custody, Judge.
All right, is that Miss Keith there?
Yes, it is Charmaine.
I need 10 minutes with my attorney, please.
Well, what are we doing today, Mr. Brown?
Well, it's my understanding we're going to admit that she desires to serve the balance of her sentence.
Yes.
Okay.
I did get your email, ma'am.
Oh, thank God.
Okay, so we're ready to proceed?
Yes, we are.
All right. Ms. Keith, you've heard the announcement of your attorney. Is that what you want to do?
Yes, I have 129 days left on my sentence, and I would just prefer just to finish out the 129 days and get it done and over with and put this behind me and move forward with my life.
All right, then. You understand you have a right to contest the allegations at a hearing in an open court? Do you understand that? Can you
Yes,
hear me, ma'am?
yes, I'm sorry.
All right. It's the state's burden to establish a violation by a preponderance of the evidence. You have the right to present testimony of witnesses and other evidence on your behalf if you wish. If a probation violation is admitted to by you, I can continue, extend, or revoke your probation. I could require you to serve the underlying sentence. You understand all the possible consequences?
Yes, Your Honor.
You understand all your rights as I've explained them?
Yes, Your Honor.
Alleged you failed to report to probation office on September 27th of 2022 to that allegation, admit or deny.
Admit.
It's alleged you failed to, okay, failed to refrain is what it said. It's alleged that you used drugs. Failed to refrain from the use of drugs. The language is just long. All right, it's alleged you used drugs. In particular, it's alleged that used methamphetamine as evidenced by a positive UA on September 22nd of 2022. The allegation that you used methamphetamine, admit or deny?
Admit.
Same allegation and date with regard to the drug of benzodiazepines, admit or deny?
Admit.
All right. And then lastly, it's alleged you failed to make payments on court costs and fines, admit or deny?
Admit, Your Honor.
All right, I'll find that you've voluntarily and knowingly admitted and waived your rights and admitted to the violations. I'll accept your stipulation and find you violated as alleged. State's recommendations?
The state would join in the defense's recommendation to revoke probation and order her to serve the remainder of her sentence, Your Honor.
Mr. Brown, anything further?
Well, that's correct. The initial recommendation was to serve a sanction and reinstate, but as she indicated, she'd like to flatten it and be done with it.
All right. Will be the order and judgment of this court that Ms. Keith, that your probation be revoked and remanded to serve your sentence. Good luck.
When will I find out my exact out date?
I'll send it to you with the journal entry, ma'am.
And am I going to get the 51 days that I've already served?
Yes, you'll get all the credit. We'll take care of that for you.
Okay, thank you.
State versus Michael Ukenna, 22 CR 321. And he's got a jacket on.
Yeah.
Mr. Brown.
The defendant appears, Judge, I just put in dictation yesterday a plea proposal for the defendant with respect to diversion. Let's see, he probably won't get it till late next week. How about April 6th, so we can get that turned into the county attorney's office?
Any objection?
No objection, Your Honor.
Continue to April 6th at 2:30.
Michael, watch your mail.
All right.
Thank you.
Well, Mr. Brown, he mentioned something about not being at his old address. Do you need a new address for him?
Point. Good point.
Yeah, well, yeah, I was gonna send it to my dad's old address because right now I don't got a solid address except that day.
Well, here's what you're gonna do. You're gonna call my office tomorrow and let us know what your new mailing address is, okay?
It's not my house, so.
Well,
I mean, all right.
get a mailing address for me.
I mean, if I give you this address, I don't know if I'm gonna be able to get it from the mail from this address.
Well, you figure out how to get me to get documentation to you, okay?
Are you in Wichita? Where are you at, Mr. Ukenna?
I'm in Wichita right now.
All right. Well, since you don't
Have an email address.
I'm not going to keep continuing this while we play this mail tag. Why don't I just the April 6th?
You guys put on the restraint. You guys put on this court order thing, and
Judge, he has an email address. I can communicate with him that way.
all right.
It's got to order to him to appear in person, and so we don't have this issue. I mean, this is meant for convenience. It's but if it's going to be abused, we just have them show up in person. We don't have this problem.
I don't got a car.
Yeah. Well, then get your mail. Figure out where your mail can be reached.
Here's what I'm going to do. I will email to him the diversion paperwork. We'll set this for April 6th. And hopefully if it's turned into the county attorney's office, we'll be able to make some progress.
All right. If it's not, we're just gonna have the appearances be in person from here on out. All right, continue to April 6th at 2:30.
Watch your email, Michael. Here's Joseph. Okay.
And Miss Federley.
Good morning, ladies. My name is Tanisha Jeffers, and I'm going to be magistrating you both this morning. First, we're going to go over your general rights. You have the right to remain silent. You are not required to make a statement. Any statement you do make, however, can and will be used as evidence against you should your case proceed to trial. You have the right to retain an attorney. You have the right to have that attorney present during any interview with any peace officers or other attorneys who may represent the state. You have the right to terminate an interview at any time. If you are indigent and cannot afford an attorney, you have the right to request the appointment of an attorney. You have the right to an examining trial, which is a pre-hearing. If you're charged with a felony, you will be given a reasonable time and opportunity to consult with an attorney, and you will be admitted to bail if allowed by law. Do you have any questions, ladies, regarding your general rights?
I have one question.
Yes, ma'am.
Okay, so how does the bail thing work if
I'm gonna go over that in just one second. You have any other questions regarding your general rights?
no.
All right, thank you. Next, we're gonna go over the 4 main ways to be released from custody. The first way is to post the full amount of your bail in cash or with the cashier's check. That is the full amount, not a percentage or a payment plan. That money is kept on deposit with the sheriff's office until your case is resolved. Once your case is resolved, those monies are returned to you. The second way to be released from custody is by hiring a bail bondsman. A bail bondsman will in general charge you 10 to 15% of the bond amount to obtain your release from jail. Any fee you pay a bondsman, however, is non-refundable. When you are back at the post, you will be given access to different phone numbers of different bail bondsmen if that is what you desire. The third way to be released from custody is by qualifying for personal bond. A personal bond is essentially your promise to return to court. The fourth and final way to be released from custody is by hiring an attorney. An attorney can obtain either a surety bond or a personal bond on your behalf. Additionally, any fee you pay an attorney to get you released from custody will oftentimes go towards your total legal fees if you end up hiring that attorney to handle the rest of your case. That way, you do not have to pay twice. Regardless of how you get out of jail, make sure you return for all your court dates, or a warrant will be issued for your arrest. Do you have any questions, ladies, regarding the 4 main ways to be released from custody?
Yes.
Yes, ma'am, go ahead.
All right, so it's about bail bonds.
Go ahead.
Okay, so if I already had a bond taken out on me and now I'm back in here, like I'm not gonna be able to get a bond?
Ma'am, you can hire any attorney or bondsman of your choice. The bond has been set, so we're gonna go over your bond amount in a second, but absolutely you can get out. This is not a hotel. We do not want to hold you here unnecessarily. Okay?
I can't stay here long. I can't eat the food here with like medical and stuff.
I totally understand. What's your name, madam?
Wendy Holder.
All right, Ms. Holder, you have been charged with a Class A misdemeanor assault causing bodily injury. The range of punishment on the type of offense in the state of Texas is up to 1 year in the county jail and a $4,000 fine. That bond has been set at $5,000. Do you have any questions, madam, regarding your charge or bond amount? Okay, are you requesting a court-appointed attorney at this time to help you with this case?
Yes, I am.
All right, so ordered. Ms. Holder, the going rate to get out of jail in Travis County right now is 5 to 10% of the bond amount. So that works out to be anywhere between $250 to $500 to any attorney or bondsman of your choice. You will be given access to the phone now that you've seen me, and the number is posted on the phone for pretrial services if you need to contact them. All right.
I have a question.
Yes, ma'am.
So since I was appointed attorney before, like, would that be my attorney now, or would that be something different, or I don't know how that works?
I couldn't understand your question. My apologies.
Okay, so I have an attorney that's supposed to be, I have a court case waiting have an attorney for that? Do I get appointed a different attorney or how does that work?
No, court administration tries to appoint you the same person.
Okay,
All right?
I'm not sure who that is. Is there a way to get that information?
I don't know if it's on here, but I'll look for you. Let's see. Yeah, this paperwork doesn't tell me. My apologies. It just says you had a prior surety bond. So when you get out, you just need to contact court administration. They can give you that name. Okay?
Oh, when I get out?
Correct.
Okay, so I can't use her for Bell's bond because I don't know who she is. So I guess I'll just go.
But you can contact any bondsman of your choice.
Okay.
All right, and then if you have people on the outside, they can contact court administration on your behalf to find out who the name of your court-appointed attorney.
Okay, and you said it's gonna be $250 to $500 to get out this?
If you want to pay to get out, yes, ma'am.
Okay, I can do that.
All right, take care of yourself, madam. Thank you. Next, we have Alexandra Federley. Ms. Federley, you have been charged with Class A misdemeanor theft of property. The range of punishment on the type of offense in the state of Texas is up to 1 year in the county jail and a $4,000 fine. That bond has been set at $6,000. Do you have any questions, madam, regarding your charge or bond amount?
No, I'll be here.
Again, you can post bond at any time on yourself, 5 to 10%.
Yeah, I have the money, so like, how long will I average, like, what I'm doing?
Okay, then I will appoint you counsel, and court appointed counsel will see you in the next day or two. They can obtain personal bond for you as well. Okay. All right, take care of yourself, madam.
Good morning, class. Today we're going to talk about TPOs. You see, I was watching Judge Manning's stream yesterday, and apparently there's kind of a universal misunderstanding about what exactly a TPO is and what its purpose is. So we're going to talk about what it is, and then I'm going to show you an example about how it should be used and how it shouldn't be used. And then maybe we can use this as a learning tool to help, use it the right way. Now let me show you an example of how a TPO should be used. Please notice the clear and concise questions, the clear and concise answers, and how everything is presented in an organized manner with no excess, how should we say, drama added into the mix.
Jessica Fagan for Miss Rose.
All right, Daniel William Rose, Jr. I don't show service. Is he avoiding?
He is avoiding. We actually had him, we have an affidavit of service from Charleston, South Carolina. We had him personally served in Charleston.
Okay, have you filed the affidavit of service over yet?
It's being filed. My paralegal actually just closed on the sale of her home, so she just got back to the office. So she is in the process of filing that right now. And I have emails with him and his attorney where they have notice of today's hearing. And
Who's his attorney? I don't think an attorney's filed on his behalf.
they have not. He says he's going to be hiring Randy Kessler. So I'm not sure who at Mr. Kessler's will actually be handling it. But everyone's on notice and he has been personally served.
Right, and everybody's here. So if, yeah, can you email a copy of that to Ms. Free, even though your paralegal is going to file it? And we'll go ahead since last call for Mr. Daniel Rose. Daniel Rose. All right, Ms. Rose, if you raise your right hand for me. You swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth.
I do, Your Honor.
Down and dirty, Ms. Fagan, get my evidence so we can put it in place.
All right, Ms. Rose, you are under oath. Could you please state how you know the defendant, Daniel Rose?
I married him in 2001. We divorced in 2014. And we have 3 children.
Next question, do you and Mr. Rose have any minor children currently?
We do. We have 3 children.
All right. Has Mr. Rose ever threatened your life?
He has.
What did Mr. Rose threaten?
To put a bullet between my eyes.
And did you take this threat seriously?
Absolutely.
And were you in fear of him acting on this threat?
I am.
And what did you do in response to this threat to put a bullet between your eyes?
I went to the police department and registered it. I went to the court at Fulton County and got a temporary protective order. I called you. I, asked your advice. I stayed out of my house with my children. We left.
All right. Did you?
Several
So
days.
you and the children vacated the residence.
Correct.
And were any of your children aware that Mr. Rose had threatened to put a bullet between your eyes?
They all are.
All right. Was this the first time that Mr. Rose threatened you?
No.
Has he threatened to harm you in some way previously?
Yes. He told me that I deserve whatever pain he can cause me.
All righty. I am going to show you what has, sorry, Judge Manning, it's out of order, but I'm going to show you what's been marked as plaintiff 5. Share my screen. Ms. Rose, do you recognize this document? Simple yes or no?
I do.
And is this a true and correct copy of a text message that you received from Mr. Rose?
It is.
Judge Manning, I move to admit plaintiff 5.
Submitted.
All right, Ms. Rose, could you quickly read the text message you sent to Mr. Rose on November 25th?
I sent him a text that said hi with a wave. It was the day after Thanksgiving. So it has a turkey emoji. It says, I hope you're having a nice holiday.
And how did Mr. Rose respond last Thanksgiving to your hope you're having a nice holiday with a turkey emoji?
He quickly texted back within seconds. I fucking hate you. You are a miserable bitch. You deserve whatever pain I can send you, period. Another text, fuck you, bitch. You are a loser. I think that's a misprint.
And then later in the day, he told you to call him back, correct?
Hours later, after I can elaborate on what happened during that time. But yes, he did.
All right. Has Mr. Rose ever physically laid his hands on you?
Not yet.
Has he ever used his physicality in a way that you felt was to threaten you or control you?
Yes, every chance he gets, and I try not to give him opportunities to be near me, but we do have children together. So he will do things like stand in doorways where I can't pass. He will put his entire top of his body in the window of my car where I have to warn him, please back up. I don't want to roll over your feet, but I'm now going to leave.
Does he ever throw things when he's upset?
He's thrown our dogs.
Do you believe that there is a real threat of family violence occurring in the future if you do not receive this protective order today?
Yes, I know that it's a very immediate threat. I mean, he is demonstrating it, and he's a man who.
Did she say through dogs?
I'm sorry, Judge, will you
Did you say
repeat that?
through dogs?
Oh, yes, he has thrown dogs.
Anything else, Ms. Fagan?
Does he have a history of substance abuse issues to your knowledge, Ms. Rose?
He certainly does.
Is there, do you have any personal knowledge that he has drank and then operated a motor vehicle with your minor children in the car?
Yes, he does that. Boats.
Does he have a history of mental health issues to your knowledge?
And as soon as I found out about that, I have tried not to let the children be with him in a vehicle because of my concern that he's not making decisions that are safe for people, for him, for anybody. I'm sorry, what was the question, Ms. Fagan?
Does he have a history of mental health issues to your knowledge?
He does, yes.
Has he ever threatened suicide?
Yes.
Has he ever threatened to harm third parties?
Yes,
In the past six months, do you have any personal knowledge whether other third parties have called the police on Mr. Rose?
100%, and there are police records for that, several.
Does Mr. Rose own any weapons to your knowledge?
I know he owns a closet, a room full of weapons. Yes, he has rifles, he has pistols, he has handguns. I don't know how to speak in that language, but every gun I've ever seen on any television show, he has them.
Okay. And does he have a concealed carry permit to your knowledge?
He does. He's always had it as long as I've known him.
And is it your testimony today that family violence has occurred in the past?
Yes.
And is it your testimony today that family violence is very likely to occur in the future without this court order?
It is, yes. I'm very hopeful that the court will see my point here. Thank you.
Are you asking, in addition, are you asking for temporary sole legal, like a no contact order with the children as well as with you?
I am.
Are you asking this court to have Mr. Rose undergo a drug and alcohol evaluation?
Yes, and you and I've asked him that for weeks. I think it's 2 months now. We've been asking him to do that for his safety.
But as we hear today, are you asking Judge Manning to order an alcohol abuse
Absolutely
evaluation? Are you asking Judge Manning to order that Mr. Rose undergo some sort of batterers intervention program, an anger management course?
Yes, please.
Are you asking this court if it feels inclined to order that Mr. Rose continue to pay child support as court ordered?
Yes, I'm their sole caregiver.
Are you asking this court for an order that Mr. Rose would continue to pay for the children's school tuition and other expenses as he has agreed?
I am.
Are you asking this court to award you any attorney's fees pursuant to Georgia law?
I am. I'm only here because of his actions.
All right. And how much in attorney's fees do you estimate as of today you've incurred?
$5,000.
All right. Thank you, Judge. That's our case. If you have any other questions for Ms. Rose.
No, Ms. Fagan, do you have the order in Word so that you can do it and put any language specifically about the children, put their information on the respondent's identifying fact sheet, and you can place the stuff about FVF, drug and alcohol eval, follow any recommendation. And does he live in South Carolina?
He maintains a house both here in Fulton County and in South Carolina.
So what house are the guns at?
Both.
Okay. So right now you can get the guns that he has.
Could I get the gun that he has?
Where you're at? Y'all at the same house?
No, we have been divorced for
Okay,
I do not have access.
Okay, so Ms. Fagan, put in there that he has 24 hours to turn over his weapons to, is it City of Atlanta he lives in?
Uh-huh.
Okay, he has 24 hours after getting this order that he turns in his weapon to his local police department. And his compliance date for his FFIP will also be a compliance date where he needs to show me an evidence receipt where he has turned over all his weapons. You will need to send that to the court to show that he has turned over all of his weapons.
To Ms. Free, do you want me to include her email address?
Sure, yeah. You have an order in Word, or does she need to send it to you?
If she could send it to me, I would greatly appreciate it. She can reply to the email with the affidavit that I just sent over.
That's free. Do you mind sending her the family violence Word document so she can put all that stuff in there?
Yes, I can do
Okay,
that.
Ms. Fagan, she says she just emailed you the affidavit. All right, thank you. And you want your 5,000 under the family violence statute?
Yes, please, Judge.
Or if you want to do a separate order, you can do it a rolling Floyd order or just give him 30 days to pay it. If you want it as a Floyd order, do that. If he doesn't pay you by a certain date, we can incarcerate him in Rice Street until he pays it. If you want to do that, though, let me know because we'll do a arrest order later if he doesn't pay it. You want a compliance date on him paying the fees?
Yes, please. I would like a compliance date on that he has turned over the weapons, registered for the anger management course, et cetera.
So can we get him on a compliance in 30 days?
Our next compliance will happen to fall, it's in 2 weeks. So the next one will be May the 2nd, I believe.
Which one do you want, Ms. Fagan? May 2nd?
I think I think May 2nd is fine. I think this might give him the wake-up call that my client's hoping he gets.
Okay, compliance, okay, so you got him, signing up for FIP, starting the, the eval, and definitely, proof of turning over the weapons. He needs to send you an evidence receipt showing them listed and whatever he's turned them over to. All his weapons. Thank you so much, Ms. Fagan, Ms. Rhodes, good to see you, Ms. Fagan, y'all stay healthy and safe.
This is an example of how a TPO should not be used.
Ms. Sims, you may be in your house, Ms. Jackie Sims, but you don't smoke in my courtroom, and you're in my courtroom.
I'm
right
sorry.
now.
I'm sorry, Judge.
That's all right. Go ahead, Ms. Thomas. When did you take this video? Take yourself off mute, Ms. Thomas, and tell me when you took the video.
This video was just from a few months ago, actually.
Okay, what does a few months ago mean?
Let's see. Let's go to it. This was from in June. This the one that I actually have that is recent that actually caught them.
So June of last year. That wasn't a few months ago.
Well, okay.
Right? Well, you got to tell me. Okay, so tell me is there audio to this video?
Yes, it is.
All right, so you're gonna have to let me hear the audio. Don't talk over it, but first tell me, what am I gonna see?
Okay, on this particular day, I was sitting in the back of my truck with my son. This was right before I had to get ready for work. Amazing Sam's came by taking out the trash. We didn't say anything to each other. She went in the house and convinced her mother that I was outside with my son talking about her, which never happened. Jackie Sands ran out the house. Bitch, this, I don't know if we could cuss, but I'm being cursed out. And I'm like, Jackie, what did I do? So I asked Amazing. I'm like, Amazing, what did I do? The daughter proceeds to run down the steps, hollering and screaming. She gonna jump on me. She gonna do this to me. All in front of my son. He's only 2 years old. The baby goes everywhere I go.
Okay, play the video.
Hey, okay.
And don't talk during it so I can hear it. Is that it? I don't hear anything being said.
And I don't understand why, Your Honor. But I mean, you could see far as what went on, another neighbor even had to come and get her for doing what she's doing. She does this all the time, Your Honor, in front of my son. I'm with my son daily. I don't bother nobody.
Okay, stop. Tell me something besides June that Miss Jackie Sims has done to you. That was June of last year. What specifically has she done to you in 2023?
He threatened to jump on me. They threatened to jump on me all the time. Other than that, nothing for Jackie Sims, Your Honor.
All right. Tell me what Miss Amazing Sims did.
Oh, okay.
Specifically, Miss Amazing Sims, and give me dates.
Specifically, Amazing Sims. Okay. Right before I took out this order, finally, I'm coming from the trash. I haven't said anything to anybody. Amazing Sims runs out the door, bitch, this, hold it, all on the porch. Her mother was having a birthday party. That's the thing. And I wasn't doing anything but taking out the trash. I gotta be bitches and hoes. Look, I got my young children. I ain't no telling when these folks gonna find a jump on me. A few months back, this was in February. Her and her mother was on the porch. The mother was right there. Amazing. She wanna yell and cuss and scream. The mother right there with her. She even threw a lit cigarette at me and my son. That's cruelty to children. She had a water bottle. She threw that. The mother knocked it down. I can't say. Jackie knocked the water bottle down. I called the police that night. Nobody came. But the next morning, I called again. And someone did come out. But he informed me that he really couldn't do anything about it because it happened the night before. I have to watch my back just taking out the trash. I wanted to sit out the other night after school. I go to school. My son goes to school. I'm in school for radiology. barely could sit on the porch when I want to, not knowing when this girl gonna come downstairs and try to jump on me. She has ran down those steps so many times on me, and it's beyond ridiculous. And I'm tired of the situation. I want to be left alone so I could just do my studying and better my situation for my children. I don't have time for Miss Sims. I just don't. I don't want to be attacked. I don't want my son to be attacked in the process. My son follows me everywhere I go.
All right, Miss Thomas, slow down, slow down. So far, what I've heard from you is she's calling you bitches and hoes. That's what I've heard.
Throwing lit cigarettes at me and the baby, and like the girl does a lot of stuff, Your Honor, and it's not okay.
This the
This
first.
girl Judge Your Honor, can I please?
Okay, yeah, stand by. Miss Jackie Sims, let me hear from you first.
Yes, ma'am. How you doing, Judge Your Honor?
Oh, go ahead. I'm trying.
I haven't spoke to Miss Thomas in over 2 years. When I go out my door, I go past her door, I mind my own business. Everybody around here know I don't speak to her. I don't say nothing to that lady. And I don't even associate with her. I just pass by her like a tree. I don't say nothing to that lady. I ain't spoke to her over 2 years.
All right, Miss Sims, Miss Amazing Sims, what would you like to say?
Yes, ma'am. I want to clear my name about the lit cigarettes, Judge Your Honor. I have never flicked no lit cigarettes at a child. For one, every time I come outside, Miss Thomas, she rushes outside like she's eardropping at the door. She comes outside when she see me outside making noises. The other day, but it was Wednesday, before we came to court, she's out there barbecuing. I'm out there washing clothes. She has her grill right by our step. She's standing right there at the grill. As I'm coming down the steps with my laundry, she's standing right there backing up, trying to get me to bump into her. I walked over to this red car that we have out here in our parking lot. So company, my friend came over, net pulls her grill in the middle of the parking. Like we supposed to hit her or something. No, ma'am. Ain't nobody messing with this lady, ma'am. This stuff been 2 years ago.
Y'all are standing too close to one another.
Not gonna let nobody lie on my name, Judge Your Honor. This girl is a compulsive liar. She is compulsive. Well, how did I get a video? How did we just have words a few months ago? How did all this take place?
A few months ago, you had video in June. What video did you have recently?
My camera doesn't catch everything, though. I can honestly say my camera doesn't catch anything. But how do we, if it's been 2 years, huh? And I cannot barbecue in the middle of the parking lot when cars are coming by. That doesn't make sense. I was barbecuing.
I remember in Freaknik when I was a cop and people barbecuing in the middle of 285.
I can't barbecue in the middle of the parking lot.
Well, they did. You obviously weren't here for the first Freaknik. They barbecued on the middle of the interstate, broke out the charcoal and everything.
I just want to be left alone. I have not done anything to anybody. Ain't no way I can barbecue in the middle of our parking lot. It's a one-way in, one-way out. Judge Your Honor, we have a spot where we all supposed to barbecue at. It's in a picnic area, and she was all out there in the parking lot trying to get me to bump her. For what? Why you keep picking with us? We're not messing with you. This girl is a compulsive liar, Your Honor.
Ladies, look.
I'm messing with you.
How do you a parking spot bothering somebody?
I know. Muting everybody. This is insane. This is insane. This is neighbors. Ladies. You know, it never matters. I give these same speeches and people roll their eyes. Ladies and women of color, you should be lifting one another up. It is hard enough out here. You should be lifting one another up, protecting one another, looking out for one another, because there's too many women out there that are getting hurt by other people, by their spouses, by their significant others, getting hurt walking up, getting hurt delivering food. And you ladies should be looking out for one another. If it's like when I was a kid, it still took a village. So if there's kids, guess what? If something was to happen and one of your children ran outside, Miss Thomas, I got a feeling, even if Miss Jackie Sims don't like you, that she would go and dash out there and get that kid from in front of the car. That's what a village does for people. Listen, that's the iPhone. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Ms. Reed, we're gonna start bringing people in person. That's what we're gonna start doing, 'cause people are gonna learn how to act in a courtroom. Here. Okay. All right. Don't you light another cigarette, sir. You heard me tell Miss Sims to stop smoking. All right. I'm not gonna put this in place because you ladies seriously need to help one another. It takes everybody helping one another. It does. Don't say anything to Miss Thomas. Don't make her come back here again with complaints. But I do this, and your neighbors, and we all gotta live somewhere near neighbors, and some neighbors don't like each other. Some just don't like them. But don't do this. Just decide you can't get along. But try. You're gonna need each other at some point in time. Y'all place your emails in the chat. Once you do, we'll send you a copy of the dismissal. Y'all stay healthy and safe. Please take care of one another. And you know what? Be more like Michelle. They go low, you go high. They go low, you go high. Y'all be like Michelle Obama. Make us happy. Y'all place your email in the chat. We'll email you copies of the dismissals.
So I doubt that you actually learned something today, because if you were watching this, then you already know all this. But maybe you can show this to a friend who may need a little guidance on what exactly a TPO is and how to use it. Or maybe, you know, they'll stumble across this and it'll help them. Maybe. Have a good day.
Mr. Bunch is now connected.
Mhm.
State of Michigan versus Kenneth Bunch, 22X00169.
Rachel McDuffie for the people. Assistant Public Defender Chinazi Carey, I can rule your honor on behalf of Mr. Kenneth Bunch. Mr. Bunch, can you state your name for the record?
Kenneth Bunch.
All right, so first problem is Mr. Bunch is supposed to be here in person.
Ma'am, I received an email on my Gmail account with the Zoom information. So I thought
told you
that
personally you need to be here in person.
you said that, but I received an email. I'm really confused. I thought I was supposed to do it per Zoom. I apologize to the court. I thought I was following instructions, ma'am.
You got a text message also telling you to be here in person.
I'm not very good with technology. I had to get help
Can I
even
help you
signing
with
into
that?
the.
Bench warrant to issue.
Ma'am, what does that mean?
That means that if you don't turn yourself into the jail, they're gonna pick you up.
I'm confused because I'm not there in person. I received an email saying that it was on Zoom. I can pull it up.
I was very clear with you that I wanted you here in person.
Well, I don't understand the email then.
Well, then I
Do
think
you
I hope
understand?
you don't understand.
How long do I have to do in jail?
$10,000 cash or surety. Turn yourself in and you'll get a court date shortly thereafter.
How long do I have to turn myself in?
Immediately.
Pardon?
Immediately.
I have I do it tomorrow. I have to arrange transportation and I have my MRT class at 2:30. Please.
Let me see the file. I give you the 8 a.m. tomorrow morning, sir.
Thank you. How long do I have to stay? Until my court date?
That's correct.
Thank you, ma'am. I appreciate everything. This is confusion. This is a miscommunication.
There's no miscommunication. The court, if the judge tells you something, that's what you do.
Well, I don't understand. Okay,
You're done
I
talking.
apologize. This is probably my fault. I received an email saying Yes, ma'am, this is my fault, I'm sure.
All right, thank you. So, Your Honor, I just wanted to get that date one more time. I'm sorry, I missed it.
I didn't give a date.
Oh, you, okay. I heard him ask about his next court date, so I didn't know if you had given me a date. I'm so sorry, Mr. Sochi, again.
It's okay. Always glad to be here.
All right. Mr. Sochi, I called it now so that you could leave. He's been in the waiting room for a minute, but
It's okay.
I understand you're
back on the line.
Okay.
All right, Cynthia Bradley, Leon King.
Yes, here.
All right, Mr. King, you gotta turn your camera on. You gotta turn your camera on.
I'm trying. I don't know.
It's been on this whole time. All right, now take yourself off mute. Both of you. Both of y'all. Y'all swear or affirm the testimony you're about to give is the truth, whole truth, nothing but the truth.
Yes, I do.
Okay. Mr. King, you're gonna have to take yourself off mute. Let me see you, not your ceiling. I need you to say yes. I just swore you in.
Yeah, I'm
Okay,
here.
go ahead. Okay.
I'm here.
Ms. Bradley, start with the most recent event, work backwards. Please be specific and please stick
yes,
to the
ma'am.
facts of what he did to you.
Okay, Leon King is my brother. He lives on the property at 5700 Spence Circle, where my 93-year-old mother lives. But I am her guardian and I hold the power of attorney over
Tell me
her.
what he did.
What he did, and I have a video to show it.
Okay,
and this
can you
was
share your screen?
okay. And right here. Is it on?
What's this video of? I don't see it. You're not sharing your screen.
Can you see it?
No, ma'am, you're not sharing your screen yet. Got to figure out how to share your screen.
Okay, hold on.
All right, why are you doing that? All right, what is this video of? Your brother, what's he doing? If there's audio, you got to put share audio too. I can't hear you.
Okay, he is talking to me.
Okay, share the audio. Hold on. Share the audio, back up, play it with the audio playing, and don't talk over it. Let me watch it. So back it up, rewind it. We got to share the audio with it. All right, now play. Okay.
Okay. Where am I? Can you put it?
What day was that video?
Okay, that was on March the 3rd. It was on a Friday. This was at my mother's house. I am, like I said, my mother's legal guardian.
Got that. What else has he done?
Well, he has done this on numerous occasions. This is the time that I had been having my phone to record him doing it. I am just tired of him, and I'm afraid that he will.
Your mother afraid?
Well, my mother had called me, this is a few months ago, because he plays music real loud And she has been concerned, but no, she's not afraid of him, but I have to take care of her. I have to
You're
be
afraid
at the
of him.
house.
Has he ever threatened to hurt you?
Well, just as far as getting in my face, saying horrible things to me, like he had that beer bottle. I mean, he could have hit me with that.
Okay, Mr. King, let me hear from you. Take yourself off mute, Mr. King. Take yourself off mute.
Okay, now you can speak. Go ahead.
She can hear you now. Ma'am? I need to see your face. Turn your camera back on. Go ahead.
Turn the camera back. Now, see, I don't know about.
Okay.
Just a second.
Okay, leave your camera on and just speak. All you gotta do, hand him his phone.
Ma'am, can you see me now?
No, I can't.
She can't still see. She can't see me. She can't hear me.
I can hear you. Stop turning the camera off.
No, ma'am, I'm not doing anything to the camera.
Well, it's on, then it's off, then it's on, then it's somebody. I'm not doing it. I can't.
Well, can you see me, ma'am? No. Hello? Ma'am?
No, I cannot see you.
She can't see me.
She can't see him. Is anybody ready that knows what they're doing? Anybody? Well, how Bonius, you couldn't make your stuff getting going at first. Now all of a sudden you got audio.
I'm ready, Judge.
Oh, is he now? Bring him in here. Bring Mr. King in. We got a deputy. Get a deputy up here and bring Mr. King in this courtroom with a deputy. I'm gonna get back to you. It's free. Get a deputy and bring Mr. King in my courtroom with a deputy.
They're right here.
Get a deputy now. I know it. Get a deputy right now.
Wait, she's saying
Just stand by, Mr. King. I'm gonna hear from you, but I'm gonna hear from you right in here. I'm even gonna invite this little camera right here. I gotta bring in here, but I gotta have a deputy. It's gonna bring you in here.
Let me get my stuff.
Just hold on, Mr. King. We're gonna get a deputy in here.
Yeah.
Hold on, we're gonna get a deputy in here so I can hear you. You're gonna stand right here in front of me. So just have a seat.
Yes, ma'am. All right.
All right, hey, bring Leon in. Bring the man in here. Let's see how he's doing, because I hear he's stumbling drunk. Come on, Mr. King.
Turn this off.
You can turn your phone off and you can sit down at that table. You turn your phone off. How much you had to drink today, Mr. King? You have drank absolutely nothing. If I do a whiz quiz up here, you're gonna pass it. You been taking any drugs? Two beers. So you decided you're gonna drink a couple of beers before you come to court. But that's before you came to court, because you've been sitting out there for, you're on the 11 o'clock calendar, right? So what time did you drink these two beers? 4 o'clock this morning. You come up here drinking. How'd you do it? Y'all done a some field sobriety test? Because I can go back to my days and do one. Y'all did it? See how he's doing, heel to toe. Do some little field sobriety testing on him. One of y'all, either one of y'all field sobriety certified? You? Go ahead and try.
I bet Justin Spiesman can do it.
I bet he can. I tell you what, sir, come right here in front of this wall, in front of the podium. Okay, so I'm going back to my good old days. That's it. Come here. Take you there. Ready? I want you to take 5 steps. Heel to toe. 1, 2, 3, listen, 4, 5. Down, down, down. Turn around and do it again. Heel to toe. Okay, heel to toe. Heel out loud.
1, 2, 3, 4. 1, 2, 3, 4.
Now what's this? So touch every finger. 1, 2, 3, 4, 4, 3, 2, 1. You did so good on that one. Oh yeah. Yeah, don't move yet. Did you drive up here? Did you drive up here? How did you get here? I suggest you not drive going back. Yeah, that's what I suggest you do. Mr. Spiesman, you didn't get to see me do my field sobriety test.
Judge, I was really looking forward to that too. I'd wonder if you still remembered your SFSD training.
I do. 2
That's
beers.
surprising.
All right, hold on a second. Look at this on this one. Mr. Leon, I'm gonna leave it up to these deputies if they think that you shouldn't have showed up here drinking like you're drinking, because that shows absolutely, I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink. Go on and bring Mr. King in here. Why you pull that up? Let me let these other people. Mr. King, today ain't the day. Ms. Bradley.
Yes, I'm sorry.
Tell me what else he's done to put you in fear.
Yes, every time quite a few times I go over my mom's house, he does the same thing. He wants to be in my face. He's saying horrible things to me. Now, my mother's 93. She has Alzheimer's. She can't speak for herself, so I am the one that she appointed to be her voice.
I got it. All right, Mr. King. Go ahead. Let me hear from you. What do you have to say? That you mean talk, make sure we can hear you through that microphone.
And she had this one tooth gone. She had cancer and was on dialysis. She passed her hand and everything. And then she destroyed not the valve, not the business. They destroyed the business and they built it. And 2 years later, I was getting all kind of lawsuits. All kind of lawsuits, you know, because they ran all these deals up in my name. And that's why basically I'm so upset with it.
Okay, here's what we're gonna do. We're gonna get this back on track. Explain the video that I saw. The video that I saw.
Video. Our water went out. It was froze. She called 10 points. I think someone told her they'd see her. We have no water, y'all. My mama didn't have no water. I went out, got some buckets. She didn't get on my belly. I went out, got some buckets, bought everybody some water. Our water was off for a long time, couple weeks. Then council finally came out.
Why did you show out? Why did you act like that in the video? Why did you act like that in the video?
She thinks everything has to go through her. No, I've been staying in a resident for 30 and maintaining it for 30 plus years. I'm the only one that keeps that resident. I take bread, I get pain, I take the plan, do everything. So that's my mom. And she
Your
don't
mama
do
is
whatever-
96 years old,
93.
93 with dementia or Alzheimer's, and you go out at her house and you act like that.
No, I would-
Well, where was that video? Wasn't that at your mama's house? But that was working, the way you were talking. Keep going.
Now, let's go show took her head and said, I don't care. And that's what made me upset. She didn't care nothing about ruining my life. She didn't care nothing about ruining her husband. You know, a lot of people like, you know, she is a control freak. I can think of all stuff about this. You know, I mean, I love her because she's my sister, but she got some nasty things. And I have not.
Miss Bradley, what is it you're asking for?
I'm asking, Your Honor, for the TPO, and I would like for him to move out of the residence because he's not going to get any better. I don't live there, but he has a house right next on the property. I would like to have him
move out of his house.
It's my mother's house.
Is she living there?
Yes, ma'am, she is.
You live in the house, and do you live in the house and act like this with your mother?
It's the guest
He
house.
didn't live in the same house.
It's the
Why am I
guest
gonna
house
put him
right
out on the
next to
street?
it. I'm sorry?
Why would I put him out on the street if he doesn't have a place to go, if he's staying in a guest house? He's not staying in her house.
The house is on her property. I just want to
I
feel
know what a
safe.
guest house is.
Yes, ma'am. I want to feel safe when I go to have to see about my mother. I could go over there at midnight if they call me, if they need me. He makes me feel unsafe. He was waving that beer bottle. He could have hit me with it. I don't know what he would do. Everybody, he's a bully for one thing.
Stop talking.
Okay.
What do y'all do when folks show up like this at the courthouse? Because I smell alcohol on you. You drank more than 2 beers and you did it more than at 4 a.m. So why don't you come clean? Because it will help you a lot more if you shoot straight with me. You drank them before 4 a.m. You didn't drink those beers at 4 a.m. And just start drinking beer. Why do I still smell it? I was thinking about reading your rights and putting you in contempt, but tell you what I'm gonna do, I'm gonna let these deputies, because they don't want to do the paperwork, make sure that you get an Uber. Drive that car off and you're gonna go to jail for DUI. You don't need to be driving, I'm telling you. I ain't a cop no more, but I did do my field sobriety test because I know him. And if you don't, Mr. Spies in here, if you get that DUI, does good DUI defense, you probably want to call him. Make sure he doesn't drive away from this place, will y'all? Get him out of here. Don't you ever show back up at this courthouse drinking. Let's move. Get him out of my face. I'll put this in place. Stay away from your sister when she's up there and have a little respect for your mother. I understand, but don't show out like that with your mama there. She needs you. That's fine. Ms. Bradley, put both of y'all's emails in there. I'll get it somewhere where I can send him this.
I'm sorry, Your Honor.
Put your email address in there and somewhere, an address that we can send Mr. King his copy.
Okay, so is it?
I'm putting it in place, ma'am.
Okay, thank you so
Stay
much.
away from you. But he's not, I mean, he's there. He helps take care of the property. He's gonna stay away from you when he comes there. I'm not
okay.
making him move out. He's gonna stay at least 20 feet away from you. You got it?
Yes, ma'am. I
Okay,
did.
put your email in the chat. Once you do, you can leave and put somewhere that we can send a copy to Mr. King. If there's an address.
Your Honor,
you
may I
can-
ask you one question,
No,
though?
you can't. I
Please.
just want you, no, you really
Okay,
can't.
all
I'm
right.
sorry, it's a long day. And people
I
know,
understand.
this is in place. I'm not making him move. He obviously takes care of that property.
No, ma'am, he doesn't. The property
Well,
looks,
okay, he said, I don't have proof that he does.
okay,
If there's a
all right.
woman with dementia or Alzheimer's who needs everybody to come around her, and if you ain't cutting the grass, he can live in that guest house, but he can't come within 20 feet of you if you're there. If he does, he will go to jail. If he shows back up here at the courthouse again and walks into this courtroom drunk, he's gonna go to jail then. Now, place your email in the chat and please place
I
an
will. Thank you.
address where we can mail a copy to Mr. King. Thank you.
Thank you.
Court calls the case of the people versus Shabab Jackson.
We're ready on that matter, Your Honor.
Laura Willenbring for the people.
Mr. Jackson, could you state your name for the record, please?
Shihab Jackson.
Your Honor, today is the date and time set for the probable cause conference. My client respectfully requested this matter be set for preliminary examination at the earliest possible date.
April 4th, 2023, 9 a.m. before me.
What happens before now and then with concerning bond?
You're out on bond now, Mr. Jackson. Is there some aspect that you want to have addressed?
Yeah, I have to, well, it's Ramadan right now, and I have religious obligations as well as work obligations in general. And for some reason, it wasn't a drug case or have anything related with drugs. And I'm on what do you call it? The daily reporting thing. And I believe I may have, I think I missed mine yesterday. I don't mean to be in violation, but I'm just sort of struggling with that and confused as to why that is.
Your Honor,
If there's a way to lessen that, or like, I don't see the reason for being on for drug testing.
Your Honor, having heard what Mr. Jackson has stated, we'd ask that the tether aspect or the drug testing aspect actually be reduced in this case or dismissed in this case. As he stated, there is no drug aspect to this case whatsoever. And this just serves as an added burden on him.
He's on intermediate supervision.
I'm not sure why.
I'll handle it, Mr. Jackson. I got you.
As set by the magistrate back in the beginning of March. I'm disinclined to change that at this point. I guess I'm not sure why his testing, why Ramadan would interfere with his testing. I understand that he may have certain obligations, but I have other individuals who are engaged in the celebration of Ramadan who aren't having these issues.
Well, it's not celebratory, sir. I just fail to see the connection with the nature of my case and having to go out of my way and pay money that I really don't have and time that I don't have to drug test on this matter, especially.
That's not a basis for me to change it. I thought that what he was indicating, because he had started out that it was Ramadan, and I thought that there was some interference with what he had to do, but I'm not changing it. I'm going to leave his bond as continued. We can see him on the 4th.
Thank you, Adam.
Your Honor,
Thank
may
you.
I address two matters briefly?
Is there?
Yes.
Hold on, Mr. Jackson.
Your Honor, I believe his name was spelled incorrectly on the complaint. I understand it's properly spelled S-H-I-H-A-B. It was spelled
So
with an
no,
extra B.
no first B.
That's correct, Your Honor. And his date of birth was incorrect on the original charging documents.
So is it not possible to amend the drug testing, Your Honor? I understand is it just a?
Okay, so hold on.
Yes,
Hold
sir.
on. I think I already said that. And I wasn't gonna say anything. I will make, Ms. Williamberry, I'll make all the changes that you want. I'm just gonna tell you something, sir.
Yes, sir.
What, I will do what I can for people. I am
Yes,
also
sir.
very of those that work around me. I got a message that you were very insulting to my clerks. So
To who?
you ought to be, that I'm
Mr.
letting
Jackson,
you.
stop talking.
I can't hear. I'm just seeking clarity, sir.
Mr. Jackson, stop talking.
I'm not talking, sir.
So,
Okay.
see, it's that attitude that's the problem. So what I'm
Sir,
gonna
I'm a
do
young black
is I
man
will,
fighting for his
Jackson,
rights.
not interrupt.
I'm listening.
you need to be quiet.
I am. Sir,
Mr. Jackson, let the judge talk.
I'm
And
not,
don't-
I understand. I'm not sure if there was a mute or something. I'm just making sure. I understand.
Okay, so you don't have to respond to everything that's said. You don't have to get the last word. That's not a
I'm
good.
not trying to. My life is on
Okay,
the line here.
all
That's
right.
all. That's all I'm.
Okay, you know what? You know what? Put some deputies at that door right now, right down there at the door. Because he apparently just called security, get him down at that door, because apparently he doesn't want to listen to his attorney, he doesn't want to listen to me.
Sir, I'm just seeking clarity on the matter. That is all. I promise. I'm a black man in the system, just trying to fight for his freedom. That's all.
Okay, so am I. So
You're
don't
not
even
fighting
try
for your
it.
freedom,
Don't
sir. With all
even
due
try
respect.
it. Don't even try it.
Don't even try
Alan,
what,
get
sir?
down there.
Tyree
Get down
Nichols,
there.
sports
Get
black
down there,
officers
Alan.
beat black
Just
people.
get down there.
sir.
Take him in.
I'm
I'm
not-
gonna find you in contempt for interrupting the court.
I'm not. trying
Mr.
to-
Brown, if you've got somebody down here,
Sir,
he
I'm
can
just
come in,
seeking-
he can see me in person. We'll wait for a prosecutor to get down here and I'll deal with this in person. I'm passing it right now, but right now he's being taken in because I'm not dealing with
What
him.
if I?
I'll
Sir.
pass this matter.
Sir,
Mr. Jackson, if you will just maintain your.
Court does call the case of the people of the state of Michigan versus Jessica Lynn Kyle.
Mr. Ganatra, First Assistant Prosecuting Attorney on behalf of the people.
Zachary Ward on behalf of Ms. Keel, Your Honor. Can we approach very briefly on this matter?
You really want to go into a room with me
Your
right
Honor,
now?
Your Honor,
Sure,
I don't
fine.
think.
Yeah,
Your
give
Honor-
us a bench conference.
Your Honor.
Put Mr. Ganatra and Mr. Ward into a room with me. Be up? Yeah. Okay, I just had to turn mine back on. Court recalls the case of the people versus Shaham Jackson. Counsel, state your appearances.
Laura Willenbring for the people.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Jackson. Mr. Jackson, would you state your name for the record, please?
All right, we're here. I set this already for preliminary examination, and it didn't seem to me, quite honestly, that the defendant was being cooperative with anything, and I didn't know what his problem was. And so I was considering revoking his bond and having him sit. But I would like to give him an opportunity or have counsel explain to me what's going on with this young man, because the behavior was unacceptable.
Your Honor, I've had an opportunity to talk to Mr. Jackson, and I want to start with that. We did talk about, and I was able to explain to him what contempt is considered in court. We went over that the definition is a willful act, omission, or statement that tends to impair the authority or impede the functioning of the court. In the course of our conversation, I learned that in 2015, so approximately 7 years ago, during Ramadan, Mr. Jackson was incarcerated and his grandmother died, and he was unable to get a pass, go to the services, spend any last few days with her. And so this time frame specifically is very triggering, but definitely with him being involved in court again. He has indicated that he would allow me to do the talking today to demonstrate just what he's doing right now. And so with that, we are asking that Your Honor give him another opportunity to come into court on his own.
Is there anything from the people?
Your Honor, just two things briefly. I was in the process of amending his name and birth date. I did send an amended complaint over to the court. I
We
also
have received that. Go ahead.
I also wanted to mention that defendant has come to our office a few times and did drop off some materials, including a flash drive. Defense has been notified of that. And he has also tried to be connected with either myself or another APA in our office, but has been told that we cannot communicate with him because he is represented. So I just want to make sure that he understands that neither myself or another APA will be talking to him directly because he is represented by the Public Defender's Office.
All right. Thank you. I realized he wasn't going to say anything, but yeah, please.
So in our discussions, Mr. Jackson and I, we did talk about the fact that our office is representing him. Specifically at this time, I am an attorney, and that is part of my job, is to participate in the court proceedings. So yes.
Well, and I'm going to tell you from my standpoint, he kept trying to overtalk me, and that ultimately, and you can tell him Ms. Gaines, anybody that's been before me, that will never happen. And then, but what was so bad is the person that's trying to help you, Mr. Brown, is trying to get you to be quiet, and you kept talking. And I don't know where you thought you were going to get to, but I can tell you right now, you do that in my court, this is where it leads. I can't tell you necessarily that you're going to listen to your attorney, but you're certainly not going to sit up there and interrupt them. And I'll tell you, I've been doing this for a long time. And when I see somebody that's not listening to their attorney, especially somebody that's esteemed as Mr. Brown, and others telling you what to do, that's a person that's not going to listen to anything. I have to almost believe they're not going to listen to anything I'm telling them to do. Those are the people that end up getting themselves incarcerated. I'm then also very disturbed that you've got defense counsel, and then you're down at the prosecutor's office. I don't even know why you're down there. Well, you're trying to give them something or whatever, and you're trying to give them something, haven't told your attorneys that what you're doing. That doesn't even make any sense. It's almost like you want to get locked up. I will be honest with you, sir. I looked at the charges and see your previous record. I get what may have happened to you in 2015. I see the timing of it when I'm looking at your record, but then I see what you did afterwards. Whatever your thoughts are, you just got to do better. There is no reason coming in here today that this should even be occurring. Tell you what, I'm going to trust Ms. Gaines. Ms. Gaines tells me that I should give you another chance. And Mr. Brown told me the same thing, that I should give you another chance. These are these people you won't listen to, by the way. But if they tell me to give you another chance, I'll give you another chance. But I'm gonna let you know. You don't have any other opportunity with me to mess up. You mess up, I'm sending you. Am I understood?
That a yes?
I'm also gonna add so I will continue his bond. He can be released to custody. I have the amended complaint. I am going to also add as a condition of his bond to be entered into lien that you are not to go within 500 feet, except if you're going to, well, that's outside of the 500 feet of the Washtenaw County Prosecutor's Office in downtown Ann Arbor. You understand that?
He's gonna get it yesterday.
Pardon?
He's gonna get it yesterday.
All right, very good. So we're adding that to lien. So I want you to know what that means. If you're within 500 feet of their offices, police officers come on you, they can arrest you on that. So don't say you didn't understand because I explained it to you. Anything further?
No, thank you.
All right, his bond can continue. He can be released. Thank you, Ms. Willenbrink, for waiting around.
Thank you, Your Honor. Trying to figure this thing out with this podium on, but it's not working. Ms. Free, can you come mute? All right, there's going to be a little feedback because somebody's been in here messing with my system, so. So, Ms. Simmons, start with the most recent event. Tell me what.
So February 1st, I arrived at Mr. Harrison's residence to pick up our son Preston that we share, but he is not legitimized. I did let Mr. Harrison know that I didn't want to talk. I just wanted to get my son and leave. And he persisted on trying to talk, and I tried to, get my son ready to go, and he persisted and persisted, and the conversation escalated to the point where I told him to just go in his room and allow me to get my son ready, in which he got upset and grabbed me and told me, "Watch who the fuck you talk to." I responded in self-defense when Mr. Harrison, then he grabbed me and he lifted me in the air and slammed me on the ground right in front of my son. When I got upset, Mr. Harrison went and grabbed his phone and started recording me and started pushing me out the door. I kept saying, "I just want to get my son and leave. I want to get my son and leave." He kept pushing me out the door with the phone in my face. When I knocked the phone out his hand and I managed to move past him and grab my phone in my purse, and I tried to reach for my son, he then took me to the door and literally lifted me up and threw me out the house. After that, the situation escalated where a reporting was presented to the police, in which I can't speak of because it's an open case. However, there is against me a no contact order in which I've been honoring, and I have not contacted Mr. Harrison at all since the incident. And since we share a son that has not been legitimized, I had removed him on the pickup list for the son because we do not have a parental agreement. On February the 6th, I received a phone call from the school because Mr. Harrison arrived at the school causing a commotion because he's trying to pick up our son, Preston. The school then, distraught because they didn't know what to do. They're not used to situations like this and they don't understand the Georgia law.
Doesn't matter about that, move along.
So Mr. Harrison, they relieved Mr. Harrison, they released my son to Mr. Harrison, in which, because we have a no contact order, I had to request a police escort. The officer, he didn't, yes?
No contact order because he was arrested?
No, it was a no contact order because I was arrested because of the footage on the video. So we share a son together, which he isn't legitimized. He took my son from the school, and I had to contact the police to receive a police escort to obtain my son. The detective had contacted Mr. Harrison. I do not have a police report because Officer Edie did not write a report, but I obtained a copy of the phone call the detective made to Mr. Harrison, in which the call he acknowledges that my son had not been legitimized, acknowledged that there was a no contact order, and in the end, he was advised to get my son legitimized. And he was also defiant against the detective when asked to return my son. He said, well, what if I don't return him? Which gives me cause to believe that this may happen again. Mr. Harrison has, I've not received any information about Mr. Harrison attempting to legitimize my son, but he has emailed me numerous times about contacting me numerous times to pick up my son. And he has also had friends reach out to me. And when I went to the office, to the police station to inquire on how I can protect myself from him contacting me with this, because I feel like I'm being baited to contact him and avoid him going to my son's school and picking him up. He suggested that I get the CPO. There has also been situations.
Is there a pending legitimation case?
Not
You know where Miss Free is? Okay. Miss Free, the deputy's looking for you. Is there a pending legitimation? Sir, have you filed one?
No, I'm actually hiring a lawyer. I'm actually about to go for full custody of my 40-year-old son.
Yeah, I don't care about all that. I just said, have you filed a legitimation case?
No, ma'am. No, Your Honor.
So, I'm sorry, everybody, but somebody has messed with the whole system in here. If there's an echo, I apologize. If I mute myself, can't hear. I don't even know how to fix it. All right, let's see. Let me hear from you, sir. What about this throwing her on the ground, etc.?
All right. So my son and we share 2 kids together. So for the past 2 years, I stayed right around the corner from my son's school and around the corner from my daughter's school. So for the past 2 years, Monday through Friday, my daughter and my son come over to my house. I go pick up my son from school every day for the past 2 years. All right. So the weekend before February 1st, I have another daughter. Her mom's name is Erica. My daughter had a birthday party and she didn't want the children that me and Miss Simmons share. The children that me and Miss Simmons share together, she didn't want them around my other daughter's mom. So on February 1st, my daughter, she didn't come over my house. And so I was concerned. So I was calling my daughter. She just turned 14. I was calling my daughter and I was calling Miss Simmons. Nobody responded to me. Nobody responded to my text. So when she came to pick up our son, and when she came in to pick him up, I asked her, I was like, have you talked to Trinity? Because she hasn't came to the house. And so she automatically upset, like, yo, I ain't talking to you right now. So I'm like, I just need to know if you talked to Trinity, like, is she at your house or is she at my house? I can't hear you. I'm sorry, Judge, I can't hear you.
I just need to know if you slammed her on the ground.
Oh, never. She got upset, and she put her hands around my neck. And I said, you gonna do this in front of our son? And so I took her hands off me and I ran to my room and got my phone and I recorded everything on the phone. So and on the video, she's punching me, she's slapping me, she's trying to choke me. And so I called 911 and I requested the police. I said, I have a lady and I got the videos, I could screen share.
This day is the day she was arrested.
Yes, ma'am.
Do you have video you want to share?
Yes, ma'am.
Okay, can you share your screen?
Mm-hmm.
Y'all can bring Mr. King on in. As soon as I finish this, we're going to take it up with Mr. King.
I will get him.
Get
I
off
will
of
get
me.
him, bro. I will
Get
get him.
off of me. Get off
I
of
will
me.
get him.
Walk away from me, dog.
Nigga, you in
Walk
my
away from me.
house. Just get out
My
my
shit is
house.
over there, and my son
I'm
is
gonna
over
get
there.
him, bro. Why are you doing this? Why are you doing this, bro? Just get out. Just get out, bro. All right, that's one.
Fuck out.
I'll get him, man. I'll get him. Just get out my house. If I knew you was coming like this, dog, I wouldn't have let you in my house, bro. Just get out my house. Just get out my house. Just get out my house. Just get out my house.
I'm trying to get my son.
Just get out my house, bro. I'm gonna get him. I'm gonna get him. Just get out my house. Just get out my house, bro. You done already put your hands on me, bro.
No.
You done already put your hands on me. Get out my house, bro. Just get out my fucking house.
Get out of. Of course you would. Of course.
Go ahead and get out my house, bro. I'll bring my son outside. I'll bring my son outside. Go ahead, bro. Go ahead. You done already put your hands on me and tried to choke me, bro.
You just threw me on the ground.
Cause you fucking choked me, dog. Go
on the
ahead.
ground.
Go ahead. Go ahead. Get out my house, dog. Get out my house. I'll get my son.
I'm getting him.
I'll get my son, bro. It was my daughter's fucking party.
I told you to leave me alone.
It was my
Get
daughter's
that shit out my
party.
face. Get that shit out
It
my
was
face.
my daughter's party. How is my daughter's party? And you don't want her there?
I don't want a pet
Bro,
them.
just get out my house. Go ahead. You going to jail. You going to jail. You going to jail. You going to jail.
You put your hands
You
on
going
me.
to jail.
You put your hands on me.
You
Go
going
ahead.
to jail.
Get
Don't go in my house.
Get off
You
of
going to jail. You going to jail.
me. Exactly what you want.
Go ahead, son.
Get off of
No,
me.
don't touch me.
Get off of
Don't
me.
touch me, bro.
Get off of me.
You going to jail.
Get off of
All right, anything else from you, Ms. Simmons?
Oh,
Yes, Your Honor.
Oh, well, let me see if she has anything she wants to say about that.
As you heard in the video, I stated you just threw me on the floor, and he admitted to throwing me on the floor. And he just stated in open court that he did not throw me on the ground. I know this was not the best light of me, but this was after I've been assaulted by Mr. Harrison. And in the video, as I was completely honest and letting you know that the situation had escalated, and I was trying to get my son, and I just wanted to get my son and leave. And he refused to let me get my son and leave. I did not want it to get to that level.
Anything else, Mr. Harris?
Yes, ma'am. Again, like I said, I've been picking up my son for 2 years. Like I said in the video, if I knew you was gonna come up acting like that, I would have never let you inside of my house. I got the paperwork with the case number. She went to jail. If I put my hands on her, I would have went to jail. But I recorded everything, according to 911 phone call. I said I do not want to hang up because I do not want to be said that I did something that I didn't do. So she went to jail. And as far as the emails and the TPO requests that she said, and I got screenshots of those too. Only thing I said was, Courtney, I just wanted to see my son. I just want to get my son. So when she called the police, when I picked my son up, it was a Monday. I went to go pick my son up like I always do for the past 2 years. So when I picked him up is when the police officer called me and said, if I don't bring him back, it'll be kidnapping because of legitimation. And I brought him back.
Have anything else?
Was that question for Mr. Harrison?
Well, that's for you. Anything else you want to tell me?
Yes, there has been incidents with my daughter, with Mr. Harrison in January the 26th. Mr. Harrison and my daughter and my son and another child were at Grindhouse. My daughter had made me aware of him taking my daughter and body slamming her on the ground. The incident was caught on video on the Grindhouse cameras. I had contacted the owner, and the owner indicated that he was going to call the police. I have the recording of the phone call between me and the owner of Grindhouse, and he indicated that he was going to call the police because he can only authorize.
Listen to it. The owner of Grindhouse isn't here.
According to Georgia law, it's a one
I
party.
appreciate you teaching me that. Let's do this.
I'm sorry. I'm not trying to offend you, Your Honor, but this was.
No, you didn't. But there was a lawyer earlier that tried to tell me that an opposing party couldn't call the respondent as a witness. But according to Georgia law, no, he is not here. I can't hear this recording. Is there anything else you need me to hear?
May I play the recording of that was an open record, so the phone call to the
Who is the phone call between?
But between the detective and Mr. Harrison? This is an open record.
It doesn't matter, but the other party isn't here. Both parties have to be here. Anything else?
I have emails between me and Mr. Harrison.
From when?
Recently, and from the past, we've also
recently mean? Tell me what recently.
This year, and in 2018 when I was pregnant with my son.
Not 2018. What is recent? Are they threatening messages, and what is recent? Because this video that I saw, when is Mr. Harrison, is the legitimation case been filed?
No, it hasn't been filed yet, Your Honor.
When do you plan on filing it?
I didn't know if I should just do the legitimation on my own or get a lawyer, and once I legitimize, go for the full custody.
When do you plan on? Have you met with an attorney, or when do you plan on doing it?
I'm talking to a couple right now. I got some recommendations. One name is Jeremy Robinson, from JR Law Firm.
I'm not making any recommendations. It doesn't matter who you're talking to. Y'all are gonna have a guardian in this. Anything else you want to? I'm just telling you ahead of time.
Mm-hmm. Yes, if possible, I can share a text message that she sent to me a week before while I was at work, where she says in the text message, "I'm going to make your life hell." If I could show you the text message and the email.
Text message, and then Ms. Simmons, you can have the last word. You're still on mute, Mr. Harrison, but I'm reading. Oh, Mr. Harrison, take yourself off mute. I can't hear you.
All right.
There you go.
All right. So yeah. So yes, ma'am. It was 2 days before the situation happened. She texted me out the blue. She wanted to argue. I even said it. I'm like, it's 2 a.m. in the morning. It's 2 a.m. in the morning, and you want to start an argument while I'm at work. I just want to get down a little bit.
Okay.
So you can
need to read it. Go back down. I mean,
Oh, I wanted to show you. I just wanted to show you the time up there. But I wanted you to see where I told her. I said, okay, Courtney, you can continue to be controlling and aggressive, but I'm not into that. So go ahead and text and argue with yourself. And when you want to be grown, you can contact me, because this is what I'm not about to do anymore. Right? So I stopped texting her. And this is what she said, Your Honor. She said, "You create your own drama. You have done nothing but disrespect me." I'm gonna scroll a little bit more. So I want you to see what she said. She said, "I am your worst effing enemy from here on out. Do not think you can sleep peacefully. Rest assured, I will make your life hell. You will regret effing with me."
all right. What else you got to say, ma'am?
These messages were a result of a reoccurring. Whenever I break things off with Mr. Harrison, he brings his, mind you, he's married and he has a child with his wife, and which is not Erica. But Erica is a woman who assaulted my daughter. It has relevance, and I
well, it's not, because this isn't against Erica. This is against him and not her. So that doesn't matter. This is between the two of you.
May I share my screen and show the emails?
Is this between you and Mr. Harrison?
Yes, ma'am. Yes, Your Honor.
When was it?
It was November of this last year. And it's just in relation to
emails about.
So Mr. Harrison is texting me.
See, no, you just tell me what it's about. You say it's about picking up the kids. It's about picking up groceries. That's what I want you to do. What is it about?
It's a random message he emailed me of a text message, and it's just showing. It shows how.
Is this a violent email? Or is it an email about Or you want?
It's difficult to explain. May I just show the email? I do apologize. I've never done this before.
Judge, I was wondering if my name had got called. I kind of got into the chat late.
Yes, if yours expired, you're gonna have to refile. Like, hold on. Hold on, let's make sure. Yep, yours is expired. You're gonna need to refile, ma'am.
Okay, thank you.
Go ahead.
Do you see my screen now, Your Honor?
Yeah, I just see a tiny, tiny picture, but yes, I see something.
Do you see it now? The
See a
email?
tiny picture, like a little screensaver. That's all I can see.
Is it still not showing?
Nope.
Okay.
Nope, still not showing.
I see what it has to do.
Still just a black screen. Are you these supposed to be the next one? Okay. Okay, that's it. You can't figure it out, Miss Simmons. You know what? I mean, I'll tell you what, we're gonna stand down because I'm gonna take this lawyer's case right here. And then I have to call and cancel my plans for the weekend because I'm not gonna be able to get out of here. So I'm gonna be back in a few minutes. Just give me a second. Just give me a second. I'm gonna take the attorney. Miss Simmons, you have one more chance. Can you share your screen? Not working, Miss Simmons. Not working. And I can't hear you, Miss Simmons. You're on mute. Anything else you want to say? Miss Simmons, I can't hear you. I mean, I can't hear you. I can't hear you. I cannot hear a word you're saying.
Can I say thing?
But Miss Simmons, I say you're not on mute, but you're not connected to a microphone. Go down to that little microphone, hit that arrow button up and connect to the microphone that you want to use. Because you are not connected to a microphone that's functioning.
Can you hear me now?
There you go. Now what else do you want to say?
I do apologize about that. I'm not very good with technology apparently, but I understand how damaging, I came into this courtroom with the understanding how damaging that video would be, and understanding that I had a no contact order against me. I was willing to honor that no contact order, perfectly happy of honoring that no contact order. I've made attempts to distance and create boundaries for me and Mr. Harrison, but Mr. Harrison continues to implement methods to try to be in contact with me. Mr. Harrison did pick up my son that day, understanding that we did have a no contact order, and that we had not had our son legitimized, and there was no way for us to do a fair exchange. He was defiant on the phone call with the officer in terms of returning my son, and unfortunately I can't play the recording to display that, but the reason why I filed this TPO was because I have no protection for myself to keep Mr. Harrison from contacting me or going to the school and trying to causing commotion, trying to pick up my son, and trying to instigate some sort of contact between me and him. Because if I contact him, or if I respond or any manner to these methods that he's using, I'm going back to jail. I would not waste the court's time.
Okay, right now there's a no contact order
against myself. I cannot contact Mr. Harrison, but it's not stopping him from contacting me.
Mr. Harrison, why are you contacting her for any reason, Mr. Harrison?
I can show you can I show you the emails?
No, I want you yes or no. Are you contacting her for any reason?
About our son. I said, please don't do this. My son needs his father. I just
Hold
want
on. Listen. Just a yes or no. Are you contacting her in any way?
Through email. I ain't know nothing about the no contact.
Okay. It's one of her bond conditions.
I didn't know that.
I do understand I can't play the recording, but on the recording he admits to knowing about the no contact order and that he had not legitimized my son, and he has had our daughter legitimized.
Stand by. Sorry. Mr. Harrison.
Yes.
You have to file a case. She does not have to let you see y'all's child. Unless you do that. That's how it is. More of a benefit than that. Something were to happen to you, the child could get survivor benefits. If something were to happen to Ms. Simmons, as long as you've legitimated this child, the child would go to you as opposed to going to someone else and you being in probate court fighting to get custody of a child that belongs to you. There are so many benefits. So people not doing this that's just ridiculous. So you need to do that. Ms. Simmons, does your bond order say that you can have contact about the child?
No, ma'am.
Okay. So Mr. Harrison, you can't contact her anymore. Her bond conditions are going to have to be modified. Do you understand me, Mr. Harris?
Yes, Your Honor.
Even about your child, you can't contact her. She doesn't have to let you see your child, unfortunately, if she doesn't want to. File your legitimation case. That judge can make any decision that he or she wants to about rights, as far as visitation, parenting time, things like that, okay?
Yes, Your Honor.
But don't put her in danger of getting her bond revoked. Because that video right there, that didn't really look like she was scared of you. I'm denying this, but Mr. Harrison, I'm telling you, stop contacting her. Even about the child. You can't do that. Get a lawyer, file something, and then y'all can talk about it in that case, okay?
Yes, Your Honor.
That's just, y'all both put your name, emails in the chat. Once you do, you can go ahead and leave the meeting.
All right, thank you.
Okay. All right, Ms. James.
Good afternoon, class. Today we're going to talk about a couple lessons you should have learned when you were in preschool. Most of you might have. These people didn't. And unfortunately, it bit them in the ass. So, this is what happens when you should have kept your mouth shut, zipped, quiet. Sit back and listen. Take it all in. Shut the F up. But they didn't.
Mr. Whitman, good morning. Good morning. Mr. Witzman, you're here for first appearance because you have a hold out of Bay County. I did look at the hold, sir, and it is a child support matter with a $5,000 purge. Mr. Witzman, what that means is if you post a $5,000 set by the Bay County judge or hearing officer, you'll be released. If you're not able to do that, Mr. Witzman, you'll go to Bay County. When you get there, you'll go to a hearing within 48 hours of getting being booked down there. At that 48-hour hearing, as it's called, the child support hearing officer may or may not lower that purge. So my suggestion is if you can't post a 5,000, I'll be seeing what I could come up with, because you're probably going to get asked that question once you get to Bay County. Mr. Witzman, do you have any questions?
Yes, sir. In 2020, I had a lawyer, Wes Hatcher, and the Price Law Firm. I had a settlement coming to me, and we paid $135,000 to child support enforcement. All the arrears have been paid off. My children have emancipated, and I shouldn't be here. Everything was paid. So there's a clerical error going on.
Well, let's look and see if we can figure out the date of the warrant, because the teletype doesn't have the teletype I got.
Dude, your lawyer's got his finger up to his mouth, telling you to hush like he's hushing a little baby. Shut up. You are making it worse. So frustrating. You just want to shake him for a minute and be like, do you realize what you're doing? Obviously they don't. I mean, who does this on purpose? Stupid people. All these people can't be stupid. They have to be somewhat emotional. I mean, some of them are probably stupid, but a lot of them are just emotional and trying to get their point across. It's not working. Stop acting like a stupid person if you're not a stupid person.
Got from them doesn't have the date of the warrant. It just has a teletype. So let's see if I can pull up the date of the warrant itself. This warrant is this year. Well, it's 23 now. So this warrant is from 22. This warrant is from July of 22. Let me see who signed it. Signed by Judge Young. And what it says is at that time, you were supposedly $52,000 behind.
No, sir.
I have.
Just telling you what.
It's a Calhoun County judge that's issued a warrant. I'm not getting involved in his case. I'm just giving you some information. So you or your family need to be talking to the Department of Revenue for Calhoun County and or the clerk's office in Calhoun County, try to figure it out. But that's what it's showing. Okay.
Yeah, I understand that's what it's showing. I'm just saying I'm here like this because of a clerical error, and no one seems, and they were like, well, that's just the way it is.
If this warrant was dated before you made the payment, I would be more inclined to try to find out more about it. This warrant is dated in July, which leads me to believe as of July, that's what their records show. I don't care if you paid $500,000. If you owed $600,000, you still owe more. I don't know. It's not my case. I'm not getting involved in another judge's case. Mr. McDaniel is your attorney for today's purposes, and that's the way it is. Wish you the best, sir. Okay. So, Mr. McDaniel, I did look at Mr. Whitman's payment history. There was a payment of $75,000 back in 2020, and it appears that these amounts have just continued to come due. I don't see any payments since then. So it looks like he was telling the truth. There was a substantial payment, but it's still accruing based upon what I can see here. So to be no information in this.
So, you know me. Court record. Oops, gotta go look it up. And he's telling the truth. He did make a sizable payment. It wasn't $150,000. It was a little bit less than that. And it was only about half of what he owed. So, he did have a warrant out for him. Bay County. So, We may see him on the Bay County stream. Keep an eye out for that.
Good morning. Mr. Webster, good morning. Mr. Webster, you're here because the circuit court judge has issued a warrant, sir, for violation, for failure to appear for your pretrial. I looked at the file. It looks like you have a private attorney involved in your case now. And it appears that attorney has filed a motion to set aside this warrant. Obviously, it wasn't set for a hearing or it was filed right before the holidays. So there's a pending motion to deal with this issue. You've got a private attorney. There's nothing we can do today. It's not my case, not my warrant. It does appear notice was sent to you and sent to your bondsman. And so I don't know what Judge Garcia is going to do with it, but right now you've got no bond. You'll get to use the phone after first appearance, sir. My suggestion is you contact your attorney, tell him that you're there with no bond. And I would imagine he's going to be in front of Judge Garcia next week sometime if she has time on her schedule, which she usually does. She'll make time for something like this and let her hear your side of the story about the failure to appear. Any questions, Mr. Webster?
There is, Your Honor. Just this. Your Honor, thank you very much. I appreciate everything you're doing there. And I just wanted to ask this. My attorney has been notified. He's been talking to her that we do have a hearing set for Thursday on the 12th. Now that was set back in December. Since then, we've gotten letters from the bonding company saying they did not get notice, just like I did not. And we do have affidavits in the file already saying from the affidavit, just 1 second, Your Honor. My wife and I are separated. And I understand all this is not within your court. And I do understand it's Judge Garcia's case. What I'd like to do is ask just one favor from the court and the prosecuting attorney. Can we speed this up? Is this something we could talk to the judge about and maybe get this moved up, or just let the judge rule on the motion itself? Is there any possible way that the state could consent on that too?
Your Honor, this is my case. I've been in touch with Mr. Fromang, that's the attorney for Mr. Webster. And it is set for a motion to set aside the warrant and reinstate bond on the 12th, I believe. And the state's prepared to go forward on that. And I think I'm in touch with the bond company, and we're going to be able to have an evidentiary hearing on that day.
Okay. So again, as you know, I'm not getting involved in her warrant, her case. I would never do that because I wouldn't want her to do that for me. What I can tell you is I'm looking at now on the computer where the notice was sent to you, according to the affidavit filed by your wife, for whatever reason. She didn't check the mail or maybe separate her wife for a week there, and the notice was there, and that one was sent and received based on her affidavit.
Your Honor, just to clarify that affidavit, I just want to clarify just for the record that the affidavit says clearly, I did check on the mail. I checked through her. She checked the mail on the 5th and she said it was not there. We have text messages back and forth saying, I don't see anything from the court. I don't see anything from the bank. I was looking for a card from the bank. It was not there. It came in after the hearing was over. And the bonding company put in a letter. They're supposed to be sending that to you today and to Judge Garcia for the filing of the motion, particularly for Mr. Gill's benefit. Bonding company is saying they got no notice whatsoever. It never came. Now, you got to remember, this was the first week of December. Volume of the postal service has gone up considerably, things like that. And I do realize this is not your case, and I know you're not going to be doing anything on it.
Okay.
The question I have is really for Mr. Gill. Can we not put a little more consideration in this and get rid of this idea of an evidentiary hearing and just look at what's in the file now? And consent to this? Yes, sir.
Mr. Gill, be aware of this. The notice for December 6th, according to the clerk's record, I'm talking about the notice to the bondsman, was mailed November 21st. Okay. The reason that this is concerning is this. My son is in law school in Montgomery, and I got his tag renewed, and I mailed him the tag in August. He didn't get it, so we had to go buy another tag thing. This past week, he called me and said, you're not going to believe what I got 3 months later. I said, what? He said, that tag. I said, when's it postmarked? He said, August. So even though it's postmarked in August, the United States Postal Service didn't deliver it to him for 3 months. So I have no idea. I'm not getting involved in her case, but there was a very short time span between the notice being sent, about 2 weeks. And if it was a functional, reliable postal system, that's plenty of time. but in the postal system we have, I'm not sure that he got the notice. Mr. Gill is, you may be in front of Judge Garcia as early as Monday. I'm sure your attorney will see when Judge Garcia can consider all the evidence and make a decision, Mr. Webster. Okay.
Mr. Webster, I'm trying to get in touch with the bonding company as well to make sure that we have them there for any inquiry by them too. But I don't want to get into the facts of the evidentiary case that will be set for the 12th. Okay. But I'll try.
Okay.
I'll reach out to Mr. Fromang and see if we can get it set for Monday. I can't make any promises. Okay.
Yes, sir. Let me just tell you, Mr. Gill, there is a letter prepared by the bonding company saying, again, did not get noticed, but they are prepared to reinstate bond at the judge's order with no cost to me. So I just want to let you know that is already in the works with Mr. Fromang. And we were trying to get over to Judge Mercer, Your Honor, just so you'd be able to look at it. We knew that this was not going to be something you're going to be able to rule on. But again, I do know that I can't personally contact Judge Garcia. My attorney should have to get with Mr. Gill to do that too, so not to be, I forget the Latin term right off the, not pro se, but the, by themselves. God, just help me with the word. I contacted the judge without the other party present. I'm sorry.
Ex parte.
Ex parte.
Ex parte. Thank you very much. I could not think of the words as my brain's getting old. He's hesitant to do that ex parte because he's afraid it'll upset the judge. And what I'd really encourage Mr. Gill, he was saying, he was telling me, he was trying to get you over and over and over again, could not get you. It could be the holidays were in the way. And I do understand that. In fact, if you'll notice the 21st, 22nd, the days we did get the mail eventually. It was postmarked the 22nd, but that's the day before Thanksgiving or the 2 days before Thanksgiving. Big Thanksgiving, big holiday with a big mailing day with the Black Friday, Cyber Monday. We also had the Warnock and Herschel Walker election right after that with all the ballots coming in and everything like that. That mail was going crazy. All I'm saying, Mr. Gill, is to please take these in consideration. There was no willful failure. I would have been there in a heartbeat. One other thing to consider, just one more thing, Mr. Gill, and I'm sorry, Judge,
Mr. Webster, we got another case waiting with another attorney. So this needs to be very quick. We're about over with now.
Just 2 seconds here, and that is look at the citation for driving without a suspended license. I took care of that during the same time frame that things were going on with the arraignment hearing. Had I known that the arraignment was there, I'd have been there. I promise you that. Thank you.
Thank you, sir.
Mr. Gill, I'm gonna just say one thing. If it was postmarked on the 22nd, that's 4 days of mailing time. I don't think there's no way it had ever got to his house in that time. Just for you to take that in consideration. Thank you. Good luck.
Thank you. Please, Mr. Gill.
You're taking out the holidays. Is that right, Mr. McDaniel? When you say 4 days of mailing
That's
time?
four mailing
Yeah,
days.
that's probably-
There's no way it's gonna
that's
get to
probably
him in time.
We know you have an excuse. Everybody has an excuse. It's never your fault. Nobody ever does anything wrong. Did you know Penny has never piddled on the floor? Ever. It's always Ziggy. She tells me. She goes and looks at him and points at him whenever I said, "Who did this?" And she looks right at him and puts her little nose up to him because Penny would never do that. It's never her fault. It is not his fault. The mailman screwed up. Give him a break. Right, Pen? Give him a break.
All right. Have a great day and a happy holiday. I'm sorry. Happy holidays. All right.
Happy holiday.
Thank you. Mr. Seals. Mr. Seals, did you speak with the lawyer in that breakout room, Mr. Seals? Unmute yourself, Mr. Seals.
Okay, can you hear me?
If you unmuted yourself and I can hear you.
I just did. Can you hear me now?
Sir, did you speak to someone in the breakout room?
No, I haven't.
So why did you come out?
Why did I come out?
Why did you come out of the breakout room? Because I said, go in the breakout room. Do not come out of the breakout room until you speak to someone. So why are you out of the breakout room if you haven't spoken to anyone?
I don't know how to do this Zoom thing.
Well, all you had to do is be still. I don't know what that means. You didn't have to do anything. The reason why you out of the breakout room because you're pushing buttons and touching things. So if you had stayed in there, sir, now you have to go back to the waiting room. You have lost your place in line because now I don't have time to figure out how to have you figure out how to go back to the breakout room. So
Well, this Zoom is new to
listen,
me.
we've been Zooming for 2 years and this is
Well,
not
I
your
haven't.
Mr. Seals, let me say something to you. You've been before me on more than one occasion. So one thing we know for sure is that you've been on Zoom on more than one occasion. Now, if you don't listen, don't do it. Don't do it. You interrupt me one more time and it's not gonna turn out good for you. And I don't think it's nothing funny on here except the fact that you getting ready to face jail. So if you think that's funny, you can keep laughing.
Well, can I talk?
No, you
Mr.
cannot.
Mr. Seals,
No, you
please be
cannot
quiet.
talk.
Okay, I won't say nothing then.
So you might need to go down to your lawyer's office. That's what you might need to do, but that's your problem. It's not mine. Now keep disrupting my courtroom and it's not gonna turn out good for you. And you got one more time to do that east side roll your eyes at me because I'm queen of the east side roll your eyes. And if I start rolling my eyes, wow, that's what I'm thinking too. Every time you say something, I'm thinking, wow. Wow, I got up this morning for this. Every time you say something, that's exactly what I'm thinking. Good morning, Mr. Reed's assistant.
Two 3G000250M, Ashley Marie Brown. Good morning, Miss Brown.
Good morning.
Can you hear me?
Yes, sir.
Robert, good morning. Erica Bakari on behalf of Ms. Brown. She's been advised for right to charge maximum possible penalty with this misdemeanor complaint. He'd asked the court waive before more reading and enter a plea not guilty with a request for pretrial conference. Ms. Brown is employed at Family Dollar. However, she is requesting court appointed counsel.
Did you say she works or does not work?
She does work. She works at the Family Dollar store.
What Family Dollar store do you work at?
It's in Davison, Michigan on Davison Road, and I actually just got a promotion to store manager, so I really need to get out of here to go back to work. I'm the only one supporting my family.
I'll let her plea of not guilty. I'll find that she can hire her own attorney. How much you make there?
I make $15 an hour.
January 23rd at 9 o'clock in front of Judge Maribel is your pretrial.
Is there any way I can get like a PR bond or something, sir?
There's no way in the world you're getting a PR bond with me in this case. I'm reviewing what little bit of information I have here. And what concerns me, among other things, she's accused of assaulting Joseph Brown, but the police report indicates that she made numerous threats to other people in the family. And I don't know if that's correct or not, but.
No, sir, it's not.
Well, I'm going by what the police tell me here on this information. It's a $5,000, 10% bond. You need $500 to get out. You're to have no contact with Joseph Brown, no contact with Brooklyn Brown.
Okay.
If I find out that you do, that bond's going to go up higher.
Okay. Yes, sir.
Need $500 to get out.
Okay, thank you, sir.
Well, have a nice day. Aaron Allen Meisner.
This is one of those things where I kind of understand what he did and why he did it, and rightfully so. I think anybody who goes in and he asks for something is without first prefacing it by, I know how bad I screwed up. Just, hey, give me a break. No, why should I? You're the one who broke the law, allegedly, and are sitting over there because you need to follow the procedures. So why should I skirt the procedures just so you can have a break? What have you done to deserve a break? Have you done something really good? Because if you did something really good, I'll give you a break. I'll give you an extra cookie at snack time.
Yes, sir.
Ms. Ayala, raise your right hand for me.
Yes, sir.
Solemnly swear firm tell the truth, whole truth, nothing but the truth.
I solemnly swear.
All right. What's your date of birth?
9/23/80.
Ms. Ayala, the charge today is battery on a person 65 or older. There's probable cause for the charge.
No, I'm the victim. I had the bruise, and did you get the pictures? I was attacked, and I'm asking to go to the Dawn Center because I do reside there. He was trying to evict me. I've been living at that residence. He rents out rooms to numerous people, and they ruled in my favor that day that the police came there. This is his second time calling the police on me. And so he struck me, he hit me in the head, he ran up on my back, I didn't even get to finish my statement. As soon as I got to that part where he ran up on me, the police did take my statement away from me. They said I could finish writing it here, but I didn't get to it. So I am the victim, I got hit. I have no violent charges on my record, I'm 42 years old, that I work with handicapped adults. I work in home health care. I've never ever had a violent charge in my life. I have petty stuff, I have drug sales, and I've done my time, Your Honor. But I, for 2 years, have been, 2.5 years, been on the street, bouncing left and right. And I finally found somewhere stable for 2 months. That was this room that I've been renting, spending quite a bit of money on it. But I'm willing to go to the Dawn Center as a victim. I didn't want to pursue charges on him, and I was telling the officer that, and then they pressed charges on me. Because he's 60 years old, he's diabetic, and he has the arm thing. I understood I understand people. He just didn't want me there. I'm the youngest one
Ms.
there.
Ayala,
So
this is the public defender. You could ask for us to be appointed.
I do. I'm.
That I would tell you in anticipation of that.
But I am the victim.
Probably, just listen to me for a minute. That you probably ought to exercise. Dave, stop. Ms. Ayala, you're not doing yourself any good, and you're just running your mouth and not giving me a chance to do anything. Okay, so you're not helping. Okay? You got arrested, all right? Probable cause is a low standard. As you stand before me this afternoon, I presume you're innocent of the charge, but you're standing in jail now, aren't you?
Yes, sir.
Okay, so
I was hoping that it would be thrown out.
it's not how it works, okay? Not how it works. And I think you know that. There's probable cause. That means that it's more likely than not that a crime occurred, more likely than not you committed a crime. It doesn't mean this other gentleman didn't also commit a crime, okay? That's what having a lawyer is for, so they can sort all of that out. I'll appoint the public defender. You seem to suggest that you want that. And state any history.
Yes, Your Honor. She does have history. Currently, she's got case number 22 CF 1756 pending. The charge is hiring with intent to defraud. She was arrested on that charge November 27th. She bonded December 2nd, and she was arrested on this after. So it is the state's position at this time to request that her bond in 22 CF 1756 get revoked. In addition to that, she has an adjudication withhold on a trespass from July of 22. She has adjudication of guilt for a trespass June of 22, a trespass from April of 22, possession of controlled substance and paraphernalia from 21, possession of paraphernalia from 2020, carrying a concealed firearm, introduction of contraband, possession of marijuana and paraphernalia from 21, battery from 20 adjudication, battery from 2019 adjudication, paraphernalia from 2010, driving on a suspended from 28, and her history does go on into the 2003
I don't have any
and 4
batteries.
era as well, Judge.
Okay.
Better? Oh, I'm sorry.
So Ms. Ayala, on this case, I'm going to say,
I don't have a battery.
Ms. Ayala,
I'm sorry. I thought you
stop
had a battery.
talking. I'm ordering you to stop talking. Do you hear me?
So sorry.
Okay, you're interrupting like crazy. There are at least 100 people in this county who have been held in contempt and sentenced to 6 months in jail for half of what you've done today. You've got to stop talking. Stop. I don't want you to say another word. I'm going to tell you what I got to tell you, and you're going to sit down after that, and your attorney will come see you, and you can talk to your attorney, okay? All right, I'm setting the bond on this case at $2,000. Condition is that you have no contact with Mr. Garath. Also, because you currently have a pending felony and you were out on bond on that felony, I'm going to, pursuant to Florida Statute 903.0471, revoke your bond in 22 CF 1756. We're going to hold you without bond on both cases until January 20th. Both of them will be back in front of Judge Merritt at that time. The public defender is going to come see you at the jail before then, so they can pick your path forward. Judge Merritt has the ability to revisit your bond when you go see him next week. Thank you.
Thank you.
If your whole entire purpose is to convey that you have improved and you are better and you're turning your life around, stop acting like a Looney Tune and a psychopath and like, listen, he said shut up and you are still talking. And he said shut up again and you are still talking. And he told you all the people that he has held in contempt of court and you are still talking. Like, if you want to turn your life around, you better stop right now because you're about to end up being one of those people.
Let's call the case. The people state of Michigan versus Justin Phillips. Counsel, state your appearances.
Caitlin Kirby on behalf of the people.
Sorry, Your Honor. Stuart Collis on behalf of Mr. Phillips.
Mr. Phillips, please turn on your camera and state your name.
Justin Phillips, defendant.
Mr. Phillips, you're in court. Please take off your hat.
Oh, okay. Thank you.
All right, a couple of things. First of all, Mr. Phillips, once again, I have gotten right before your hearing, actually after the time that your hearing was set, I've received about 100 pages sent directly to my chambers. My chambers, Ms. Tang, has let you know that is not the way that you file pleadings in the court. And so I do not want it to happen again because I will reject it and I will not read it. I now come before the court, and I'll certainly let Mr. Collis make his own argument, but I come before the court for you now asking for a fourth attorney. And the same, and when I read over the motion from Mr. Collis, it seems we keep going through the same thing. And I'm not going to play the game, just not going to play the game. So, Mr. Collis, I'm not saying at this point I'm going to deny your motion or anything, but what I am going to do is I'm going to adjourn this over. And with this admonition to you, Mr. Phillips, you can't keep coming before this court deciding which attorney you wish to select. So what I'm going to suggest to you is that you find a way to reconcile whatever differences you have with Mr. Collis.
Oh, no, he
and
went
to
off.
deal with that. No, hold it. Do not ever interrupt me, ever. That what you will do is you will attempt to reconcile whatever differences there are. If you can't, then I will deal with Mr. Collis's motion. I am not dealing with your motion. You have counsel of record. It is not going to happen this way. You are not going to make some mockery of these court proceedings. And so I'm done with you in that regard. I will adjourn this matter out to February 2nd, 2022 at 9 a.m. or as a time set by the court. Mr. Collis, use your best efforts to try to resolve this with Mr. Phillips. If you guys don't, then that's fine. So to the extent you don't like Mr. Collis, didn't like Miss Julian, didn't like Mr. Brown before then, those are the devils you know. So you can take those or you can take one you don't know. Because if I let Mr. Collis off the case and I appoint counsel, I'm not hearing another motion to withdraw. I'm done for today. We'll see you on the 2nd. Thank you, folks.
Thank you, Your Honor.
Yeah, he's assaultive. It's not good. So you can't behave like that to me.
Cut him off. Do not do that in my proceeding.
Your Honor, I just say thank you, and I'm headed back to school now, so that'll be all for me.
Oh, no. No, it's not.
So I hope you were able to learn the valuable lesson of keeping your mouth shut. If you did, then I want you to go and I want you to tell a friend. If we all go and we tell a friend, there'll be like 10 less stupid people in the world tomorrow. We can make a difference, you and I, together. Thank you for stopping by. Hopefully I'll see you again soon. If you enjoyed this video, please take a moment and like and subscribe. Help us get the channel off the ground. And also let us know in the comments what you want to see, what you like, what you don't like, so we can make it good for you. Thanks.